Hi, chat. How are you guys doing today? Day 6, Ashley Benefield. This is gonna be it. We've got a little bit of rebuttal. Oh God, this thing makes my hair look like crap. Jeez, gotta do something about that. Because otherwise, it looks too bad from the front. But it's like when I do that, you're like, oh, not good. Anyway, day 6. We've got a little bit of rebuttal. We got some jury instructions. Ugh, we're gonna skip through those. And we got closing. It's going to be fun. It's going to be fun, chat. It's going to be a good day. Hope everybody here is doing well. And William Smith, yes, I agree. She came off as sincere to me. Hope she doesn't have a leaky balloon knot. I agree. I hope she don't. I hope she don't too. Oh my gosh. I'm glad that you guys are thinking about the most important things. You need a haircut. Yes, I know one of those is coming up. So let's get started. We've been through it all now. We went through all of the jury instructions yesterday. There's going to be a little bit of an issue today because I think they were coming back on some topics, and we'll start off from there. Dolly says, I was about to say you were muted. Then realized my tab browser was muted. Yes. And there was a big Richard Allen hearing today. Yes. Sadly, we don't get to hear about any of that until afterwards because Judge Gull's a scumbag. Yes. Also, yes, Jeffrey Williams says he's truly humble under God. Yes, there's a lot of Young Thug happenings, guys. We are going to be picking up and catching up on a lot of things this week, especially after Ashley Benefield's done. We've got Young Thug and Richard Allen. We're going back into those feet first and catching back up. We got a ton to do. So let's get started. Oh, you guys talking about Clyde's beautician? No. All right, guys, here we go. They are in jury. So the jury has been deliberating for about an hour and 20 minutes right now, as of 5 o'clock. So let's get going. We got time. We got to catch up, chat. We are going to catch up here. Here we go. Let's see what we got. Starting soon.
All right, y'all can have a seat. Good morning, everybody. Welcome back. Before we get started, should anybody talk amongst yourselves about the case, discuss it with anyone else, or do research on anything about the case? He says no. All right, when we were finishing up yesterday, the defense had rested its case. The state
God, she dresses like a grandma.
Wishes in present a rebuttal case. State.
Judge, just very briefly state and call Eva Benefield.
I thought it was Ava, like Ava Braun, but okay. Isn't it true she's related to Denisovian, man? Isn't it true you're related to Australopithecus? Australopithecus? Or Sahelanthropus?
Good morning. Good morning. Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
And when was that picture taken?
That was taken in 2018.
Then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this?
Here's the problem. She's answering. I know we're going at 1.5 speed, but she's answering them so fast. That looks rehearsed. Jury's going to notice that.
Picture taken.
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Judge, I just want to publish it briefly. Oh, at this time, I would enter State's Exhibit 105 into evidence.
Same objections? No objection. Received.
There. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
Give me the wrong, Mr. Taylor. Go for it. Can the witness be released from her subpoena?
Yes.
Can the witness be released? Can the witness be released from her subpoena? Maybe release your subpoena, your freedom.
Thank you.
Thank you.
See,
See?
that was the picture they cut up yesterday, chat.
All right.
And that's the problem with it. It looks like you're hiding stuff too. That's always a big problem. But
All right. Members of the jury, at this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down now that everything is done and work on those jury instructions to make sure they're in final form so that I can instruct you on the law. You can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, do anybody want to be heard before?
okay, real quick. So what was the point of all this? Well, the point of all this was to show that Doug Benefield wasn't all jacked, like he wasn't jacked and swole in 2020. By the time he got to 2020, he's an old, fat, flabby guy. But remember, an old, fat, a guy who's 55 years old and is fat and flabby is still going to be stronger than a 25-year-old woman, probably. So that's what they're trying to show, that he wasn't this muscle-bound psychopath. He's a guy who's flabby, who's beating the shit out of dogs and shooting guns into the ceiling. Just not that he's jacked up. So
at 12:30, and then we're going to get you rounded up, you back downstairs at the jury assembly room at 12:30, and then we're going to go instructions by me. All right, so we'll see you back.
all right, so
As I was coming downstairs, Kelly handed me an email from the state with, I haven't had a chance to look at it yet.
Do you have a printed copy?
I do. I have it. Print out a copy for me.
oh, they got an email. It sounds serial. It's serious, we
All
serious.
right, so I assume that this has all of the changes that we discussed yesterday.
Yes. So that's our belief.
All right. So let's go ahead and take a run through these.
By law, he's a
And Ms.
man.
Benefield,
Like, come
please feel free
on.
to share a copy with your attorney.
No.
Look over his shoulder.
Nar.
So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir. Thank you.
All right. First, 3.1, any objection? No. 3.2, statement of the charge, any objection? No. 7.1, introduction to homicide, justifiable, and excusable.
Objection. You have to the second part. Under great bodily harm. Means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I object to that part. I think particularly because of the nature of the facts in this case.
State.
It's a standard jury instruction that we ask that it be read unedited.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event. I think to keep this instruction as it is to the distinct detriment of Ms. Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
All right. I understand your argument. It is part of the standard jury instruction. It's not misleading in its nature in describing great bodily harm. It complies with Florida law and the statutes. I think it needs to be given as part of the standard instruction. So I'll overrule that objection. Other than that one, the rest of it looked all right?
Yes.
7.4, murder in the second degree.
It's the state's position that part in yellow about sudden provocation should come out.
Judge, I'm sorry. I just wanted to also mention in the May update to the jury instructions, they cut out the reference to mere bruises.
Well, online, it still has on the.
You have the Florida Supreme Court order on that?
I'm on the bar website, so.
No. Okay. Do you have there'd be a Florida Supreme Court order? Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update. I may have it, Judge. Give me 1 second.
Yeah, I'm gonna have to see it. The Florida Bar website still does not include mere bruising.
Okay.
Okay, here, Judge.
Don't you show to the state first?
But this is a different instruction, sir. This is not homicide. This is just felony use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use or threatened use of deadly force. Court will note that mere bruises has been redacted.
All right, thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024. That was not the parts that were amended. On 3.6.
All right. Again, I appreciate the argument. It's a standard jury instruction. It's not a misstatement of the law. I'm going to give the standard. All right, 7.4.
It's okay.
The judge the state's position that there's been no evidence of sudden provocation. Heat of passion, unadequate provocation. There was no evidence that a reasonable person would have lost normal control, would have been drunk. There was no evidence of a blind and a reasoning fury, so the state would ask that section be removed.
Do you want the sudden provocation? Towards the bottom of 7.4, going to the second page.
It's the other one.
I'm fine with it like it is.
So you want it in?
Yes.
And state you want it out?
Yes, and I don't think there's been any evidence that entered to go to those facts. That portion.
All right, I'll leave it in. 3.3G, possession firearm.
Fine.
State. 3.4, lesser included.
Fine.
7.7, manslaughter.
Fine.
3.3A, aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6, justifiable use of force.
Yeah. Sure. Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6F.
Okay, that's right.
I wonder if the court would consider under the second part, giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, the justified use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
All right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender to the court.
Now, I will say I do agree. I don't think manslaughter has been set. I don't think there was heat in the moment. I don't think there was provocation. I do agree that that isn't there. And I'm surprised the state's willing to say, we don't want that. We just want straight murder. I really don't feel that. I'm surprised they're not trying to ask for that. I think they're a little scared. But you think they would be. So, it's a little interesting that happened. Sorry, guys. I was on Clyde controlling duty. So here we go.
Well, this is the final charge conference, so I'm going to need it.
Give me a moment, Bill.
Yes, sir.
Okay, here's one that we had, Judge, in preparation. I'm trying to keep up with all the paperwork. Let's do it. Move it out. Your Honor, I'd also like to request if we could adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Yeah.
I think it might come from case law.
Is that it come from Webster Dictionary? The state objects, number one, that the definition does not make sense to the state. Number two, I'm on Webster's dictionary where it says it comes from, and that is not the definition provided by Webster's dictionary. It's partially, I mean, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was the second request, which is in the second paragraph. Great bodily harm means distinguished from slight, trivial, minor, or moderate harm. That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Under 3.6F, the second paragraph, where it defines deadly force, means force likely to cause death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's not a definition of great bodily harm. Actually, my copy has an explanation.
That's
Right, it's
the standard.
it's from the standard.
Okay.
And then was you asked for imminent, you made your arguments against it, rebuttal.
No rebuttal other than I don't see what the downside is to it. I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in, so let me mark it to preserve. So this is defendant's proposed definition of imminent. See the 30th. All right, that'll be filed.
And Judge, I think we got ahead of ourselves in this instruction. So if we could go back under the paragraph on 3.6F, the first page, it says the law justifiable deadly force, use of deadly force is as follows. It's the state's opinion that that first section in yellow would come out because where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and it's almost identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed late yesterday. So
Yes.
you're in agreement?
Okay.
Yep.
All right. So
I'm sorry,
that,
I didn't realize we made a decision on that.
well, I don't think we made a decision. I just rambled on and on explaining the difference between the two and the distinctions and why 776.0122 and 776.0312 differ than 776.0131, but cover the same ground. Just one is general self-defense and stand your ground, and the other one is in your home. And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law unjusted to if she's in a dwelling, that portion.
Right. All right, here's where we're going to need to take a few moments to talk about the forcible felonies. And Mr. Taylor, I had written them down yesterday. Hopefully you saw, oh, there it is. All right, state, yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776.013 subsection 1, I assume that you're going to want A and B?
Yes.
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Correct.
Are there any others?
No, sir.
No felony battery. I thought felony. Did you say felony battery?
Mhm.
Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge. Sorry.
Burglary, ag felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours. But I'm not sure yet on that one. So I just think there's problems with each one of them, and I'd rather we could just go through them.
Okay, burglary.
I think it's the classic remaining inside. The testimony, if the court recalls, from Miss Benefield was that when he spun around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present, and as a result, at that point, he was a remaining inside burglar.
All right, well, that's not just the end of it. So I've got the standard instruction for burglary, which would need to be obviously modified because I don't instruct them on the burden of proof. It's just the elements for any of these forcible felonies. The initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary under 2, there's 2 A, B, or C. So I need to know which one of those you're arguing. And based upon what you just argued, I'm assuming that you want 2B, as in Bravo, after that would be essentially 2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn and with the intent to commit, there has to be some crime alleged, right? Because it can't be burglary or trespass, or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Give me a moment. I think we would prefer other than, Your Honor.
All right, State, now it's, and are you asking for any other portion of the burglary statute if it's to be given?
Give me just a minute, Your Honor. Can I see the instruction the court is referencing?
It's 13.1. 13.1 burglary.
Yeah, we're having computer problems, Your Honor.
I think the internet just came back. It goes down a bit.
Oh, here we go. All right, what was the court's question?
On the burglary instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
And I'm sorry, guys, I had to step away for a minute.
So are we talking about, I just want to make sure we're talking about the same thing.
No, so-
Maybe it's legal.
The court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep, and then I have to give A, B, or C
Okay.
as appropriate. And I'm sorry, that's A, B, or C. It can be in the conjunctive or the disjunctive.
All right, we would request B and C, Your Honor.
Okay, guys, in the neighborhood, you're asking a good question. Why are they asking for these crimes to be included? They're including these because that way they could say Ashley they're letting the jury determine, hey, Ashley was defending herself from a burglary. You're allowed to use deadly. So in America, well, I should also include for £5 sterling, the king sterling. Burglary and aggravated burglary in America is considered in every state is an inherently violent and dangerous felony. The odds of severe harm and or possibly death are very high in a burglary. Happens quite a bit. Aggravated assaults, false imprisonments. Those are all crimes you are allowed to use force to free yourself from. If somebody's imprisoning you, you are allowed to use whatever force necessary to get away from that person. You know, if somebody's falsely imprisoning you, I mean, you could use a gun to get out of that. And you should. You have it. And they won't let you out, then you might have to fucking kill them. If somebody's battering you and they won't stop, you might have to use a gun to stop them. If a burglar is in your home and starts attacking you, guess what? You're going to have to put him down. Those are all, that way she has justification to do this. Just because someone's in your home doesn't, and this is something even people in America understand, the fact the person's in your home doesn't automatically, an intruder is not automatically a deadly force threat automatically. There might be places where you can get away with that, but generally you should be able to articulate something like, he had a weapon, he advanced on me, something like that. You walk down the hall, you come out your bedroom, and 20 feet down the hallway is some guy carrying your TV out the front door. That's not, you know, you can drop them. I wouldn't recommend that. But they're showing she had crimes that she was defending herself from. So I hope that makes sense. Does that answer that? Yes, because you are one of the king's subjects. Yes. You don't get to do all this. SB Sellers is burglary is against an occupied dwelling. That's not true. Burglary is when you're breaking into a, under the cover of darkness is the common law version of an occupied dwelling or structure. Breaking and entering is like breaking into an occupied building. Aggravated burglary, and I don't know Florida's, but Ohio, I can commit burglary or I can commit aggravated burglary. If I can commit aggravated burglary, I did a violent act or I carried a gun. That makes it aggravated. So, in Doug's case, you know, committing a crime of violence makes it aggravated burglary. And very quickly, even though you're invited into a home, if you're even an invitee, you could quickly become an intruder, which then becomes a burglar almost immediately. You know, you entered under false pretenses, or you're told to leave and you're refusing to leave. And now, like, things, your legal status could change on a dime in any situation. It could very quickly go from legal to illegal to this to that to boom to boom to boom to boom to boom to boom to boom. It happens very quickly and it can be very fluid. So, Seller says, isn't a robbery when occupied? No, robbery is me forcibly taking something from you with a threat of force. So if I give me your wallet or I'll fucking kill you, that's robbery. Give me your wallet. That's robbery. If I come up and pick your pocket, it's just theft. So robbery's on your person. Burglary's in a home. So yes, you can also become an aggravated burglar because the goddamn window won't open. Turnip says, what differentiates trespass from burglary? Well, trespass, I mean, in Ohio, we actually have this called, like, it's like burglary light. It's called trespass and habitation. With burglary, you're also expected to be, you're breaking into an occupied structure with the intent of committing another crime. If I'm just trespassing, well, I'm not trying to commit another crime, although very likely you probably are going to be considered to. Typically, you don't get charged with trespassing if you're breaking into an occupied home. Trespassing is you're wandering around someone's property. Skies and Input says, if burglary is inherently violent, how can it add an aggravation? Like I said, the aggravation is you commit harm while you're doing it. Like that you actually commit harm. So if I break into a home, if I break into your home, there's a presumption I'm committing burglary. If I break into your home and in the middle of it, I find you and I don't want you to talk, so I start punching the fuck out of you, well, that's aggravated burglary now. I committed physical harm in the commission of that burglary. So now it's aggravated. It's an enhancement. It raises it up one level of felony. If I break into your home and the police catch me and I have a gun on me, then that's aggravated burglary. If I say, I've got a gun, if you call the police, I'll kill you, that's aggravated burglary. There's a lot of ways you can there's a lot of ways you can escalate a burglary into an aggravated burglary or an armed burglary or whatever state may consider it. Yes, and it's the idea there's a strong potential for violence, but yes, it's an inherently dangerous felony. It's inherently violent. There's an inherent sense that violence will be committed in the burglary because a lot of people, there's burglaries and burglars don't want to get caught. So they attack the homeowners. They might attack that homeowner, knock him out. If it's a woman, they might rape that woman. They might murder that person. I mean, burglaries gone wrong happen all the time. But trespass is typically while you're wandering around the property. You're not generally trespassing in a home. You're unlawfully entering into a home, and that's a felony. Trespass is generally considered like a misdemeanor level offense. So here we go. Let's keep going.
All right, and on C that you're requesting, is it just to commit or attempt to commit a forcible felony?
Yes.
Which potentially would be. Now, any other portion of that instruction before I go to the state? Or you state, whenever I get over to you, if I do decide to give it, if there's any additional portions, be prepared to argue those.
No, that's it, Your Honor.
All right. Okay, that's it. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yeah.
So it's on the second page.
Yes, sir.
And if I give it, it'll essentially be something along the lines of the elements of the forcible felony of burglary are 1, 2, B, and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, would be an or. C, commit or attempt to commit a forcible felony. So obviously you object to that. But if I am going to allow it, is there any other part of this instruction that you would want to be given?
2 paragraphs. Oh, let's see. It says the next paragraph is about intent, the operation of the mind. The following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it. If the evidence does not establish that it was done with the intent to commit a crime, other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because we don't have proof, but I think that is an important.
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next 2 paragraphs to be given, which explain intent. And when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
All right, so here's what I propose it would sound like, and everybody can object, because you don't want it, you want it, but you might not like the language, but I've given it before and it works. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Here's where the changes are, because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it's an accurate, I'll let hear your arguments, but I found that it's an accurate statement of the law, because the other way is the defendant must be found not guilty. That's not what we're talking about here. So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us, Your Honor.
All right. Do you need that, State?
I will need that. And I can say, based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
We'll need to-
So I'm sorry, and we also need structure, because structure is not defined in any of the other instructions. And that's on the very next page. All right, Mr. Taylor, what I've done is I took the standard instruction and have amended it in my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right,
Does
thank you.
that include the elements portion too?
Yes.
Okay, sorry, I was trying to do it
Yeah.
as you were talking, but I wasn't keeping up.
My penmanship is horrible. I apologize.
This is perfect, Judge. Thank you.
So that's what I've approved for burglary. Let's talk about false imprisonment next. And that's instruction 9.2.
Judge, I had one thing before we leave. On the last portion of 3.6F, justifiable use of deadly force, I wanted to ask the court to substitute 2 words in the final section.
I don't think we've gotten there yet.
We've not gotten there yet.
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah. So the next forcible felony that the defense has requested is false imprisonment. So 9.2, if I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are. So which one of those elements or methods by which one is falsely imprisoned do you think the evidence supports, Mr. Taylor?
We would like to have confined and restrained.
Just those 2? Okay. And also on number 1, it's you would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
Forcibly.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about the forcibly and by threat, Judge?
So it would be or. And that means we would not need secretly. All right, state.
The state would object. There was no evidence at the time in which Ms. Benefield used deadly force that Mr. Benefield was preventing her from leaving. If there was a time in which there could be argued a false imprisonment, it would have been when she tried to get out the door and claims that he spun her around by her arm. But there was no evidence that when she was in the bedroom, there was any effort to forcibly or by threat confine or restrain her without her lawful consent. So the state would object.
Rebuttal.
Well, actually, I believe the testimony was that when she turned around, he was standing in the middle of the doorway, blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However, the facts as presented by the defendant do support the giving of this instruction. False imprisonment, here's how it'll read. The elements for the forcible felony of false imprisonment are Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so. That would be the end of that instruction. As I review the rest of it, the rest has to do with certain enhancements.
Are you giving me that one? Are you going to give me that one?
I would ask.
If not, I'm going to need you to repeat it.
Yeah, no, my plan is to, after I do this, give them to you because then it's all,
Yes, sir. Thank you.
I'm sorry to put that on you because I know you're objecting to it, but
It's on her.
all right. Anything else on false imprisonment? So I am going to give it as I just read.
Yes, we would request a specific definition of the term false imprisonment based on the case law, Provo versus State, if I may.
The definition of false imprisonment?
Yes.
The elements of it.
Isn't that the elements of false imprisonment is the definition of it?
This just lays it out, Your Honor.
Okay. Go ahead and take a look at it real quick. State. Thank you. All right, did you want to be heard on this?
We object.
Right.
I think elements are sufficient.
Any further arguments?
No, sir.
All right. I see
Yeah,
one pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute. But I don't think I would give a definition of false imprisonment.
Yes, Angela, the jury's out of the room. Remember, he said the jury's coming back at 12:30. So yeah, the jury's not allowed to be here while they talk about this part.
In the false.
And normally they're not even like here in the courtroom. Like they got sent home or they're out fucking off. You don't normally do this even with them in the room next door. Yeah, you don't want them around. You don't want them nearby.
Imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
right, so let me do this. Same thing, it's just my marked up version that I'm gonna give them so they can, that way the typeface will all be the same. Thank you. For instruction in false. Put this. Fine. How about aggravated battery next? I'm trying to take them in some semblance of descending order. Might not be perfect, but all right. Ag bat. So I guess what I'm looking for, defense, from you is what parts or portions of aggravated battery 8.4 you're asking for. We would start with Doug Benefield, A or B under number 1.
Judge, I think, frankly, after reviewing this instruction, we're going to withdraw the request.
Okay. So ag bat is withdrawn. Next one is felony battery. 8.5.
Yeah, we're going to withdraw that as well, Your Honor.
All right, felony battery is withdrawn as a forcible felony. And the final one that you had requested was 8.2, aggravated assault.
That's either be.
Well, there's a brief break. Everybody check your phones. Make sure they're on silent or turned off.
This one, I think, is viable.
You want to keep?
Yes, sir.
All right. And so let's look. There are some options. So let me go through them. So 1 is standard, 2 is standard, 3 is standard. But then under 4, are you asking for A or B?
B.
And what is the felony charged? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others. False imprisonment, Your Honor.
Sir?
False imprisonment.
Okay. State.
It's the same argument. Well, it's a two-part argument. It's the same argument as to false imprisonment. I know you're already getting it. They're getting it, but I don't think that there's evidence that he made threats by order act, I guess, other than your done, which the state would argue is ambiguous. At the time, the defendant Mr. Benefield appeared to have carried out the threat. I don't know what that means for this case. And the defendant created a well-founded fear of violence was about to take place. I mean, I think this is so akin to the self-defense argument that I think it's duplicative. But also to then say that assault was made with a fully formed conscious intent to commit false imprisonment against her. Their argument was just that he was already false imprisoning her when he, I just don't know how you would put this in there, because he was already committing a false imprisonment, and then when he made the threat, he was then fully informed to commit another false imprisonment. I just think it's circular, and I'm not sure that it will make sense for the jury. I think it'll be confusing.
Like most of these things, it becomes a question of fact for the jury. And I'm not prepared to say precisely when, given those facts and the fluidness of the circumstances, when or for that matter, if the jury will conclude that there was a false imprisonment.
All right, thank you both very much. I'll give it. The question is, any other portions of that, or it's just the elements of that one? Certainly, there's no deadly weapon.
I think the first one, if the circumstances were such, that should be in. Deadly weapon is out, as would be an object not designed to inflict bodily harm. Great bodily harm is out, as would be, Judge, not necessary that the defendant had an intent to kill.
Okay, you give this one to the state. So that'll be the last one. So we ended up with 2, right? 3.
And I guess you're going to need some guidance on how to word this. Imminent commission of forcible or burglary, comma, false imprisonment. Like that sentence isn't going to make sense.
I'll give that to you.
Thank you.
All All right, so I think it would need to say imminent death or great bodily harm to herself, or the imminent commission of burglary, false imprisonment, or aggravated assault against herself. Could be in the disjunctive. And then immediately after that, I'll need, yes, thank you. All right, the next portion of what we need to discuss on the self-defense, we're still on 3.6F. We're through the use of force in the home. The very next paragraph talks about 782.02. This is the bottom of the second page of the state's, I think it's on the bottom of the second page. I think we talked about yesterday removing that, but let me make sure. The portion about 782.02.
I think I already took it out.
I thought we did, but I have a question mark next to the one on my copy.
Oh,
So I'm just making sure.
I have the next, the next paragraph I have after the ones we were just discussing is in deciding whether Ashley Benefield was justified is the next paragraph I have on the one we did last night. Is that what you changed?
I'll look at the one.
I thought you would ask yesterday if we wanted A and D. You said yes.
That's how we're talking about.
On which one? I'm talking about the portion that was 782.02. And like the state said, I have it, we weren't going to give it, but then I have a question mark by it, so that makes me wonder if it was, we're not going to give it, but we're going to think about it.
Yeah, I marked it out. I have it.
Again, I think that's what it is, but this could be just me having a question mark there for, I don't know why. But I just want to get confirmation on the record that we're not giving it.
Yeah, we'd like to have it, Judge. We would request B and C.
All right, any further argument?
No, Your Honor.
No.
In response to the court's question, did I have any further argument?
Okay. So before I go to the state, because this is my question, if we're giving 776013 that talks about the approved or justified use of deadly force when one is in their own home or in their own residence or dwelling house, and including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing, what are we gaining by adding 782.02? It seems duplicative to me.
It would be the first time that there's an instruction that overlaps.
All right, state, you want to be heard?
Yes, Judge. It's not an instruction that overlaps. It's repeating parts that are already in the instructions. The first paragraph is in 7.1, justifiable homicide, that almost the exact paragraph. And I believe the states are contingent. These are cases that are not when there's been a homicide, so you wouldn't have read 7.1. That's why it would be in self-defense when you use deadly force, but it's not necessarily homicide. And I think that to say B and C, that is exactly what you've already just read. And I do think it's duplicative, and I think it's really confusing if you don't.
All right, final thoughts.
Nothing wrong.
I think I've shown that I tend to give instructions when they're lawful, they're an accurate statement of the law. The facts of the case support the giving of the instruction, and it's necessary to explain or clarify an area of the law to the jury so that they can do their job. However, when you look at what's being proposed under 782.02, that portion of the instruction, it is, while a different order, it's virtually identical. Subsection C talks about the commission of a felony upon Ashley Benefield in a dwelling house in which she was present, and that is taken care of in the instruction we're giving from 776-0131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she is justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given. And so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So quite frankly, we're already giving that. That wouldn't just be duplicative, it would be the exact same instruction being given twice. The 776.013 subsection 1 covers all of the issues and elements that have been presented. All right, the next one is then in deciding whether Ashley Benefield was justified. Certainly that's in.
Yes, sir.
And then we discussed yesterday, all of that middle part is out. And then the last portion,
Yeah, Judge.
yes.
They've added, if I'm not mistaken, they've added totality of circumstances to that paragraph
Which paragraph?
in deciding whether Ashley Benefield is justified in the use of deadly force. You must consider the totality of the circumstances.
It said you must consider the circumstances of the time
And
of force.
they've struck by which he or she was surrounded. So totality of circumstances at the time.
Sorry, do you have that where it was?
Yeah.
If you just show that to the state first.
Those are proposed, that is not what happened. The online is what happened. Those are proposals. We didn't strike it. If you look at 3.6 as the Florida Bar has it, it's the same. That's a proposal. It's a code.
So we would like to propose language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission. It was when they proposed instructions before they
This was from the committee.
So the committee proposed putting in totality of the circumstances, but it wasn't adopted.
Correct.
Okay, I got you.
We would object.
As the court knows, the court's not married to the patterns any longer.
All right. Thank you very much for the argument. I think the standard jury instruction that we're dealing with adequately explains the law. It's not a misstatement. It's not going to mislead the jury in any way. So I'm not going to add totality of the circumstances. The jury is told you must consider the circumstances at the time the force was used. So I think it's sufficient. So that remains. And then if you look, then all that middle part is out. And then it goes to, if you find that Ashley Benefield, who because of prior threats or difficulties, had reasonable grounds to believe. Do you see that part?
I already took it out on the version I did last night, though, so it might be. I think he's working off the state's newer version. I took out everything you already said.
Right. All that middle part is out. So it's going to go from you must, look at the circumstances that she was faced with, and then it has the part about you may consider and you should consider those prior threats and acts of violence that she knew about or was aware of.
So now I had on the penultimate paragraph.
Yes, sir.
Rather than committed an act of violence, we would request that it read had committed acts of violence. You may consider rather than that, this. Based on the evidence, there's obviously more than one act.
All right.
Where exactly? Okay, right.
As you said, the penultimate paragraph, the next to last paragraph, and it says Doug Benefield had committed an act of violence. They want it to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right. Well, so do you want it to say an act or acts or just committed acts?
Acts, ACTS, acts of violence, and you may consider this rather than that.
It's that fact of determining.
You want it to say this fact instead of that fact?
Correct.
Okay. I don't know.
Plural as opposed to singular.
Sure.
That's fine, Judge.
All right. Anything else on 3.6F?
No.
State?
No.
Okay.
Thank you.
3.7, any objection? Okay. That's horrible. Sir, you're not writing down each sniffle line, are you?
No, it's not.
Okay, thank you.
It's a lot.
So if they left that out. is missing on this one. Proof beyond a reasonable doubt does not mean proof beyond all doubt.
Where's that at?
It would come right before a reasonable doubt is not a mere possible doubt. I'm looking at the 3.7.
Which paragraph are you on? I'm sorry. Oh, okay, I found it. Oh, that's an update since 2024. There's an update.
Is that the only update?
Yes, that's the only request that I have as to that instruction.
Well, looking at that one, they've also added,
I'm still,
is this one of the ones that just came out in May or July?
obviously, our system is not updated.
So if you look at the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too? It also has an addition. See right in the, about a third of the way down? The defendant is not required to present evidence or prove anything, which is what we've always had,
Right.
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that applies.
Do you want to make an argument for or against defense?
Jen, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
I just didn't want to be rude.
No, I don't know what you're talking about.
Yeah, so.
I
you know,
think
it's
these
interesting,
guys,
right,
I think
because
these instructions are kind of like pretty middle of the road.
self-defense is an affirmative defense, but yet in the instruction, they don't acknowledge that. They just limit the instruction, whereas a suggestion, insanity, reunification of an attempt, or rather renunciation of an attempt. No, I think that's confusing. I wouldn't request that.
This is interesting. I'm not even aware of any case law interpreting
Yeah.
this edition yet.
It's a,
Because it's interesting, and State, I'm just going to throw this out there. So certainly it's an accurate statement of the law. I think we can all agree on that, right? State has to prove beyond, well, first it's a prima facie case, but proof beyond a reasonable doubt. Then there's the preponderance of the evidence that an affirmative defense, and the defendant has the burden of production and persuasion on it. But then the burden shifts back for the state to prove beyond a reasonable doubt the defendant did not act in. So it's interesting because this addition says they're not required, defendant not required to present evidence or prove anything except for the defense of, but then doesn't talk about that burden shifting. I don't know. I wasn't on the committee. I'm on a different committee, so I don't know how they. I understand explaining. Well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more likely than not, greater weight of the evidence, whatever words they wanted to use. But then the burden shifts back to the state to prove beyond a reasonable doubt the defendant's not entitled. So, do you want to be heard?
Yes, I think that we're asking for it. I think insanity and renunciation of attempt are examples. It says e.g. So I think it's well established that self-defense is an affirmative defense, and I don't know what legally would prevent it from being included in this instruction. And I think it is, as Your Honor has already said, an accurate statement of law. So we are asking for that paragraph to be included.
not that this isn't difficult enough, but if the court does decide to add that, I think the court, in fairness, would be required to elaborate on the burden shifting back to the state, as the court just acknowledged.
All right. Thank you both very much. Here's, and certainly, whenever after I read the instructions and I charge the jury, I'll obviously ask if you have any objections to how the jury was charged. If it's just all the same previous objections, just renew your objections. Here's the reason I hesitate to give this right now. It's brand new, and I could be wrong, but I do have some concerns about how truncated it is with the actual nuances of the burden shifting that goes along with affirmative defenses and not explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law on how this instruction is going to work now. So I'm going to leave it at the defendant is not required to present evidence or prove anything. You added in that additional sentence, proof beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, but you're going to put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the,
I printed out a new one for
Perfect.
yes.
Any other changes?
No, sir.
State? 3.7 good,
No, nothing else.
except for the objections about,
Yes.
that'll be interesting to see how that plays out. All right, 3.9.
No objection.
All right, perfect. Again, that's where I'm going to stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
3.11?
No.
3.12?
No.
3.13?
No.
During that same paragraph, I talked. I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech cart that's right out here in the hallway. And when they go back to deliberate, they can play the 911 call? Is that the only thing that's in?
Well, there is a DVD of text messages if they want to do it.
All right. They have a computer back there that has no access to the internet. It's just a laptop that is on the tech cart that they can use to view items or listen to items. So I do go off script there to tell them that. Also, up a couple of paragraphs from there, when I talk about the cell phones have to be, and the electronic devices have to be left out. I also talk about smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the deputy. All right, and then the verdict form.
No objection.
On the manslaughter, I thought the manslaughter was just,
We were just talking about that.
yeah, I think the manslaughter might need to be,
Sometimes we.
it's just one question.
Well, yeah. You mean breaking the questions up? I think the state, this is the jury instruction we've been using because I think that it is confusing I think it puts too much emphasis on the separate charges if you break them up. And I think if they check manslaughter and then 1, 2, and 3, there's no harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between obviously the second degree murder and the manslaughter for the sentencing enhancements and the 1020 life.
Yeah, I don't have a problem.
You're okay with this one? All right, here we go. Not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so I'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here and we can get started.
Is there going to be a long J-way argument? And if so, when do we want to do
Oh, did you want to make one now, or do you want to wait until after we let the jury go?
After you let me go.
All right, so the reserve on that. All right, y'all. We'll see you back in a little bit.
Well, that's interesting. In Ohio, you got to bring that up before you get to dismissal. I mean, before you get to the jury instructions. I think you'd actually risk getting that waived. Wow. That's very interesting. You can do that. I mean, here I would never do that. Here I would never. I would argue you might have actually already waived it. Hold on here. Yeah, just very, very weird. But anyways, so we got 2 hours, chat. I mean, he's gonna deny it, but let's get through it.
Thank you.
So let's get to it, chat. It's time to time travel. Just a couple more minutes. Here we go. Gosh, she got a shiny nose. Oh, Judge ain't there. Let's go ahead and see where Judge Wings
Forcible
is.
felonies.
Be a change or an error from earlier?
On 3.6, where it's the false imprisonment, I think your instructions said forcibly or, and you crossed out by threat, and then you circled it, and I think we thought it was supposed to be left out, and so it's typo. It says Judge Benefield forcibly or confined or restrained, because you written or, I didn't catch it. So it's on the second page of 3.6F, and it's the first element of false imprisonment. And I don't know if we were supposed to say threat or not.
Okay, let me hand out, thank you for doing those and sending them. The reason I'm late coming back, I apologize. The copier upstairs is moving just as slow as the internet today, so it just took forever to make these copies. There's one for each, the state and the defense, and I want you to check. I saw that, and I think I fixed it.
We printed, I'm thinking if you found it, we could at least just print that page, so.
Look and see. There was also a few punctuation issues that I changed, so a couple of commas.
She was typing away, that's good.
No, listen, I really appreciate you guys putting that together for the standards. But look at 3.6F, I did catch that.
Yes, sir, I see your face. Thank you.
Madam Court Reporter,
Yes.
here's a copy for you.
Okay, so we have one other issue, Judge. In 3.6F, when the court lays out the forcible felonies, we kind of feel like they lose their individual identity because they're not separated at all. And we were wondering if we could label them. For example, the elements of the forcible felony of false imprisonment are 2 dots, and then do the same thing with the elements forcible felony of aggravated assault are 3 dots. If you look at the instruction, the way it's printed, knowing that they're going to take it back into the jury room with them, it doesn't seem to have an individual identity. It just kind of is all lumped in there. So what I am proposing, may I approach?
Right.
I've shown this to Rebecca. Perhaps if we could just number them to give the jurors some sense that they're individual crimes. The only other thing we had, Your Honor, is the last paragraph on that page in deciding whether or not Ashley Benefield was justified. That refers to subparagraph A, and we were thinking it should come after subparagraph A, and then the rest applies to subparagraph B.
All right, State.
I don't care about the numbering. I think that they're fine. I think Mr. Taylor's welcome to explain it in closing. I think it's clear they're each labeled what they are, and you have them in a sentence. We have them in a sentence. As to that paragraph, I don't think that paragraph actually goes to A or B. It's for the self-defense instruction altogether. It's not as to that one section A or B, the last paragraph on page 2 of 3.6F. So I just asked that it remain where it's at.
All right, final thoughts. All right, I think that how we have it is, how I prepared it is correct. The elements of the forcible felonies are laid out as discussed previously. They're not misleading. It's one solid instruction referring to the various forcible felonies. I'm going to read it to them, and I think when they hear it from me, read to them, it's going to be eminently clear that these are separate forcible felonies, so I think they're ready to go. Any other objections?
No, sir.
All right, you ready to bring the jury out?
Yes.
You ready?
Yes.
Before we do that. All right, I want to speak directly to the observers that are in the audience. We are now about to begin closing arguments. This is when the attorneys are allowed to tell the jurors what they believe the evidence was, discuss how the law applies to this case, and explain to the jurors why they should vote one way or another. You will likely agree with one side and not the other. However, you are instructed not to behave in a manner that is distracting or in any way attempts to influence the jury using threats, intimidation, or sympathy. If the court determines that your behavior is distracting, you will be removed from the courtroom and prohibited from returning until closing arguments have been completed. This includes coming in and out of the courtroom during closing arguments if the court determines it is distracting.
Hey, don't be a
to the jury.
fucking idiot.
All right, I've got 9 copies without verdict forms. Just check. The ones I gave you should have the verdict forms, right?
Yes, sir. Yes.
Yours does? Okay, perfect.
And Judge, I will need the screen. I don't really want to put it down.
All right, y'all can have a seat. All right, everybody have a seat. All right, before we get going, just to make sure one final time, did anybody discuss the case amongst yourselves? Did anybody do any research on people, places, things, or legal topics we've heard anything about? Did anybody talk about the case with anybody outside of this jury? Members of the jury, both the state and the defendant have now rested their cases. I will now give you the initial jury instructions, after which the parties will give their closing arguments, if they wish, and then I will give you the final jury instructions before you retire to deliberate. The courtroom deputy will now hand out a copy of the jury instructions for each of you to review as I read them. The jury instructions are like your notes. You may write on them. After the trial, the deputy will collect your notes and jury instructions and return them to me to be destroyed. No one will ever read your notes. I will also add that I am confident that you can all read a lot faster than I can speak these jury instructions. Sometimes I've said to Ms. Sarah that I'll take that as a challenge, but we want a good, clean record. So I am going to ask also that you stay with me as I read the jury instructions. There's also a point, like I said, where I'm going to stop, turn it over to the attorneys to do their closing argument. So it's just be better if we all stay together.
All right, chat, we're going to skip this
Members of the
part.
jury, I thank you for your attention during this trial. Please pay attention to the instructions.
We're skipping. We're skipping.
Does the witness's testimony
We're
state
skipping.
is
Here we go.
entitled to divide his time between an opening argument?
Are you going to give a warning?
Still sounds like a Bond villain's house.
Yeah, you want the lights down?
Yes, if you could just see the ones back there.
Gotta turn them lights down low. Listen to it on the radio.
Domestic violence is absolutely a real problem. There are many, many women around that are in horrendous situations.
Congrats on getting through day one.
Women and sometimes men that are in situations where they're being abused and beaten horribly on a regular basis. People that feel like they cannot get out, they have no way to get out. That is not this defendant, and it never was. Now, some of those women who are victims of horrible domestic violence may be justified in a situation where they have to use self-defense to kill their abuser. Absolutely, there can be situations where that might be a valid point, but not for this defendant. This defendant used domestic violence and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs. And to understand that, I think we need to go through the background, even though this case really is about what happened in that house. What happened in that house, the last moments of Doug Benefield's life. But we need to go through the timeline to see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary? That self-defense instruction called justifiable use of deadly force is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name calling. Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided, in less than a year of marriage, they wanted to have a child. This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it. If you look at the emails, the text messages between him and Ashley, he says, "I'll spend the rest of my life making this up." And he says how wrong he was and how stressed out he was. And he apologizes. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy. And then within about 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last moment that this defendant ever lived in the same house with Doug Benefield. Was August of 2017. Very, very important date. Within a couple of months after getting to Florida, the defendant starts this campaign of complaints against Doug Benefield, all with the idea to get sole custody of her child that she was pregnant with. So she filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against, but finds it appropriate to get an injunction in South Carolina. It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. That is not what we are used to probably in Florida for injunctions. Then December 2017, so that's within a month, Ashley starts the series of allegations in Florida. So she files for this injunction in South Carolina. They mutually agree, okay, we're not going to talk to each other. We're not going to be around each other. But she starts a series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child, and also goes back to things that he supposedly did in South Carolina when they don't even live together. So on March of 2018, she gives birth. She gives birth after Doug Benefield has a lawyer contact her, because they're not really supposed to be talking to each other. The lawyer helps him write a letter where he says, I want to be a part of this child's birth. Please, I'll honor your wishes, but please let me be a part of this child's birth. Not only does she not respond, when she goes early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, he didn't know the child was born. Then she does not put his name on the birth certificate. Now, alleged behavior or not, she knows who the father is. Why is she not putting the father on the birth certificate? And then she gives this child her maiden name instead of her father's maiden name, or I'm sorry, her father's last name. Then 1 month later, she starts complaints to law enforcement. She says he violated the injunction in South Carolina. She files for a new injunction in Florida based on all of the same things in South Carolina. This is all based on the same information that she had already spoken about in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. And you heard from Detective Gillum about the conversations that they had. And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive, it is her plan, it is what she did everything for. He said her true motives were to use the criminal system to affect her family court case, to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, if the judge sees him arrested, it will help me keep my baby. She wanted him arrested in family court in front of the judge and made that very, very clear. That was what was important to her. The detective said in 20 whatever years that he's been doing this job, he has never had anybody ask him to do that. Never. And she was very adamant, and they talked for 15 to 20 minutes. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs, all because she could not get him to go with her plan. She also said to him, you will fucking arrest him in front of the judge, and I will make sure that you do. Then she said, I will do anything I have to do to keep my baby, asshole. She wasn't saying, I'm so afraid of this man. Please help me. I'm a victim of domestic violence. I need help. Not at all. She's saying, I want to keep my baby. And she's afraid that this man who is 30 years older than she is, and a lot more established, has a lot more money, has a lot more resources, she's afraid that this man is going to get custody of her child instead of her. So after this discussion with Detective Gillum, in about September 17th of 2018, the second hearing for the injunction happens. Remember, this injunction hearing was in two parts. One was in July and one was in September. All of the same allegations. He's poisoning me, the stuff in South Carolina. Again, they're not even living together. And she fails. The judge in that case says, no injunction. And this man will have immediate visitation with his child, who, by the way, was 6 months old and he'd never met her. It wasn't for lack of trying. There may be a lot of deadbeat dads out there that don't care about seeing their children and don't want to be around. This man tried everything to be around for his child, to be there for the birth, to visit the child, to see the child. And she kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. I'll go with you. And now we're in a stage where we're acting like we're going to get back together. Because she knew the court system was not working, and she was afraid that if she didn't buddy up to him, he was going to get this child away from her. So it begins the charade of her telling him, we're going to get back together, we're going to be a family. She played on Doug Benefield's wishes. He wanted more than anything to have his family together, to have his wife that he loved and this child all together. And she kept telling him, yes, that's what we're going to do. That's what we're going to work towards. So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. He files for divorce. And a series of complaints start against Doug Benefield for now abusing the child. Which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And May 1st of 2020, the defendant, having failed in the criminal system, again, files for another injunction. based on these allegations that fail in the criminal system. Do you see a pattern here? May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens? All of a sudden, she sidles up to him, and now we're getting back together. And we start to go to marriage counseling. And we go see Dr. Forrest, who referred them to Dr. Quintel. And they're going to marriage counseling about how they're going to get together. And to Doug, she's saying, yes, I want to reconcile. Let's get back together. But behind his back to the doctor, she's like, no, I know how. I'm not getting together with him. Then she goes on all these social outings with Doug and the child. Goes to the beach, goes to the movies, goes out to dinner, to lunch, swims at the pool in his apartment complex, giving Doug all of these mixed signals. We're gonna reconcile. We're gonna get all this back together. And in the back of her mind, she knew all along. She was just waiting for an opportunity to strike. And then 6/1 of 2020, the system sends them for an evaluation with Dr. Broder. And they're like, what is going on here? Someone needs an evaluation. So they go to this evaluation with Dr. Broder, and this deception on the part of Ashley Benefield continues. She does the same thing. We're going to reconcile, we're going to get back together, and then when she's not with him, she's saying that that's not true. And then towards the end of September 2020, but before the 21st, there's a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough. I want the report. I want this to be done. We need to move to Maryland. Why do you think she's moving to Maryland? We need to move to Maryland. This is taking way too much time. And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered. On 9/21 of 2020, after this comment to Dr. Broder, she goes to mediation with Doug Benefield, and they end the mediation saying, everyone's going to drop everything. Because at this point, Doug had filed for divorce, again. And Ashley had filed for an injunction, again. So at this hearing on the 30th, those things were going to be heard, as well as a joint motion to release a report by Dr. Broder. But they go to mediation, and at the end of mediation, it's very fast, because they all agree. We're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction. Look at the text messages between her and Doug that were introduced by the state for the week before this murder happened. They're talking to each other about the fact that everything's going to be dropped. Give this attorney a call. Okay, I'll give that attorney a call. Ashley's telling him we're going to drop everything. And she knew that was not true. Her attorney testified, we were not dropping that injunction. We were ready to call witnesses. At that hearing on the 30th, we were going forward. Ashley Benefield knew that day it was over. It was going to be over. Her entire charade was going to be done. This entire get along, go along that she's trying to say was because of domestic violence. She was just trying to fake Doug out. And she knew that on the 30th, her ruse was up. Because if she goes forward with an injunction, what better way to tell someone you're not going to reconcile than trying to get another injunction? So what does this timeline tell us for what happened at the time of the shooting? Okay, it's background, yes. But also, it tells you they did not live together for 3 years before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they hadn't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no. I do want to talk a little bit about domestic violence, and Mr. Ferris testified a lot about this wheel, this power and control wheel. So I want to put it up there. First of all, the overarching umbrella right here is physical and sexual violence. There is no physical violence in this case. There is no sexual violence. There's no allegations of any of this, unless you believe the defendant that the day this happened. But there was never any allegations of physical or sexual abuse. However, it's a power and control wheel. So let's go over some of these things. One of the first categories, using intimidation. So this is, did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. The first year they were apart, they barely even saw each other or spoke. So how exactly was he using intimidation to control her? And there's no allegations of threats during this time. The defendant testified. She didn't say that there was anything going on during this time. One of the other prongs is using emotional abuse. Same answer. They weren't together. There was no allegation of emotional abuse. The defendant didn't talk about anything that was going on during this 3-year period, that he was emotionally abusing her. She felt comfortable enough. She even said, I told him when he thought he was going to move in with me, I told him I didn't want to do that. She felt comfortable enough to say, no, you're not moving in with me. But yet somehow he's emotionally abusing her. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine, and she even started a new relationship with someone else. So how is it that Doug Benefield is exercising control over her by using isolation? And then minimizing, denying, and blaming. Well, nothing had happened in 3 years. So was there even anything to minimize, deny, or blame? Nothing had happened. And there was no evidence of anything happening, other than maybe some things that the defendant said happened, but did they really? For instance, Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there? He said he lived there. And somehow this translates to this person is looking into your windows across the street. And the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Did you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really. Then the next spoke on the wheel is using children. This man did nothing but try to see his child over and over and over. Ashley Benefield kept his child from him. So if anybody was using power and control, it was Ashley Benefield against him. And I think if you look at a lot of these folks, you're going to see a lot of behaviors on the part of the defendant that were actually using power and control instead of being a victim of power and control. Then male privilege is the next spoke. There was absolutely no evidence of male privilege. There was an email to the realtor to get a house, just as one example. And if you read that email, he says, okay, but I have to check with Ashley first. How is that male privilege? He's telling this guy he's going to talk to his wife. Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. That doesn't apply. Using coercion or threats.
God, she's
No
such
threats.
an asshole. I don't like her.
None. There were no allegations that he threatened her or hit her or did anything. He didn't make any reports or threaten to report her to Department of Children and Families. He didn't say, oh, you better do what I say or I'm going to call DCF and tell them you're a bad mom. No. That was the other way around. That's what she was doing to him.
No.
There were no allegations that he was trying to get her to drop charges. Quite to the contrary. She was not dropping any charges of anything. And Mr. Ferris talked at the end of his testimony about domestic victim mentality. So let's talk about this. One of the things in the domestic victim mentality is covering for the abuser. Like making excuses, covering for them. Did you ever hear any evidence of the defendant doing that? Never. Making excuses for the abuser, making excuses for their behavior. Not once. She was telling everybody, anybody that would listen. Not reporting abuse, same answer. She was telling anyone that would listen and a bunch of people that wouldn't listen. Dropping criminal charges. That certainly didn't happen. The domestic victim mentality, she won't stand up for herself. Never saw that with this defendant. She won't leave the relationship or the home. She left. She left the home, she left the relationship. They were not together for 3 years. So how does this domestic violence mentality, domestic victim mentality even apply to her? It doesn't apply to her. And don't be mistaken about what applies to her and what does not. Even, like I said before, even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between. So I want to talk to you a little bit about the jury instructions that the judge talked to you about. I just have a few on here that I want to go through. It's got to be overwhelming, I know, when you read the packet. There's a lot of words. So I try to help break it down a little bit. So the defendant is charged with murder in the second degree. So I would recommend the way you go through this is check off the things that you don't have to argue about. If everyone agrees to one of these, just check it off. So number one, Doug Benefield is dead. That should be easy.
What if
Check it
everybody
off.
agrees that you're a bitch?
Number two, the death was caused by a criminal act of Ashley Benefield. Check it off. She shot him. Number three, there was an unlawful killing of Doug Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Now, that's a lot of words. So what does that mean? The next slide explains what that means. An act eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, and again, check off things, okay? So a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Shooting a gun, firing a gun into someone clearly qualifies. Person of ordinary judgment would know that would kill someone. Check. Let's go to number 3. That this act is of such a nature that the act itself indicates an indifference to human life. Pulling a trigger, pointing a .45 caliber firearm at someone and pulling the trigger 4 times shows an indifference to human life. So then we go back to number 2. If the acts are done from ill will, hatred, spite, or evil intent. Now notice, this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files. Fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will. Everything she did was for this goal, and everything she did was to get Doug Benefield out of the way. And unfortunately, the way she did that was by killing him to get him out of the way. That is ill will, hatred, spite, or evil intent. Now, the judge read to you that there's something called a lesser included offense. And what you may have heard, but it's in your packet, is the way you should handle a lesser included offense is such. So if you agree as a jury that the state has proven a charge beyond reasonable doubt, you should start with the highest charge. So start with second-degree murder. And if all of the jurors agree unanimously that it's beyond a reasonable doubt that the state has proven their case and the defendant is not entitled to self-defense, then you don't even get to manslaughter. You don't have to go and then review manslaughter. You stop at the highest charge. You only get to manslaughter if you don't agree on the top charge. Then you get to the description of manslaughter. And again, check off the things that you are not arguing about. Doug Benefield is dead. Check. Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. Yes. There's no question as to that. Now, the state did prove this, but the state also proved the added element of ill will, hatred, spite, or evil intent. So we have proven manslaughter, but we have also proven above manslaughter. And I want to show you the verdict form, and then we'll go back. This was the verdict form that the judge showed you, just to let you see it ahead of time. And this is the heading that the judge read. We, the jury, find as follows. As to the defendant in this case, check only one. And here's A, B, and C that the judge talked to you about. Defendant is guilty of murder in the second degree as charged. Defendant is guilty of manslaughter, a lesser included offense, or defendant is not guilty. And then if you find A or B, then you have to answer all 3 of these questions. And then the foreperson will sign it and print their name. So the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are 2 words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those 2 words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. So let's get to the date of the offense, okay? Clearly, these 2 are getting along. At least according to Doug Benefield, he thought they were getting along. If you look at the text messages between the 2 of them, if you go by the information that you had from the witness stand that Ashley was acting nice, she was acting like they were going to try and reconcile in Maryland. They were moving together. They were using the same truck. He was coming to her house to help her move the heavy things. So they were getting along. They actually went to the mediation during this time. It was about 3 days before she killed him. They had mediation where they said they were going to drop everything, move into Maryland, and everything's going to be fine. But obviously that was not Ashley Benefield's plan because she knew she wasn't going to drop the injunction. Obviously, the day of the offense, Doug Benefield had a right to be at the house. She invited him over. They had text messages back and forth. Trucker on the way, he's taking a picture of the stuff in the back of his truck. And she'd let him in the gate numerous times before. So he had a right to be at the house. She clearly was not afraid, but she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield. And you heard her story. And she made herself a witness just like any other witness in this trial. And you will judge her credibility and the truth of what she said just like you do any other witness. And see if it matches the evidence in this case. If you notice, when being asked questions, she became evasive. If questions got a little too difficult or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes? Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break, crying hysterically. Takes a stand right after that. Eyes are just fine. Makeup's just fine. That goes to her credibility. What is she trying to convey to you? The truth or her version of events? Let's look at what she did say. She said, during this move that Doug bumps her on the shoulder a couple times, body check or something. She didn't really act that out very well. Who knows what that was. Doug, carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Wouldn't you expect a bruise to be there as well? You'll have the pictures in the back. So look at those pictures and see. There's no bruising. They look like cat scratches. The defendant also said when they were by the front door to the house that he grabbed her by the wrist and hit her in the head. So when I asked her, okay, what do you mean hit? Well, I don't know. Okay, was it an open hand? Was it a closed hand? What was it? I don't know. She should know if a grown man balled up his fist and punched her in the side of the head. And there would be a lot more damage than what she claimed she had. But she didn't know. He just hit her. Now, 4 people testified that they saw her after this incident, very shortly after this incident. Well, one of them was 3 days later, but the rest of them were very shortly after this incident. John Sands, the neighbor, he didn't see any swelling. He didn't see any injuries. He didn't see any disheveled clothes like there'd been a, rumble. Detective or Officer Burrell, Deputy Burrell, was the one that put her in the back of his squad car. No injuries. Didn't notice any injuries to her head or swelling to her face. Crime scene tech Dvorak took pictures. Didn't notice any injuries, any swelling to the face. 3 days later, crime scene tech Conlon takes pictures just to make sure, because bruises don't always come up right away, that she's not bruised. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen. Let's look at these pictures. These are 4 pictures that were entered into evidence. The first picture was, the defendant said, was before she even knew Doug Benefield. She thought it was before she even knew him. The second picture over to at the top, over on the right, is the night of the shooting. Down lower left is 3 days later. And then one over is about 5, 6 weeks later. Does it really look like her face is swollen? She said the side. She said right here. On the right side. Or, I'm sorry, the left side. Right here. The left side of her face doesn't, it actually looks slimmer than it did in the picture taken before she even knew Doug. So let's talk about what she did when she claims that Doug grabbed, I think she said she was going for the front door, he grabbed her arm, she kind of spun around, he hits her in the head, although she didn't know if it was overhand or not, and then she said, I just wanted to get away. I just wanted to get away, right? Here's the front door, right? She went this way and could have gone right out the door, but she just wanted to get away. She didn't go right out the door. She turned to her right and went into this room. This room that has nothing in it except for a mattress, a broom, and a hamper, and 2 handguns. It's hard to see in this picture because of the lighting, but I just want to remind everyone, here's the mattress, here's the broom, nothing else in this room, but there's a hamper right here with a gun on it, and there's a gun in this closet right here. And that's where she runs. And this is a better picture of the hamper and where the murder weapon was. So she just wants to get away, but she runs into the very back corner of this room and grabs the firearm. Now, she claims that as she's retrieving this firearm, he slams the door open and she turns around, right? And she sees him standing there. When I asked her to get down and show me what he was doing, that was another one of those evasive times. I don't know, he was in a fighter stance. I don't know what fighters do, but I know it's a fighter stance. Okay, well, show me. What do you mean a fighter stance? I don't know, kind of like this. Okay, well, what are his hands doing? Just kind of moving around. Okay, so his hands are kind of moving around. And it didn't look a lot like a fighter stance. And then she said, I'm standing there with the gun pointed at him, and he lunges at me. He lunges at me. Let's think about this. So if she's standing in the room, she has a gun in her hand, and he just came in the door, and she's pointing the gun at him. She says he takes a fighting stance. First of all, he's right-handed. Do this yourselves when you get in the back. If someone told you to get in a fighting stance, what would you do? And determine for yourselves, use your common sense, which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away. So if he's right-handed, he's in a fighting stance, he's going to be like this. Interesting, because he's shot from the side. So he's like this. And then she says he lunges at me, right? So if he lunges at her, he's head on, straight onto her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went. That bullet went side to side. And if he's in a fighting stance and he's right-handed, why would he have this side towards her? And Mr. Haig, the expert, the firearms expert, displayed when I said, okay, I'm going to point a gun at you. You show me where your body would have to be in order to get that trajectory. And he turned sideways. So his body in his fighting stance would have to be completely sideways. And what, he's skipping to her to lunge? I mean, how is that trajectory going to happen based on what she said? More than likely, the hands that were up was a defensive stance. He probably came into the room and said, whoa, she's got a gun, and started to turn around. He had his hands up like, whoa, what are you doing? It makes no sense to be in a fighting stance. So I want to talk a little bit about this trajectory just because there's sort of some misconception that this shot was front to back. That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, right-hand side, and that red dot is where it landed in the back. And let's talk about the leg wound. It's very hard to determine exactly how this leg wound happened. And we may never know exactly how it happened. But this is the basic trajectory of it. If a person were in a normal standard anatomic position, this is the medical examiner said that. This is a standard anatomical position. So in a standard anatomical position, that is the way the wound path went through his leg. So you can figure out for yourself different ways that might have happened. Now, Dr. Lou said, based on information that she got from Ashley Benefield, by the way, that it must have happened this way. That once he shot the first time, somehow he falls and his legs go way up in the air and he shot like this. Where did that bullet go if he was shot like that? The expert testified about the two that went into the wall had not gone through a body. He said the one that hit the leg was in the room. Might have been kicked, and that's normal when you have emergency technicians in there and they're kicking things around. But the projectile was in the room. It was not in the wall. So if he's falling back this way, his legs slipping way up. And by the way, Dr. Vega said the only way your legs flip up like that is if you're falling over a rail or falling over something and your legs come up that high. So that just does not make sense with the rest of the evidence. Now, this may not be the way it happened, but it is also another way that it could have happened. He is turned away, leg up, and that bullet could have gone in and come out his knee, but his leg was bent. So you use your own judgment and decide what you think about that leg wound. What's important is this wound. This was the wound that killed him, and he was not facing her at the time. The defendant trying to say he was in a fighting stance, he lunged at me, that is just her, once again, trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And then she sees her mother come by the car. Not once does she say, Mom, he just came at me. Like, I had to shoot him. It was awful. Nope. Not a word. She goes back to her mom that night. Not a word. Really? You're not going to tell your mom exactly what happened? And then this lady, Barbara Russell, that she lives with for 9 months after the shooting, never tells her what happened. Not once. Remember,
Okay. So
the defendant sat right there and said the defendant never punched her, ever. Never choked her.
this is so. I don't think I would argue it like this. You are just If this is a guy, we would all think he's an asshole. I don't know how she's arguing if it doesn't think she looks like a bad guy right now.
Never kicked her. Never came at her with a knife.
I mean,
Never
really,
came at her with
I
a
don't get it.
club. Never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder. Thank you.
Right, Mr. Taylor, do you need the screen?
Not.
I'll turn that off for you.
I mean, really, none of that. There's no mic drop moment in there. God, that was awful. Well, yeah, everybody's gonna have a lot more sympathy than her. That was awful. That was awfully put together. Absolute garbage, guys. I mean, I don't look at that and see. Yeah. I just don't. Hey, hi, Frank. How you doing?
Yes, sir, when you're ready.
Thank you. Good afternoon, ladies and gentlemen. I have a bit of a cold. I tested 3 times and it's not COVID. Don't need to be concerned. I've just listened to the state's closing argument. I have to tell you, I think there's obviously some real different perceptions of what the evidence is. I think perhaps there's even been some distortions. You all have taken, we've observed, pretty careful notes. If I say something that is not reflected in your notes or is not as you recall it, I want you to trust your own recollection. But I think if you check your notes, you will find that what I represent to you is accurate. This is and has been a fundamentally flawed prosecution. And I think we can demonstrate that through the testimony of 2 of the state's witnesses. The first is Stephanie Murphy. And you may recall she was the attorney who was representing Douglas Benefield. In my cross-examination of Stephanie Murphy, I served up for all of us, but especially for you, the members of the jury, what the state's theory of prosecution was. And I said, so Ms. Murphy, let's be clear so that there's no misunderstandings. It's your belief and the state's theory that Ashley Benefield killed her husband because the Broder report was scheduled to be released 3 days later. She said that's correct. Check your notes. Now, the state, in their opening statement, even made it dramatic. They said to you, this report by Dr. Broder was to be released on the 30th of September, but she killed him on the 27th to avoid that. If you look at the emails that have been introduced into evidence that reflect the conversations back and forth between Stephanie Murphy, Faith Brown, Miss Benefield's family court attorney at the time, and the judicial assistant for Judge Moreland, you will read in no uncertain terms, black and white, the Broder report was not set to be released on September 30th. Not only was it not set to be released on September 30th, there was not even a day for it to be released scheduled. Stephanie Murphy was attempting to have it scheduled. The JA wrote back in no uncertain terms, Judge Moreland will not hear that. The only thing being heard on September 30th is the domestic violence injunction. The other witness that I think reflects what a fundamentally flawed prosecution this is Detective Gillum. And you might recall that Detective Gillum, check your notes, said that the South Carolina domestic violence injunction that required no contact by either one did not go into effect until November 27th. But if you look at the written email that we introduced into evidence, where Detective Gillum is contacting Gina Torsha, Miss Murphy's assistant, Detective Gillum tells her, wait a second, he's helping them. Wait a second. This injunction, unless I'm reading this wrong, this injunction went into effect on November 3rd. The judge signed the order on November 27th, but on November 3rd, he announced it in open court, and Doug was present, and so was Ashley. So unless I'm reading this wrong, I want you to be aware of that. This is Gillum trying to help them. This is the same Gillum who gives you quotes of exactly what Ashley Benefield said 2.5 years later without having one word of it written in his earlier report. The same Gillum who I asked the following questions of. Detective Gillum, do they teach you in police academy about the importance of writing reports? Sure. And is the reason why the reports are so important is because it preserves important facts about a particular incident? Yes. So how many cases do you handle, Detective Gillum, in a month? You might recall he said, oh, probably about 20. And then we multiplied that out by 2.5 years. I think we were into about 600, 700 cases. Yet he remembers the exact words she had to say, despite the fact that on the day she said it, not one word of it appears in his supplement 2.5 years earlier. Ladies and gentlemen, Detective Gillum, you might also recall, countermanded the capias, the arrest warrant that the other deputy issued for Doug Benefield when Ashley went down there and explained that Doug Benefield had mailed her this package in violation of the South Carolina restraining order. Detective Gillum said he remanded it, he reversed it, and he was going to refer it over to the state attorney's office. This was a good old boy network. They liked Doug, and they never looked back. And that's the truth of the matter. Do you not find it astounding that Detective Gillum, 2.5 years later, could remember such things as Ashley Benefield saying, if the judge sees you arrest him in front of her, it'll help me keep my baby. Isn't that something that you would put in a report?
You think you would?
I think perhaps the most disturbing thing about the testimony of Stephanie Murphy and Detective Gillum is the following. Remember that common sense I told you about that you're going to be able to take with you back into the jury room, and that without offending anybody, there will probably be more than 100 years worth of it, which there is. Does anyone believe that either side calls witnesses that they don't know what they're going to say? So how do you reconcile the state calling Murphy and Gillum knowing that they're going to testify inaccurately? Read Gillum's written email about how he misrepresented his knowledge of when that South Carolina domestic violence injunction went into effect when he testified in front of you, and read the emails between Stephanie Murphy, Faith Brown, and Judge Moreland's judicial assistant. Okay, so what happens after that testimony? I want you to remember that the state's theory of prosecution up to that point is that Ashley Benefield
Good.
killed Douglas Benefield to stop the release of the Broder report because she was so afraid of what was in it. And right in front of your eyes, I've never seen it before, right in front of your eyes, the state changes their theory. And the next thing you know, their theory of prosecution is she killed him because the domestic violence injunction was scheduled 3 days later. Check your notes. See if what I'm telling you is not accurate. Both theories, honestly, are ridiculous.
Objection, Judge.
Sustained on that.
Both theories are not supported by common sense. Let's look at Broder. What exactly was it in Broder's report that Ashley Benefield was so afraid of that she killed Douglas Benefield. Check your notes, but try to think back to Broder's testimony. I think your notes will reveal that Broder never had one thing adverse to say about Ashley Benefield. In fact, the only thing that Broder had to say was that after evaluating Ashley Benefield, he found that she had no violent tendencies. She was not prone to impetuous acts. That's it. Her only concern, according to Dr. Quintel, was that she was afraid if Doug found out what she had to say about him, that he would take it out on her or on the child. Okay, let's look at the theory then when it shifts to it being the domestic violence injunction that was scheduled for the 30th of September. What kind of reason exactly is that for her to kill Doug Benefield? If that was a reason, wouldn't she have done it before? There was already a domestic violence injunction the first time. It was denied. It was not only denied, but Judge Moreland ordered shared custody of the child. Why wouldn't she have killed him then? For 4 years, Ashley Benefield did what any law-abiding citizen can be expected to do. She filed complaint after complaint after complaint, calling Doug Benefield's behavior to the attention of the authorities with no result. Over and over again, no relief. So she kills him? Really, that's quite a leap, ladies and gentlemen. You need evidence to support such an inference. You know, you can't take innuendo and wrap it up in an inference and call it a fact. You got to have evidence that supports a theory. For example, you know, in the reasonable doubt instruction, I'm going to show you in a minute, but it says a reasonable doubt can arise from the evidence, from the lack of evidence, and from a conflict in the evidence. So what evidence would you need to show to support this theory that flies in the face of common sense? Well, how about somebody who comes in and testifies, yes, I heard Ashley, I overheard her say, you know what, I'd kill this SOB before I'd let him be alone with my child. Or how about this? How about downloading from Ashley's phone when she's sitting there in her most private moments, never expecting it to be revealed to the world, searching on the internet how to kill an abusive spouse? How about that? Instead, what you saw in her most private moments 6 months before this happened was her searching on the internet how to co-parent with an abusive spouse. Am I making this up? Check your notes. How to get along with an abusive spouse. In my opening statement, I told you two things. I said that at the conclusion of the case, those were the only two things that would be established beyond a reasonable doubt. The first one was that Doug Benefield was a very sick guy. I think there's no doubt of that. The second thing was that Ashley's action on that day, September 27th, 2020, was absolutely justified. Let's take a look briefly at Douglas Benefield's behavior.
And it's a little
And I want you to
meandering
keep in mind
I don't like this.
Bruce Ferris's testimony,
I don't like this.
who's the former cop who specialized in domestic violence, ran a domestic violence department, and then was so fascinated by it, went back to school to become a licensed mental health counselor. I thought he was a pretty persuasive witness. Doug Benefield shoots a gun into the ceiling of their kitchen to intimidate Ashley to stop speaking. Now, those are easy words for me to speak, and they fall on ears and you move on to the next thing. But I want you to try to imagine how it would feel.
Objection.
Sustained.
How would one feel sitting in their kitchen, having their husband pull out a gun and actually fire it into the ceiling of their kitchen? Can you imagine the trauma of such a statement? Do you think that that's something that you forget about after 6 months, after a year? I think that's something you remember for the rest of your life. You never forget it. Throwing a loaded gun at Ashley Benefield, threatening suicide, not only to Ashley, but to his former wife, Renee. You've got a copy of her text message that she wrote to Doug, kicking her on their honeymoon and threatening suicide. So this is twice now, not only with Ashley, but with his prior wife. Punching the dog so hard that he knocked the dog unconscious. Bruce Ferris on the wheel. Now, I'm not an expert on the wheel. I don't pretend to know it anywhere near as well as apparently Miss O'Donnell does. But I can tell you with certainty that it has a provision, and Bruce Ferris elaborated on the fact that abusers tend to hurt pets because they have no empathy and because, check your notes, they can control the victim because the victim loves the pets. So hurt the pets, you keep the victim in line. You get compliance, control, and compliance. That's what they seek. Threw the cat down the stairs. Put a tracker on her car. The neighbor catches him in the yard at night. It wasn't in the house across the street. You've got the schematic of the houses in the neighborhood. You see Mr. Sands' house is right next door, literally, to the left of Ashley's house. Ashley's house has got the red dot on it. Cursing, yelling, screaming, belittling. Text messages. I'm in a murderous mood. I want to rid the earth of them. Take them out. That was about two guys having a conversation while Ashley was on a cruise. Doug Benefield was so demented that just hearing in the background two men speaking while Ashley was on a cruise makes him say he wants to take them out, rid the earth of them. That puts him in a murderous mood. Of course, Ashley at the time at 24 thinks, well, gee, that's kind of flattering. I guess this guy really loves me. Oh, that was just a little tip of the hat to what was to come. The South Carolina injunction, he violated it. There's no way around that. How about driving from South Carolina to Florida so that you could follow Ashley in the car? I mean, if that's not determination, what is? If that's not fixation, what is? If that's not obsession, what is? And most chilling, I thought, was Mr. Vincicaro, the realtor, who, while the injunction is in effect from South Carolina, look at the email between Doug Benefield and Vince Vincicaro. I asked him, did you have any dealings with Douglas Benefield? Yes, I did. What was it? He was a customer looking to buy a home. Where was that home? It was the house immediately behind Ashley Benefield's house. This is sick, ladies and gentlemen. This is while the domestic violence injunction is in effect. Not only that, but then he says to Mr. Vincicaro, well, I have to first check with Ashley. Well, you know that's a lie. He can't check with Ashley because the injunction doesn't allow him to communicate with Ashley. So what's the basis for that conclusion that Doug was that disturbed? Well, how about Doug's own admissions? You have the text messages where he admits to Ashley, you know, I'm sorry, I apologize. And according to Miss O'Donnell, well, that should be the end of it. You apologized, it's over. Unfortunately, Bruce Ferris explained to you that that's the MO of an abuser. Oh, baby, I'm so sorry. Please forgive me. It'll never happen again. And it happens again. Time and time and time again. That's their pattern of behavior. And Bruce Ferris told you that. He explained that to you. Ashley Benefield got on the stand and told you about all of that. And I have a great discrepancy. I'm wondering if we were at the same trial between Miss O'Donnell's evaluation of Ashley's testimony and ours. But how about this, in addition, as a basis to establish how disturbed Doug was? How about the letter that Ashley Benefield leaves for Doug on November 17th?
Objection, not entered in evidence.
Sustained.
Judge, I was testified to by Ms. Benefield. I'm just speaking to the letter, not quoting from the letter itself.
Okay.
So she told you that she left him a letter. She told you what she put in that letter. That letter recounted some of the things that he did. Some of the things that you heard about in the trial, such as shooting the gun, punching the dog.
Objection, content of the letter.
Oh,
So, how about that as a basis to support it? She described them as controlling and manipulative. You're putting me and my unborn child in danger by the way you drive. You drive crazy when you get angry. How about Dr. Quintel? He doesn't even have a dog in this fight. He's got absolutely no reason to shade his testimony one way or the other. What did he tell you that he concluded about Doug? That he was, quote, super controlling, unquote. That he was jealous. That he was intimidating. That he was a real alpha male. Dr. Quintel's description, not mine, ladies and gentlemen. And then we have Ashley, who's the victim of domestic violence. We have the history of the prior acts of domestic violence by Doug. According to Dr. Broder, the state's witness, and Bruce Ferris, our witness, victims of domestic violence look for appeasement. Dr. Broder, I even asked him, I think that word appeasement appears in your report about at least 4 times. They go along to get along. They walk on eggshells, always afraid that something they might say will set them off. And according to Bruce Ferris, what the abuser wants is compliance. That dynamic changes very significantly once a child is introduced into it. And why is that? Because the abused woman is going to look to protect her child. That's what mommies do. So she will put herself in danger in order to stand between the abuser and her child. Yet, Ms. O'Donnell argues, well, when they first exchanged custody, as Stephanie Murphy said, Ashley looked happy and very content. Well, we know from Bruce Ferris that that's the compliance mode. That's what you do to protect your child. She knew how Doug was. He went off on her. The only thing worse than that would be him going off on Emerson, the child. You keep the beast at bay. Those were the words of Broder and of Bruce Ferris. Importantly, Bruce Ferris told you that victims of domestic violence appear to act happy. So you have these text messages in the week leading up to the shooting where they're saying nice things to one another with emojis and smiley faces. And you have the video of the restaurant where Ashley and her mother and Emerson are present. And Ashley appears to be acting happy, when in fact she's actually quite scared, according to Bruce Ferris. But you go along to get along. You might recall in the voir dire, I asked you about the presumption of innocence and how many of you had ever seen a cop car on the side of the road with somebody sitting in the back. And the first thing you thought to yourself was, gee, I wonder what they did to cause them to be in the back of the squad car. And I told you that the issue to be resolved in this case was the force used justified? All of you pledged that if the state failed to prove their case beyond a reasonable doubt, your verdict would be not guilty. All of you took an oath that said, at the end of the case, if you were unsure, if you did not know what happened, if you did not have an abiding conviction of guilt, you'd vote not guilty. I want to show you the beyond a reasonable doubt instruction. Deputy, if I could have the easel, please. This is in your packet of instructions. You're not going to have to memorize it. I want to just go over it, though, for a moment. I think we can agree it's pretty important. It reminds you that the state has the obligation and the burden to prove the case, to overcome the evidence to the exclusion of and beyond a reasonable doubt. And here's how they define reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, goes back and forth, gee, I don't know, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must, not you can, ladies and gentlemen, not you may, you must find the defendant not guilty because the doubt is reasonable. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. Thank you, Deputy.
That what? That was not very, very good at all. I was not. Damn, I didn't think you could do worse than the prosecutor. That was awful. Charts are beautiful, yes, but yeah, guys, I was not impressed with that. I was not impressed with that. I mean, the problem is we can't see the charts, but TV just turned on and there's no one else home but me. We're going to hit play, chat, and I'm going to go take care of something. What the fuck is this? So.
Let's take a brief look at the facts rather than theories. Because once again, the prosecution could not have been more clear. Ashley killed Doug to prevent release of the Broder report. So where was the evidence to support that theory? You can't simply say it and make it so. Ms. O'Donnell comes up, and the evidence that she presents to you to support that theory is that Ashley said, I'll take matters into my own hands. Ladies and gentlemen, Dr. Broder testified that Ashley made that statement on her way out of his waiting room. And I asked him specifically about it. Please check your notes. What was she referring to? And he said, going to the authorities in Maryland to seek relief from them because the system here had failed her, and she was very frustrated. Ms. O'Donnell also told you that Doug Benefield filed for sole custody of Ashley. Please check your notes. No one ever testified to that. There's absolutely no evidence in this case that such a thing was done or a statement was made. Other evidence in the case? Justin Warren, the lead homicide detective.
That was weird. That was weird. No, the TV fucking turned on. And the remote's like up out of the way. That was really weird. Oh well. So. Anyways, let's keep going.
They never even called him.
Objections.
We called him. What did he tell you? He told you that in his arrest warrant, he said it did not appear that Douglas Benefield was facing Ashley Benefield when shot. Now look, Dr. Vega came in here and testified that the shooting in the chest, the shot to the chest, was from front to back. Yet Ms. O'Donnell comes up here and distorts that and tries to tell you that it wasn't from front to back. It was from side to side. Dr. Vega told you the trajectory of the chest shot was front to back, right to left. Now, not only did Dr. Vega tell you that, Michael Haig told you that, front to back. Dr. Liu told you that, front to back. There has never been any evidence introduced in this trial that the chest shot or the arm was anything other than front to back. Detective Warren told you he did not speak with the medical examiner before he submitted his arrest warrant. I showed him his report to refresh his recollection. Oh, yes, I did speak to the medical examiner. And finally, I asked Detective Warren about a supplemental report that he wrote where there's a section that provides for any bias that he was aware of that Ashley would have had against Doug. And the form was written none. And I asked, is that not where you would write in things like ill will, hate, or spite? Mike Haig, let's look at his testimony for a minute. I think you'll remember him. What he said, I thought, really presented it well, was in explaining what forensic meant. He said it's the juncture where law meets physical science. Okay? So he told you there were 4 shots. He gave you a 3-dimensional diagram, and it showed you the room and how the shooting took place and where the shots went. One shot, according to Michael Haig, went out the door and down the hallway and lodged in a book. He described it as a miss. One shot was in the wall. Told you it was a nice round hole in the wall. They put a trajectory rod in it. One shot was in Mr. Benefield's chest. It was lodged in his back. Dr. Vega removed it. And one shot was in the leg. The state's own witness, crime scene people, told you that the shot to the leg was on the floor in the room and that a piece of it had broken off. And Haig told you that as well. According to Ms. O'Donnell, if you completely suspend the explanation that Dr. Liu gave you about the shot to the leg, if Douglas Benefield was running away, that's how you could get the shot in the leg. You might remember that the trajectory or the wound path to the leg was up. Ashley would have had to have been lying on the floor to shoot up so that the bullet would go in her calf. Dr. Liu explained to you exactly how that happened. We even had our summer law clerk, William Galvano, come here and demonstrate.
It's a problem.
What else did Michael Haig tell you that was significant? He told you that they were moving. He said both Douglas Benefield and Ashley Benefield was moving. And he even showed you how it went from right to left in that 3-dimensional diagram with the first shot out the door, the second shot in the wall, or one shot out the door, one shot in the wall, one in the chest and one in the leg. He showed you the 2 different cones. That would be consistent with what Ashley told you about trying to get more distance to move away from him. There was only one way to go in that room. She was already back to the back of the room, so the only way she could go was sideways, to her left. Finally, he also told you that Ashley's explanation was absolutely consistent with the physical evidence. Then we had Dr. Liu, Emma Liu, former medical examiner for Miami-Dade County, who has always testified for the state, except here, she came in and testified for the defense. Why do you think that is? Dr. Liu told you that the abrasion to the arm, she believes, was from front to back, and she believed it was the shot that went out the door and down the hall. And the bullet would not have mushroomed or expanded, as you heard Michael Haig explain, that bullets are designed to be able to expand. Because the wound was so superficial, there would not have been enough tissue in the hollow point of the bullet to expand it. She also told you it would be consistent with Doug lunging at Ashley Benefield. And she showed you with rods how the abrasion to the arm would take place, as well as the shot to the chest. Now, here's something interesting that maybe everybody's forgotten. Ms. O'Donnell did not address. Who was it that told us that Doug was skilled in martial arts and trained to take the weapon away? Why, that was his daughter, Eva. So here's Doug, who gets into his fighting martial arts position and lunges at her to grab the weapon, and Dr. Liu explains the abrasion shot. All four of these shots had no pattern at all. These are four random shots, no association whatsoever, indicative of somebody who's in an absolute panic firing a gun. What's more, as not only Mr. Sant told you, Mr. Haig told you, and as the state's own witness told you, if you don't hold the weapon properly and give it the pressure that it needs, it will result in a jam from one of the cartridges, just like what happened here. So I want you to please consider something. Before evaluating the defense case, you have to first determine whether or not the state failed to prove that the shooting was unjustified. That's your first order of business. Because if the state failed to prove their allegations beyond a reasonable doubt, it's over. You don't need to evaluate the case that the defense presented. We weren't obligated to present anything, but we did. And I think we can agree that if the state's case does not meet that threshold of beyond and to the exclusion of every reasonable doubt, your verdict must be not guilty. Ashley Benefield got on the stand and endured over 2 hours of cross-examination. It was our perception that the state never landed a blow in over 2 hours. That's 2 hours in addition to the hour and a half that I had her up there on direct examination. In the world in which we live, it sounds strange to try to reduce an event like this to an explanation within an hour and a half. But this is the only form that we have to resolve things like that. So we did it. And Ashley got up there and she explained to you exactly what happened. And she did it well. And the state never touched her. Look at the crime scene photos that were taken, not at some modeling presentation, not at some outing. Look at the crime scene photos that were taken by Miss Dorvac. They're in evidence, and you see if you don't see swelling and redness on those photographs. So it's September 27th, 2020, the day of the homicide. Doug arrives at Ashley's house late that afternoon, and he's already simmering. He's on a slow boil, ladies and gentlemen. Why? Because he knows she's leaving. She's leaving. He's not going with her. He's going to live somewhere else. He knows that. This was his last hope for any kind of reconciliation. And Bruce Ferris told you that the most dangerous time for a domestic violence victim is when the abuser recognizes that she's leaving. So how does Doug respond? With threats and intimidation. He would not leave. Ashley tried to de-escalate it. She could see how he was starting to build. She wanted to avoid a confrontation. Gee, you know, Doug, we pretty much got everything done. Why don't we quit for the night and we can continue tomorrow? He ignored her. Instead, his hostility starts increasing. 2 body checks where he bumps her shoulder, passing her in the hall. And it's not a bump that's an accident. It's a bump to intimidate her. She told you she almost lost her balance. Then we have the cardboard box incident where he slams that into her. Once again, she tries to de-escalate it. She even apologizes to him. And I asked her, why in the world would you apologize when he was the one who hit you with the box? Well, shortly after that, Ashley's had enough. What does she do? She tries to leave. She tries to flee the house. He catches up to her, grabs her by the hand, whirls her around.
Better now.
His back is now at the front door, and he's got her blocked. Somehow, Ashley finds the inner strength to yell, "I'm done. You need to leave now. I'm done. You need to leave now." Please check your notes. That's going to be real important. Why? Because that revoked Doug's permission to be in Ashley's home on that afternoon. And here's what the instruction is going to tell you about that. It's in your packet. It's going to say the law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, I think we can all agree this was her home. Doug did not live there. He was there by her permission on that day to help pack things.
Okay.
She had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1, Douglas Benefield had permission or consent to enter the dwelling or structure owned by or in possession of Ashley Benefield. 2, Douglas Benefield, after entering the structure, remained inside after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure. The offense was false imprisonment. Ashley tried to leave her home. Doug stopped her, spun her around, and held her trapped inside the house. Or B, attempt to commit a forcible felony. Forcible felony is aggravated assault. Through threats and intimidation, Doug committed the offense of aggravated assault. It's in your packet, read it. The important point is that once Ashley says, I am done, you need to leave now, he becomes, in essence, a burglar by remaining in that house after she tells him to leave. Not my words, not my law, the law that Judge White has given you. The last witness that we saw was Amy Carlton. And you might wonder how Ms. Carlton fit into all of this. Well, actually, she played a very significant role. We called Amy Carlton to show that this was anything other than a staged event. If you accept Ms. O'Donnell's interpretation of this, it was a staged event. It was a setup. Ms. Carlton told you that she was out walking the dog with her husband. They heard a series of shots. And less than 30 seconds later, Ashley emerged from the house, hysterical, screaming, holding the gun, and ran right next door. If you're going to stage an event like this after the shooting, you're going to certainly check the scene to make sure it's going to support your version of the event. Because if it doesn't, you're on your way to prison. It's going to take you less than 30 seconds to do that. The state has failed to prove anything here beyond a reasonable doubt. We prove self-defense beyond all doubt. But the burden is not ours. It's theirs. And they must prove it beyond and to the exclusion of every reasonable doubt, which, ladies and gentlemen, they just have not done. So, for the last several years, I've walked hand in hand with Ashley.
Objection.
I'm now going to surrender her fate to you. I've presented to you everything that I possibly could
Now,
to show you the
that's bad. When you start objecting like that, prosecutor, just leave it alone. You're not getting anywhere. Now you look like an asshole.
dynamics of what took place on that day and why they took place and what Ashley knew about Doug at the time they took place to show you that her action in using deadly force was reasonable. The judge is going to tell you in your instructions you can take into account what she knew about the domestic history with Doug, the size differential between Doug and Ashley. Ladies and gentlemen, Ashley Benefield is not guilty of murder in the second degree. She's also not guilty of manslaughter. When you read the manslaughter instruction, it tells you that it is not manslaughter if the shooting was justifiable, if it was in self-defense. The manslaughter instruction tells you that as well. You all promised in voir dire that you would stick to your guns and not be intimidated by the majority or the other jurors. Manslaughter is a compromise. Ashley's not looking for a compromise. She's entitled to more than that. This is either second-degree murder or it's not. If you follow the oath that you took and you read the instructions, we're confident you will return a verdict of not guilty in this case. Thank you very much.
Thank you, Mr. Taylor.
Thank you, Judge.
Rebuttal?
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times. And why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Gillum remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make him. That's what she told a law enforcement officer. You think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did. Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did, with 45. And let's talk about what we've heard. And it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory. But I want to set some groundworks. Number one, Ms. O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then they wouldn't have. And that's why they did it. That is not an old boy network. That is how our country works. That is what the law is for. Otherwise, any woman could walk into any police station and say, my husband did XYZ, and they'll just try to arrest him? No. It requires evidence. It's the same reason that law enforcement took a long time between this murder and her arrest. They were investigating it. They were making sure they had everything they needed to have. And when they did, they effectuated an arrest. And the prosecution, you heard a lot. You heard Ms. O'Donnell's name more than Ashley Benefield's name during that closing. It's not about Ms. O'Donnell. It's not about Ms. Friel. It's not about either of us. It's the state of Florida, and we have the burden. And we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield so she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Ms. Murphy and her client, who was murdered just a few days later, thought that Mr. Broder's report was coming out. Clearly, Faith Brown and Ashley Benefield thought or knew that they were having an injunction hearing on that day. The jig is up. She has wanted this man out of her life. She has wanted her baby to herself. And what is she doing? She's so scared of him, she has him doing her manual labor. You can come over. You can move my stuff. You can get heavy stuff. You know what? Can you stop and buy me boxes? Can you stop and buy me tape? Do you want to go to the gardens? She told you that she couldn't dress a certain way. She was in a sports bra and shorts when he showed up. You didn't hear that he said a word. You didn't hear that he had insulted her in any way. She would have you believe all these things about Mr. Benefield. And mind you, Mr. Benefield is not on trial. Ashley Benefield's on trial. Ashley Benefield's the one that committed a criminal act on 9/27/2020 when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding of what was going to happen. There's certainly no dishonesty by Detective Gillum. Not remembering something or Detective Warren and being dishonest are two wholly different things. And nobody's expected to remember everything. The question for you, as Ms. O'Donnell said, is whether or not it was reasonable and necessary for her to kill him, for her to shoot him that day when he's in a shorts and a t-shirt and flip-flops doing her work for her. And keep in mind, this ninja we've heard of, 5'9", 169. Adult small t-shirt. Adult small t-shirt, size 30 waist. We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. One of the biggest being trying to maintain this relationship. But it ended in his death. So it wasn't reasonable. Never hit her. She said he never hit her. He did some outrageous things, but never hit her in any sort, way, shape, or form. In 3 years, they've been.
Calling those outrageous is not. You should call them what they were. That's far more outrageous.
3 years. Reasonable. Is it reasonable? She would have you believe that, and look at those text messages. Look at the text messages going into that week, that whole week. And look at, I would ask you to read the state's version because that is a complete conversation. Oh, I'm sorry, those are the older text messages. When you look at the older text messages, this murderous intent, he's talking about her old boyfriends. She admitted that. And them choking her during sex. He's not talking about wanting to go out in the world and murder people. He's certainly not talking about her. It may not be what the average person thinks of a way to express your love, but apparently to Doug Benefield and to her, it was. So she's like, I know, baby. Don't talk like that. She never checks it, right? She never says, oh, don't. She says, I think she says, it was just a fight. These men that were just talking, she says it's a fight. So don't be confused. Look at the evidence. Then the text messages leading up to that week. Look at them. You have them. They're the ones Ms. O'Donnell did that had the video of them playing a game at Panera where they're all yucking it up. I would dispute that she was afraid. I would dispute most of them, Mr. Ferris said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse. 3 years. He's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child to terminate his parental rights. And no allegations that he insulted her, came to her house and hit her, did any of those things. Shot any guns, had any guns, none of that. Right? So she did all those horrible things. If you want your baby, those are horrible. To Doug Benefield. She did all those things. Nothing happens. But this day, when she has been dictating for a week when he could come over, when he could help her, what they would do, she would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There's no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keep in mind, she saw her the night of. This is her. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her. This woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them till the cows come home. You won't see swelling. All those law enforcement officers who are trained to look for that, crime scene techs who went there for the sole purpose of finding injuries and had some lawyer pointing out that her ear was red. Look at that picture. There's no redness. No redness. So he becomes so enraged that he hit her for the first time. She doesn't go down. She didn't say I fell. This man is a trained fighter who's a ninja, and he hits her and she doesn't go down. And she can't tell you if it was a slap or a punch. There's a big difference. There's a big difference. And if he punched her in the eye, her eye would look way different than it does. There's no swelling on the side from a punch.
You got to be careful about that.
Not a bruise. Not a swell.
That's a good argument to make.
So let's say it was a slap. Let's believe her. It was a slap.
A good argument to make.
There's no redness, no swelling, no bruising, no scratching, no evidence in the photos. I mean, if somebody slaps somebody in the face, there's a red mark. Nothing. Within minutes. Stop. And even if you don't believe law enforcement, which I submit there's no reason to not believe them, Mr. Sand, that sweet old man who she brought this drama into his home, said, I didn't see any injuries. Wouldn't he be the one in the best position to see if she had been slapped in the face moments before? Certainly. He didn't see it because it wasn't there. It's an attempt to manipulate the system, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together. And it was fine. It was fine. So he gets so enraged and pops up and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. Is that reasonable? It is not. trying to think of a way to say this nicely, but I would submit to you that everything that Dr. Quintal said about Doug Benefield was basically Dr. Quintal talking with Ashley Benefield's voice. She's a manipulator. She manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are, right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things, he conceded that they were all based on what Ashley told him. Not based on anything he observed. He conceded that, which I appreciate. But the weird thing was that he had this weird encounter where he thought that Doug didn't want to see the child. And what did he say? I saw him for a few minutes in my waiting room. I went into a session for an hour. And then I saw him for a few more minutes, and then we started their session. So what happened in that hour? Dr. Quintal doesn't know. For him to make any assumptions on what the relationship was between Doug Benefield and his child based on seeing him for those few minutes is not reasonable. There was no basis for that. And keep in mind, through all of that she's dictating when Doug can see that baby. We don't know if he knew she was out there. He's sitting in the lobby of a psychologist or a therapist's office. We don't know that he knew she was out here. There's so many assumptions that Dr. Quintal jumped to in order to say those things, and they're just not reasonable. Despite a court order, she's dictating when Doug sees that baby and how, and then you're supposed to believe that it was something weird about Doug that he didn't go out to the parking lot. He could have been in the parking lot for an hour for all Dr. Quintal knows. And the one thing he did say that was interesting was Ashley said she was frustrated with the system, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. She tried to terminate his parental rights. Judge said, he can see that baby. That 6-month-old that he's never seen. So what did she do? Well, I don't really want him to do that, so I'm going to dictate how he sees the baby. Now I'm going to be sweet again. Now I'm going to go back. I think the only person that was in a cycle was Ashley Benefield. I'm not going to talk to you for months, but when somebody says you can have my baby, now I'm your best friend again. That's not Doug Benefield. He acted the same way in those text messages as she told you he did for 3 years. No violence, no threats, no manipulation, no emotional abuse. And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship. He would not concede anything. On direct, Mr. Taylor was giving him hypotheticals that had 6 or 8 aspects to them. And he was able to just answer. Oh yeah, sure, that's domestic. Goes right on the wheel. I'm asking him simple questions, and everything he would not concede. The only one he conceded about was that if she was living on her own, he couldn't have been economically controlling her. But how did he not concede that one, right? That's common sense. Every other thing he refused to concede. And this is one thing I will agree with Mr. Taylor. We have different perceptions because I think Dr. Ferris was clearly biased based on his inability to answer my questions when he clearly could answer the defense questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's a victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. And keep in mind, Mr. Ferris would have you believe that somebody could be violent and then never be not violent again. That's what he said. I said, are you telling me that once there's violence in someone, it can never be changed? Well, if that's true, why does he teach CBIP? He makes his money on CBIP, right? Certified Battery Intervention Program. If what he told me was true, he's wasting people's time because he doesn't believe anybody can get better. And we all know that's not true. People change. People learn. People realize what they've done. People apologize for what they've done. And while saying the words is not enough, 3 years of not being in any way violent or threatening or abusive, that's an indication that Mr. Benefield was trying to change. He was trying to do anything he could to be with his wife and to be with his baby. And Mr. Taylor the defense kept saying trauma. She was so traumatized by this gunshot in the ceiling. So she had a baby with him? She testified to you that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. all the while she's so traumatized? I would submit to you that is not the case. She wanted a baby and she got one. The Doug was in the way. And as to that neighbor thing, it wasn't Mr. Sam. I don't know where that came from. There was no allegation it was ever Mr. Sam. It was some neighbor across the street. And Ms. O'Donnell told you exactly what was in evidence. Somebody across the street saw some man in her backyard wearing a baseball cap. And clearly that must be Doug Benefield looking in Ashley Benefield's windows. That's ridiculous. That's a jump you cannot make. That man could have been looking for his dog. We have no idea. There's certainly no evidence he was looking at anybody's windows other than the defense counsel saying that. And even if he was, does not make it reasonable and necessary to shoot him. It is not a basis that would cause you to believe he's going to kill you. Going to kill you. Not a basis. I would bet you he never was in that yard. He was never looking in the windows. But even if he was, a tracker, not a basis to believe he's going to kill you, if that even happened. The house. Buying the house. I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that that mutual injunction was, I'm sure, Miss Benefield was speaking to him when it was convenient for her. But she could get something out of it. It only goes with the rest of it. This letter we've heard about, that Ms. Benefield testified all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Liu when it comes to trajectory. He's an expert, no doubt about it. That's what he does all the time. Dr. Liu, the medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why did she do that? She did that because she's getting paid. She's getting paid to be here. That's why she's here. That's why she's saying those things. And most of them are probably very accurate. So Mr. Haig tells you there's 4 shots. We know that, right? We have 4 casings. We have 4 projectiles. One is in Mr. Benefield's chest or back. And I think there was an understanding of what Ms. O'Donnell was trying to show you. What she's trying to show you is that if it was...
I'm to the point now where when I have cases and they talk about like the witness coming in, the expert coming in, that they're being paid, everybody gets, and I'm going to make the argument for now, everyone gets paid. Everyone gets paid. None of us are the Salvation Army. No one's doing it for free. The coroner's doing it for his check, his pension and retirement plan. That's bias too. Everyone's got a bias for a buck. I fucking hate that argument. Like, I'm going to start objecting from now on. It's like, well, everybody makes money. The prosecutor's getting paid. If she didn't convict people, she wouldn't get paid. Like, we all got incentives to do our fucking job. Like, I fucking hate that.
From the front, because say I'm lunging, it would go in my chest and out the back. That's not what happened. It went front to back because it hit him here and came out here. Well, that's front to back. That's not front to back like it goes in my chest and comes out my back. That's front to back because it didn't end up here, right? Or she didn't shoot him in the back, it ended up on the other side of his back. It goes across his body, destroying his lungs, destroying his spinal cord, damaging his ribs. And what did Dr. Liu say? He dropped. He dropped. I think that's important. So Mr. Haig said there's 1 bullet, right? We got 4. 1 is in his chest, so we know where that one is. 1's in the living room wall that Mr. Haig said he believed was going down and struck the tile and then bounced up and hit the wall. He knows better than me. Seems reasonable. 3 is in the wall, number 7. Perfectly round. Typical gunshot. Nothing in its path. Because what did he say? Something was in his path and would begin to tumble.
Here's the point. If she didn't convict people, she wouldn't be a prosecutor. Like if she lost every case, she wouldn't be a prosecutor very long. We're all motivated to do this by a job. And if we aren't good at our jobs, we all don't get paid. Right? That's the point. Well, he gets paid, but you know what? Everything he said was true. I fucking hate it when they bring that up. Keffels quit social media? Good. Why aren't they? Because nobody ever objects to it.
Be that perfect hole that we picture as a gunshot in a wall or target or anything. And then through his leg. So which bullet hit his arm? And I think Dr. Liu might have been correct when she had that young man laying on the floor. It probably went through his leg and he was on the floor. Because Ashley Benefield told you something. She said, she's shooting down. We know that's not true, right? Because his chest is way up here. His chest isn't down here. But she told you that once I had stopped shooting when he fell. That's also, I think, untrue. Dr. Liu told you he would have dropped. So he's paralyzed, laying on the ground, and she continues to shoot at him. Otherwise, if you believe that she's moving from left to right to get away from him, he's dancing around dodging bullets. They'd have you believe this is a very tight room. I don't know how tight it is, but you can see there's either a full or a queen size mattress in that room, and there's plenty of other room. This is not a room closet. This is a full size bedroom. And what else do we know? Dr. Vega said that they had been at least 3 feet apart. 3 feet apart. Uncontroversial. Nobody said anything different. Except for our firearms guy. He talked very fast. But said, he looked chemically at the shirt and found nothing. 6 to 7 feet. 6 to 7 feet. Even if we go 3 feet, you have to keep in mind, that's from the end of the gun. She is pointing a gun at him. Here to Mr. Benefield is at least 3 feet, if not 6 to 7, when she hits him in the chest. At least 3 feet when she hits him on the leg, because Dr. Vega said there's no stippling on the leg. They're not in close combat. We keep hearing about this. They're not in close combat. They're a whole road-sized man apart, 6 feet, from the end of her gun to his body. And we know that. That's from the science. That was uncontroverted. You heard nothing to question that. You can take that one to the bank. And I would submit to you that those 2 experts, Mr. Haig was the one you should be depending on, even though he's also spoke to Ms. Benefield, so clearly got one side of the story, or a made-up story. And that Dr. Liu is not the expert that Mr. Haig is on trajectory. So if you go in the back and you're curious about the trajectory, I would say you should depend on Dr. Vega's testimony about how the bullets entered the body and exited, which Dr. Liu did not contest. And as for the other bullets, you should depend on Mr. Haig, because he was clearly more suited to answer those questions. As to Detective Warren, poor Detective Warren, who gets called just to be impeached, said he had opinions. You know whose opinions don't matter in this case? But Detective Warren's. Mine don't matter. Ms. O'Donnell's don't matter. Defense attorneys don't matter.
Why didn't you bring them
It's your
up?
opinions that matter.
That's a big
Because when you go
question
in the
you
back
aren't
and you listen to
answering.
the facts and evidence in this case,
Why didn't you
and you
bring them
decide
in?
to
That's a
prove our
big
case.
question here.
And Detective Warren, at the time in which he made his decisions, thought that he was shot in the back. That's not wholly unreasonable. He may have been mistaken. It doesn't make his opinion invalid, but what it does, it's not relevant to your decision making, because you're depending on the facts, and you have the accurate facts.
You have 10 minutes.
Thank you, Judge. I appreciate that. And that whole bias business, Detective Warren explained what that is. That's sexual bias or racial bias. This wasn't a hate crime. This wasn't a crime because somebody hates somebody else because of their sexual orientation. That's not what this is. That's not a place to put ill will, hatred, spite, or evil intent. Ill will, hate, spite, or evil intent is not bias. It's an element of second-degree murder. It's a depraved heart. And that's what Ashley Benefield had when she murdered Doug Benefield. A few more things, and then I want to talk to you lastly about the reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland, because then who's going to move her boxes, right? I can't say in front of Doug, I'm not moving to Maryland with you, because then maybe he won't drop his divorce case. Then maybe he'll try to take my baby, right? She can't let him know that. She can't let him know that because he's packed her up, ready to go. It's manipulation. And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew the jig is up. He might seek more control. They probably just went in there. But Stephanie Murphy told you that when they went, she was trying to get an injunction and it was denied. And he was trying to get custody, visitation, see his baby for the first time. She said something I thought was very telling. The judge gave Doug sole medical control, or primary medical control over the baby. Right? So now he's already got some control. She can't do anything without him on the medical stuff, right? Of course she's worried. Of course, because she wants that baby and she'll do whatever she can do to keep it, her. And I wouldn't put anything in the fact that she didn't confess on her phone, that she didn't tell somebody that she had shot him one way or the other. She didn't even tell her mama. Her mother would have you believe that in all these years, she's never said something to you. You think she's going to put it on her phone? No, she's smarter than that. If that's true, she's certainly not going to put it on her phone. And just because you search up how to co-parent with an abuser doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody.
Well, I think you could argue he is an abuser because he's clearly a fucking lunatic. To argue, this is where you can't argue he's not an abuser. You have to argue that that moment he wasn't being an abuser. But to argue he's not an abuser at all, honey, fucking flip the script and you'd be rubbing your pussy raw over this.
Custody or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. And she's trying to manipulate you. You can decide what you think about her testimony. She's a witness like any other. But I would submit to you that was all manipulation. There were no tears. You use your common sense. If you cry, have to take breaks, and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's tissues. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes. Didn't need a tissue. That's manipulation. That's her efforts to manipulate you to make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. And reasonable doubt, I would ask you to read your instructions because that board they put up was an incomplete instruction. It left out parts. And the part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the 2nd degree with a firearm. Thank you. Thank you, Judge.
All right, can you go back to your instructions? And if you remember, we left off at 3.10. And we're going to ask when you find that, you just look up at me and I'll know we're all on the same page.
All right, we're skipping this. Okay, we're skipping this part because I don't need to hear him talk. And there we go.
I wish to advise you of some very special privileges enjoyed by jurors. The law gives you a unique privilege not to speak with anyone about the jury's work. Although you are at liberty to speak with anyone about your jury service, you are also at liberty to refuse to speak with anyone. It will be up to you to decide whether to preserve your privacy as a juror or not. With that said, again, I offer my heartfelt thanks on behalf of myself and the other judges of the 12th Circuit, all of the court administration, and for all the citizens of the 12th Circuit for being part of this process. I now discharge you as jurors in this case and release you from any further obligations in this matter. If any of you would like to be escorted to your vehicles, all you have to do is let this deputy know, and he will make sure that you are walked all the way to your vehicle until you leave. Thank you again very much.
Thank you, sir.
All right, you all can have a seat.
Your Honor, if I may, what's the 12th Circuit's position about approaching alternate jurors?
All right, guys. So it's done. It's in the jury's hands. Let's they had it for, let's see if when they came back. Looks like it ended on a looks like it ended there 4 hours they've had it. So it ended for the day, and they have 4 hours of deliberation down. Will they frame their certificates? Oh, Dolly says they're still deliberating. Really? Are they still going? Hold on here. We'll pull up Law and Crime, see if they got the clicker going. Surprised they have. No, those... no opening arguments were impressive, but geez, that was... I just wasn't impressed by anything there. The defense kind of brought it home after a while once it got to the charts, but if you are the state, like you making the argument, and I've had to explain this to clients before. When it comes to the issue of, well, I hit him and there wasn't marks on the person. Well, how does that work? Not everybody getting punched leaves a mark, and it doesn't always leave the same mark for everybody. I mean, because you're gonna find a jurist like, yeah, I know. Like, I remember it's like my buddy got fucking hit by something and not a mark on him. So I'm just trying to say, like, some of these things the state brought up, like, those are easily refutable points. Everybody's fucking different. All kinds of things could have happened. And just running up there screaming that she's a fucking lying whore. I mean, you sound like a defense attorney at that point. Like, I would never do that. I would not be doing that as the prosecutor. And then to say, oh, he's not an abuser. He is. Now, you can make the argument he wasn't abusing that night. Sure. I think that's a fair argument to make. But to run around and scream he's not an abuser, well, not scream, but you guys get my point. Oh, he's not an abuser. It's like, what? Like, come on. Is anybody going to fucking believe you? Because that's not going to encourage me to believe you. Like, really? Like, I'm not. And I think some of you guys do. Even if you guys are, on team guilty, like, how does that work? How do you square those circles when you start making claims like that? Yes, they sound like defense attorneys and they're really fucking bad at it. I agree. Yes, and people are not one-dimensional, I understand. But I'm just saying that was you could say that night he wasn't acting as the abuser. And you know what? I think that's a fair argument to make. And that Ashley knew about all this. She was gaming the system and she set him up. Cool. But to sound like, oh, poor little Doug, he didn't know what was going on. He's just a poor nice boy, and oh Lord, and me. I'm like, no, you can't do that. If I'm the prosecutor, you don't have to like Doug Benefield. You don't have to like him. You don't have to like the choices he's made in his life. And you could say, I would never do that in a million years. I know that you wouldn't. And I hope as a society, most of us wouldn't do what he did in his life. But that was in the past. And his past does not mean she gets to kill him. You see how that sounds? I'm not hiding anything. I'll accept what he is, and I'll run for it. I doubt he expected to die that night. I'm sure. And Stabby, you're saying that dude isn't on trial though, but he is. It's self-defense, so the victim's now on trial. It's a self-defense case. The victim is now on trial. Doug made me do it. If Doug hadn't done what he done, I wouldn't have done it. I wouldn't have killed him. Victim's on trial now. But this is where you have to bite the bullet. You have to bite the bullet and accept what happened there. I'm just saying there's ways you could do this where you're not just pretending like, oh, he's not, remember, you can't play the Dindu card. Oh, he's a nice boy. He didn't do nothing wrong. Like, no, he wasn't a nice boy. He did a lot of shit wrong, just not that night. Own it. Don't try to bullshit them. That never works. That never works. Chaucerian Fraud said, what did Doug do that we can prove? Well, he admitted to beating the dogs, beating the cats, shooting a gun, throwing a gun, being overall just a crazy fucking loon, trying to buy the house right behind her when there's a protection order. So, yeah, we can prove a lot of things. It's just those things are older in time. But like I said, that's where the prosecutor goes, you don't have to like him. He still has rights. And one of those rights is not to be murdered. Not to be murdered in cold blood by his abusive and manipulative wife. That's the right Doug Benefield had. And then you go into why Ashley's a manipulator. But you own the issues with your client. That's how I would do it. Q says, like and subscribe. Thank you. I appreciate it. Doug bit multiple bullets. Yeah, you bit him with his chest cavity. Eric says, can you refuse to speak with the judge? Who and what kind of context? I'm not sure. Chastain Fraud says, I'm talking about the night of the murder. Yeah, I mean, it could very easily be that way. Dolly gifted 5 memberships. Thank you, Dolly. Do protection orders cross state lines? Typically, yes. The full faith and credit clause generally guarantees that they cross state lines or are effective. Although there are going to be times where there's going to be one state doesn't recognize it because it apparently wasn't done on the up and up, or there's just going to be issues. But generally speaking, if you have a protection order against somebody, you can carry that along with you as you go. Brian says she also has the right to protect herself. I get that. I'm just trying to explain to you, if I was the prosecutor, how would I do it? Because they didn't do that right way. That was horrible. That was absolute garbage. Oh, yes, I will not forget. But anyways, we got to catch up on some things here. So Adam is saying, Sean, do you think she will get a lesser charge? So it looks like manslaughter is on one of the options available. Amateur Iconoclast gifted 5 memberships. Thank you. Eric Rowland said, I would give her a pass with a very stern look. Give her a blue steel. Jasper says, use the code, check your notes for free Clyde coin. Oh, if only there were free Clyde coins out there, chat. They're all used up, though. Nicholas Kreuzer says, and with Doug's final breath, he looked over and punched the dog one last time and said, I'm super guilty. Shit. What are your Avid saying? What are my thoughts to all the prosecutor objections? The one point where he argued about a fact, not an evidence, that's fine. But she objected a lot. And I mean, if you're the prosecutor, like, your case should be good enough. You could have the defense attorney spew some shit and it probably ain't going to hurt you. I don't know, though. I don't know. I was not fond of how they did that. I think the way they did Cross was really bad. Like, I'd be very fucking angry about that. And Camp Patrick says, just because Sean wasn't wearing his conductor set at the dinner table that night doesn't mean he's not a foamer. It's a very true statement. Now, there's some other ones we didn't get to here. Been there, done that. Been a member for 5 months. Says, who in chat can fix this? Who in chat can fix this woman? Yes! Fix her like Janelle. And then Skeeve Man for £5 sterling. The King Sterling. Although if he's in Scotland, that might burn his ass that the king is there. So, sorry. Yes, there's rarely criminal trespass in Scotland or in, I think, in most of the British Isles. I even think in England, it's you have the right to roam. And that's an issue. And that's because all the land is owned. So you have the right to travel around land and hop over fences as long as you're not doing anything. And that makes sense. And that makes sense for land because there is no open land. It's all been owned for, 2,000 years. And then Sky is a neighborhood for £5 sterling. The King Sterling is saying, we don't have a stand your grounds as casual doctrine. Self-defense is considered only what is reasonable and necessary to the situation. Thank you. It's interesting. Yes, and that's the problem, because you do see people in Britain defend themselves and defend their homes, and they still get charged. It does happen. So, and I don't envy people there. Yes, and Eric Rollins is a new member. Thank you, Eric. Mercada can fix her. Max Murrah says, Black Swans meta. Hi, Max. The jury question was interesting. Eric Thor says, okay, I see your point. Well, thank you. I'm glad. Like I said, I'm not trying to hammer on it. Joke goes Zoom. Well, never said I was smart. Big thing here. That's the thing. Never said I was smart. Let's see here. The Chevron overhaul for protection orders. There's no really an issue with protection orders. It's nothing like that. And that's more of on a state-by-state basis. Check your notes is crazy. Did I miss something? Was there a jury question in there, chat? If there was, we'll go back and check it out. Hold on here. If there was a jury question, we need to go back to it here. Hold on. All right, so where's the jury question? I don't see a jury question anywhere. Oh, something popped on. Oh, they're putting comments on screen. Oh, here we go. All right, so let me see what I don't know what this question is, guys. I didn't know there was a question here. Okay, here we go. All right, here we go. Okay, we got it, guys. Oh shit. Hold on, I gotta share with you guys here. Hold on.
Super controlling.
There we go. All right, for you guys.
And I'm going to read the question, and if either side wants to approach and look at it yourselves, you sure can. I'm going to read it as it is. Dr. Quintella testimony. Defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine? Anybody want to be heard first?
Any particular order?
No, sir.
I understand the question. What's the court's inquiry?
How do you, I'm listening for, I mean, I know in my mind how I think I'm going to respond, but I'm always going to give the parties an opportunity to be heard on that.
Sure. I think they should have Dr. Quintel's testimony read back to them. Specifically because I asked Dr. Quintel if he reached any conclusions as a result of meeting and evaluating Douglas Benefield. And those were the conclusions that Dr. Quintel said he reached. It had nothing to do with my asking him if it was based upon anything Ashley Benefield told him. And I think unless that message is sent, unless that's clear to them, then I think it's a terrible prejudice to the defense.
I'm sorry, what's the prejudice to the defense?
What's the question?
No, what was the prejudice to the defense? If what happened?
Prejudice to the defense is that they're being misled.
If we do what?
If we do not read back their testimony, read back his testimony. That way it doesn't have to be the lawyer's comments, it's the testimony of the witness, it's objective.
Judge, I think there are a couple options. One is the standard use your memory. I don't know if the court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
All right, any final thoughts?
This judge does not want
They
to.
clearly are not asking for a read back.
Yeah, I was gonna say they're not asking for a transcript, and this judge is like, I am not fucking reading this. I'm not having this shit read back to him verbatim. He's like, ain't no way I'm fucking doing that.
They're asking a factual question. And I would direct both sides.
You're gonna have to rely on, your notes and your recollection. Got to rely on your recollections of the events, what was said, especially because this is a factual issue.
To standard jury instructions 4.3 and 4.4. 4.3 addresses answers to juror inquiries during deliberations. 4.4 is request for readback or playback or transcript of testimony. We've all done this long enough. This is not a request for a readback. If they want to read back, they say we want to read back. They ask for testimony. It happens all the time. So at this point, the appropriate response is going to come from 4.3.
What kinds of data? Wonderful. Wow. Okay, now we're- Judge, my concern, Your Honor, is that we're just assuming they know that they can ask for a readback. And I don't know that that's a fair assumption.
In your 400 trials, when
Okay. I don't even know I don't even know what the judge is going to say here, but I think I do. He's like, in your 400 trials, have you ever provided the jury with like extra stuff? No, you can't tell them that. Oh, by the way, if you guys want more shit, here you go. No, you don't do that. It doesn't work that way. That's not how this works. I love how this judge, he's going to fucking dress him down here. Here we go.
I don't know that that's a fair assumption.
In your 400 trials, when have you ever given when has a judge ever given an instruction? Hey, by the way, you could ask for a readback.
No,
No, I haven't either.
no, but I don't know if they know that, and the question may be
That's so
inarticulate. That maybe you could ask for a clarification of the question.
Your Honor, Judge, we don't object to 4.3. We ask that you.
I'm sorry?
We agree 4.3 is the right.
Yeah, that's the
Thank
correct
you.
response.
Yeah, if you needed us to agree, we do.
Okay. No, it's not even a debate. That's the correct response as far as I'm concerned.
Yes. 400 tiles, answer them. I don't understand this part here. I don't understand why he's like typing it out. I've had other judges where they're just like, yeah, and they write it out. See, he's like Jordy. He angrily types. Now you just need to start yelling at the screen. He's mad everybody stream sniping him. This judge is a dick. Mine would have been like, nice try, counsel. No, I've been in front of a lot of judges who would have been like, I've been in front of a couple of judges who have been like, have you ever heard of like, how many trials have you been in, Mr. Martin? I've been like, enough. Okay, how many trials do you think I've been in? The judge say, how many trials do you think I've been in? A ton. You think I've ever heard of this? No. He's like, I've been doing this for 30 years. Do you think I've ever heard any judge ever saying this? No. Judge White, I can't take this shit no more. So do you think shops have days since accident? Ashley has a 13 days till next marriage if she meets someone. Yes, I think so. I think so. Yes, he's gonna punch the monitor like Jordan. And the thing is, guys, and here's the thing. I fucking like Wings Redemption. Wings overall is a funny guy, I think. You know, he owns up his shit, comparatively speaking.
The attorney. 4.3. Members of the jury, I have discussed your note with the attorneys. You have asked the following question, and then I'll read it. If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it.
No objection.
Object.
Object for the same reasons that you want me to affirmatively offer a readback.
Yeah,
Okay.
just so we're clear, I think that what created that question was the plethora of misrepresentations that the state delivered to them in the closing argument, and that's the reason why they've asked that question.
You know what?
Tell me his name. It's not Quintella.
Quintel,
No.
Quintal,
Can tell.
Quin.
Like William Tell can tell.
Okay, thank you. Because like a quinella is a bet at the track, isn't it?
I think so.
I think that's what they're.
Daily double.
It's like me trying to call the other witness the wrong name the whole time.
Keyless.
All right, Madam Clerk, I'm going to have to send this to you because I don't have a printer. Yeah, I'm sure they'll pop that on. So that's one. That's tough. Yeah, pop right on.
Come on, Judge.
Subject of food as well. Do you guys want me to broach the subject of food as well?
Yes. Yes.
Okay, Judge
Do you,
Jordy.
Judge?
Okay. 2924, Dr. Quintella testimony, defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine, signed one of the jurors? If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. Also, I don't want to know what's been discussed. However, it's getting to be almost 6 o'clock. If you want us to order food, it is not, it's not steak and lobster. But we can order some pizzas and get some sodas and have them and brought to the room. If you want that to happen, also send a note through the deck.
I mean, you guys are on the coast.
All right, you may
This is
retire
the
to
Gulf
continue
Coast.
your deliberation.
You're in the Gulf Coast of Florida. You guys should be able to get some good shit. I'm just saying. All right, so we heard that question. Yeah, like that was, this attorney is fucking something else. So as of 8:26 p.m., they're still going, guys. Oh, they're still going, chat. They're still going. Look at them go. That's impressive. That is impressive. They're still going. Yeah, what the fuck? Lobster should be cheap as hell. I mean, go out and spearfish it. Yeah, 420 blaze. Yeah, 430 now, but I'm surprised he's keeping him there that late. Like, they want to keep going. They don't want to come back. Yeah, I think they must be close. I wonder if they're done or getting close to being done. We'll hang out for a bit here. But you guys had some other questions, some comments here. Eric is saying the judge said the jury could choose not to speak the trial about anyone. Can they choose not to speak to him? Yes. You mean after like if they give a verdict and the judge comes in the back? Yeah, they don't have to say shit to anybody. Remember, you all have the right to remain silent. Nobody can compel speech from you. You don't have to say shit to the judge. Judge is like, do you guys have any questions? Nope. He's like, can I ask you questions? And you could say nope. And that's it. He can't, you don't have to talk to him either. That's a very good question. I was wondering, I thought that's what you might be asking, but I wanted to hear it to make sure. Bass for 199 says 400 tiles, Sean. Answer the tiles, Sean. Yes. I have not had full, I've had probably like now probably like 175 trials if you count. Well, actually, hold on. Probably close to 200 if you count all the, no, probably 175 if you count all the misdemeanor stuff, the PD stuff. So yeah, I probably had like, Skeevy Man says the jury's next question is grounds. Yes. For £2 sterling, the King Sterling. And I know Skeevy Man agrees as a fellow as a Scot. Long live the king. People keep asking. Okay, that lady in the purple with the short hair is Alice LaViolette, a DV expert from Jodi Arias. Wow. Ooh. That's interesting. Matt B says those are rookie numbers. I'd like to have more, but you know what? You can't force trials to happen. They have to happen on their own. Otherwise, you're not doing something right by your clients. That's a shame says, what's the latest you waited for a verdict? Well, thank you for the super chat. I appreciate the support. There was one, like the one place I was a prosecutor at, the judge would let people go like late. And I waited, he sent people home. It was like 8:30 and he finally sent everybody home because he asked and they're like, oh, we're close. And then it was like 8:30, he brought him back in. Like, how close? This was like at 7. They're like, oh, we're really close. He's like, okay, fine. 8:30 rolls around. He's like, how close are you guys? And they're like, well, and he's like, we'll try again in the morning. Now, that said, in that same office, one of my colleagues, she had a trial and it was like 7 o'clock. And like, we were all hanging out with her, giving her like kind of some moral support and everything. And it was like, it got to be like 7 o'clock. Actually, hold on. No. It was like 6:45. And I'm like, I'm going to go home real quick. I got to make sure my house didn't burn down. Like, I had to switch over my laundry and stuff. And I lived like right in town. She lived like, everybody else lived kind of far away. But I lived like 2 minutes away, the house I was renting. So I said, like, I'm going to go. Like, do you guys want, like, and they said, like, I went out and, I changed into like jeans and a t-shirt and they, oh, hold on, guys. Hold on here. What the hell? That was fucking weird. Okay. I'm going to restart this. So, like, they ended up, like, ordering food, and I came back, and I was sitting there with jeans and a t-shirt on, and we came back, and they were out till, like, 9 o'clock, but they came back with a verdict that day. They came back, it was, like, 9 o'clock, so that was as late as I've ever really seen. Anna Well says, are most of those misdemeanor stuff... Oh, most of that misdemeanor stuff is, like, bench trials. I've probably had 30 or 40 misdemeanor trials at this point. Like with a jury, and then for felony stuff, I think now at this point it's like I have them all listed somewhere in my I have a file with everything listed, and I updated it, but I think it's like I'm at like 33, I think, total felony trials. Like that, so I mean, it's not a lot. I mean, it's a couple a year. But that said, though, I mean, remember we had COVID, and there was like a 2-year time window where like nothing went to trial. So, I mean, I probably have even more if that hadn't happened. Spets saying, what's the situation happened in Mali? It looks like the Ukrainian intelligence special forces guys helped some Tuareg rebels kill a bunch of Russian mercenaries. Which, hey, like you'd think they'd be in Ukraine helping them fight the fucking war, because I don't see how killing these Russians in the Sahel region helps. But hey, whatever. There was a head that walked by. Yeah, but that doesn't mean anything. Yeah, Sarah Boone's looking for a new lawyer. Am I looking to boost my numbers? Thing is, I don't think Sarah would like how I'd handle her, because I really would have the come to Jesus speech. And as I say, it's the listen here, motherfucker speech sometimes. Especially with new attorneys. Because I've been brought along like with newer attorneys, because when I was a new attorney, I had to do this. You did what was called, you got a gray hair opinion. And it sounds funny when you say it like that, because I already had a lot of gray hair. But you bring in somebody who's older, you're like, look, man, I've been an attorney 25 years. And like, you don't have a fuck case. You bring in the gray hair with you to come tell them like they're being retarded. Listen to your client, listen to your attorney. Your attorney's giving you good advice. And there were times where there's some attorneys that, they said, like, if you ever need a gray hair opinion, let me know. And there were like 3 or 4 times when I first started, I had to go do the gray hair opinion thing. You walk in the county jail, and you schedule it out with that other attorney. You make your schedule work with theirs. Usually when they're going to see their clients, hey man, can you help me with this? I got an appointed case and the guy's acting crazy. And you bring him in. It's like, hey, this attorney's been hanging out. Show me everything that's going on. And he's, and he sits there and tells them like, yeah, you're toast. So it does happen. They're not back. See, here's the thing, Matt. This doesn't work because I wish I could. Hold on. Can I show you guys this screen? Stop sharing. No. I'm going to have to take like a screenshot, I think. So here is what I see. And there's a little window that shows the screen that's been minimized and covered up. So I can see it. I can see it right now. And I know it's not there. So you're going to have to try really hard to pull that one over on me, because I can totally see it. And I don't know if I can bring this up in a way you guys can look at it. But let's see here. Wait, I think this will work. Present. Stop screen. Present. Share screen. Window. To the window. To the wall. So this is what I'm looking at. And, way down here, this right here, that I've got it going so I can see what's going on. So nice try. Nice try. You get points, but I can tell. And now I had to bring them back. They're here. Let's see. What else are you guys talking about? What's going on in your house? No, that was a phone. Like I got a weird phone message and I was trying to like accept it and it wouldn't work it. Matt says, any murders? I've done murders. I've never done one as a first chair by myself, but I've been second chairing on a couple of murders. So never on my own though. In this case I just had, this was like my, this one was going to go all the way. It was an aggravated murder trial. We were about to box it up, man, and go all the way. Like, we actually had a fairly good argument that he didn't do it. And we were about ready to do it. But they came to us with what my guy wanted, and he accepted it. Did Aaron send me Kayla's pics? No. Still don't understand, is it really revenge porn when you're running like a swinger co-op? I don't understand how that works. And I don't even know if it's best to call it a co-op. Luke says, are you going to read Sarah Boone's motions? We will. And I think we will. I don't know if we're going to do those right now or not. Imagine getting lectured by Sean. I know. Imagine. Anyways, Hella, how are you doing as well? I know I said hi to Dolly earlier, but hope you're doing well. Sean represented, but only if he's permitted to slap her during trial. Yeah, I don't know. Neo says, was my hair always gray? Yes, but my hair was black. So after a while, it was like little strands of gray. And when I first passed the bar, I still had a lot of black hair. So it wasn't very good. That's Shame says, or a penis opinion. Yes, I've heard of that one also. Believe it or not, that does happen too, where a female attorney, especially a young one, has to bring in a penis opinion. So, but that's one thing I do feel bad about female attorneys having to deal with when they're young. When they get older, guys tend to listen to them more. But yes, you're not lying. The judge is not back, like I said. Are they deliberating right now? Yes, they are. Clock's still running. Can we see the train pictures in your glasses? No, you can't. Oh, you were talking about the TV burglar. I don't know, guys. That whole thing was fucking weird just now. Like I said, I'm sitting here and I could hear the TV running and I'm like, no one's home. Like, I guess we're gassing up the shorty and seeing what happens. Kino Casino is going to be spicy as fuck tonight. Yes, it will be. Yeah, I don't know. Did they cover the whole issue of Nick kind of admitting that his kid got like cocaine smoke in her hair? It's like, so now you're like, people are smoking crack around your kids and smoking coke? Like, that's not really better. KL says, this thing was a former client passing my house in Universal Remote. You wouldn't be able to access the windows to my house. Well, from the road that I'm on, you couldn't hit the TV. And if you try to do it from the backside, you would have to get into one of my neighbor's yards. So I don't think that would have worked. Sierra Rose says, when did you decide to become a lawyer? Every fucking day I ask myself that question, and I don't remember. Eric says, judge asks, how do you find and charge blah, blah, blah. And the jury reminds the judge, we don't have to speak to you about this. I mean, they wrote it down so they could hand it to the clerk and make the clerk read it. I will read, you know what, we'll do the Sarah Boone motions. Oh, you guys are already talking about them too, yeah. Stasia says, hello, I'm 40 years man from Somalia. Sorry for my bad, England. Oh. I can send you the motions. No, I have Sarah's motion. Like all in one thing. Sweet Tooth says, have you ever been considered to be an adjunct professor in a law school? No. I don't think I'd ever be considered for a law school. I mean, the only one around here is Cleveland State anyway. So I think it'd be fun to teach a little bit here and there. I really do. I mean, believe it or not, and this is something I talked to 2.0 about once a long time ago. Is at some point, because I don't always, there are days where I'm working at home, and there's days where I don't have things scheduled, and like I have work to do those days. But I was thinking at some point, like trying to like substitute teach. Kind of curious to see how that would go. So. Long Crime says court starting soon. Well, it's like it's saying not. Well, hold on. We'll back out. We'll read chat. Let's see what their chat says. Not guilty. 51% guilty. Oh, come on now. Dismiss. What's our live chat? They got 5,000 people watching. Okay. Yeah, it doesn't look like there's anything set yet, guys. Holy shit, I was Asian. No slapping in front of a jury. Well, accidentally. I thought there was a bug there. Why is my long crime ahead of yours? I don't know. Have you run a train before? No comment. Yes, Ken, I was more of making a joke that if they're all running around fucking and sucking and doing whatever, I'm sure they all have each other's naked pictures. It's just, if this is the point of what we're trying to do, it just shows you how desperate people are getting. Oh, that is in the title for the night? Nick smoking crack or freebasing cocaine? James Oland. I don't know, but Nick said, hey, another way people can get cocaine residue in their hair follicles is if somebody's out there smoking cocaine, which means either they're freebasing cocaine or smoking crack. And that's a really weird thing for Nick to want to fucking admit or even fucking bring up, that his kid was around people that were smoking fucking cocaine or crack. So unless he's going to accuse the cops of like blowing crack smoke in the kid's hair, which that's still all bullshit. It's all bullshit. But once again, Nick is saying fucking things that don't help him and only make it worse. Justin says he means crackers if you're basing it. Here's the thing. It's not clear. Nick brought it all up as a hypothetical, but why'd you have to bring up that hypothetical? And then I will point out that somebody on the farms did bring up Nick had all those Pyrex glasses there, and he could have, smoked up the coke and got it rendered down like doing a double boiler method. So I don't know what happened, but it's not, stuff ain't adding up. Now, here's the thing. There weren't any pipes. There wasn't any foil laying around. They didn't have like chore boy. So I don't think Nick was smoking crack, but something's weird happening. This guy's a neighbor says you already teach. Yeah, but I appreciate that. But no, I think it'd be kind of fun. Especially like history class. I think that'd be a lot of fun. Lois says you'd be a good teacher. Maybe. I don't know. I could be an adjunct professor for the Ohio State University. Not in a million fucking years. Not in a million fucking years. I'd rather go teach at Kent State than fucking Ohio State. Just Joyce says you'd be a great teacher. I'm not too sure about that, but I appreciate the thought. Stacy says in a public school? Well, yeah. I mean, like, I'm not going to be able to go teach at yeshiva. Yes. Volunteer at your local homeschool co-op and teach the Constitution course. Yeah, maybe I will. Teaching is fun, but I'm math. Yeah. So, is the verdict in, or are we still deliberating? It's still going. It's still going. You can't yell at the children. I don't know if that's true. I'll have to find out when I walk in there and I fill out the forms. Like, how much can I yell at the kids? A little bit? Okay. As long as I can do something. I teach here. Yeah, I know you guys learn a lot, but still, I'd like to, try it. I'm 20 seconds delayed, you guys. I mean, it's live here. Nikki the Rail King, yes. Yes. Yeah. Nick Recanus and I could freebase cocaine around children. He said it was legal. Stacy says I know too much. About what? Can we get CLEs for your streams? No. No, sadly you can't. Let's see. But you have to research and write papers and books and shit. Not to be like an adjunct. I wouldn't want to be like a university professor. Fuck that. Like, that's the difference here. Okay. Bella says if Gino showed it to Keanu, then he gets a revenge porn charge. The thing is, though, probably like they live in New York, don't they? I don't think it matters there. I don't think it counts. Besides, like, the whole thing's fucking weird. Anyway, let's go over this. Let's go over Sarah Boone, because it is very interesting what happened to our girl. America's sweetheart Sarah Boone has dropped some hot motions today. Sean know how to use Oxford commas, yes. Robin Lane says, what is my alma mater? Oh, there's two of them. I mean, technically. And my alma mater is Bowling Green State University, located in beautiful Bowling Green, Ohio. Go Falcons. Caw-caw. Now, not Bowling Green, Ohio, not Bowling Green, Kentucky. That's home of the Western Kentucky Hilltoppers. My law school, I went to the University of Toledo, just up the road. And yes, a lot of you are going to be like, isn't that kind of a shit tier school? Probably it is. And I don't know if it is right now, but yeah. Better than Cooley. Skeevy Man says, for £5 sterling. The King sterling. The King shillings. Like 100 shillings in a pound. Says, my art teacher at high school used to pick his nose and flick it. He also threw chairs around class. Wild times. No, but I will say, our art teacher, when we were like in junior high, Mr. Sandelbach, it's sad because he got cancer. Like, and from what I understood, like it kind of caught him like off guard. Like they didn't find it right away, so it really tore him apart. Really fucking sad. But he was a really good art teacher. He didn't throw chairs and stuff like that. He was just like, this dude who like he went to Ohio University, I think, and he wrestled there and stuff. But no, he was just super cool about shit. Like, doing pottery, learning all about that, and glazing and firing. And then just like art education and art history. It was like really good. Really, really good. Especially because we were out in the middle of fucking Hee-Hawville and he's out there teaching us troglodytes, some pretty good stuff. It was, helped culture a lot of people. Mine was just clip for faggotry. That's fine. You're going to be clipping for fucking forever, dude. I'm just saying. Was I a Freed or a Freddie Falcon man? Of course I was a Freddie Falcon man. Did they do bowling on the green? No, they did not. Toledo should be returned to Michigan. At this point now, that probably wouldn't be a bad idea for Ohio. Yes, the streets are where I got that's my real alma mater. I know. Growing up on the east side of town as a kid, it was rough. Sneed, of course. It's never a bad time for Sneed. That's a shame. Says the girl who inspired me to go to law school and became a PD, my favorite judge, my last boss. Well, I know David's here, and I think David said he went to Cooley. That's why I was making fun of it. My last boss and the only murder qualified deputy in my office went to Cooley. Yeah. No, there's nothing wrong with Cooley. I mean, all these schools, like, they all teach the same law. It's not like you get to Harvard and it's like, okay, guys, listen, here's the real shit. Like, you learn the same things everywhere. And believe it or not, a lot of your professors went to better schools than the ones they're teaching at. Trayvon Washington says even RoboCop gave up on Toledo. That's pretty fair. I gave up on Toledo. I got the fuck out of there. Sniping Kino Casino, they just started talking. Yeah, we'll get Sarah Boone done first. So here we go. Yeah, it's about the connections. Yeah, but here's the thing: if you go to a local law school, you're going to get some connections anyway. So it just depends on what you want to do with your connections. If you want to stay, like, if you're in Ohio, going to Akron, going to Toledo, going to Cleveland State, going to Capital, going to OSU, going to Dayton, going to Chase down there in Northern Kentucky, going to Cincinnati. All those are acceptable to be here in Ohio. And if you're going to Cincinnati, it's acceptable to be in that Indiana, Kentucky region. For Toledo, it's acceptable to be up in Michigan. Like, if you're like in an area, that's all that really matters. Like, I mean, most attorneys go to the small schools and, the other schools out there. I mean, even Akron is not a bad school. So, well, anyways, here we go. Let's get to Sarah Boone real quick. Let's get through these because these are ridiculous. And then we'll check on Kino Casino and see how they're doing. So this is Sarah Boone. She's saying a temporary motion for reservation. Reservation and proposed cost to acquire investigator for a defendant's defense and trial, which is funny because she's already got the freaking PI working. Although, I mean, to be fair, that guy's wasting his time making copies. So now comes Sarah Boone, pro se, indigent defendant. Respectfully request from this court the reservation and proposed cost to acquire investigator for her defense at trial. I don't know who I want. I don't know how much they're going to need. How to calculate, unknown by defendant. Reason, no discovery or case materials provided to defendant from the judge. Now, that is something. This is really fucking her up. And I think this is going to be a problem potentially for the judge. Why doesn't she have fucking documents now? Like, she has, like, this is actually prejudicial. This is a problem. I think this is a problem. Especially if she doesn't get everything she needs, I could see this being an appealable issue. And this is something I'd like to ask Peter Tragos, because I guess he actually knows Judge Kranick or is familiar with them or has some interaction with them before. But this is something I like, and I'd love to hear his take on it. This is, and hopefully one of you guys could be like, hey, Sean said this, is he a retard? I actually think this is bad. At some point, he has to make it so, oh, God. Yeah. There you go, share screen. I see you guys. Yeah. Uhuru on screen. Yeah, there we go. No, you can't see it. I mean, here's the thing. I just don't know in Florida. This is a big problem for me. Just she's not getting her stuff. Bring her a box of fucking documents. Like she has to have something. And this guy running it all through a high-speed scanner still. Like this, she said, okay, I'm ready to go. And now you're like, well, I'm making this drag out. So now you're on your own. It's like, I don't know if that's going to work. I don't think that turns out the way you wanted to, Judge. I certainly wouldn't be doing it this way if I were them. I'm just saying, chat. Like, And I think there's an issue with this. Hold on here, guys. And don't worry, I have Ashley Benefield going in my ear, so I'll hear it if we go forward. Okay. All right. So this motion is being submitted to meet the delegated due date. Is that delegated? I guess due date of 7/22/24 by the judge, and the court is stated in the defendant in the order dated 6/28/24. The defendant is trying to avoid any further persecution and penalization from the judge in court, while vigorously attempting to succeed in her forced position of pro se attorney and representation of self. The exceeded time limit of waiting to receive the defendant's discovery in case materials promised by the court has forced the submittal of this temporary motion. Once the defendant has finally received discovery, she will be able to proceed and revise and resubmit this motion upon completion. Now, here's what I would say if I was Sarah Boone in the meantime. Figure out who your investigator is going to be. Get one. Find out how much he's going to need. Like, how much do you think it's going to cost you? The other guy said he needed like $3 or $4 grand. Okay. Well, will that give you a lot of what you need? Sure. I think that's something she should have in here, like the names of these people. Here's who I want. I just don't know what I want them to look into. There it says, wherefore Sarah Boone, indigent, respectfully request to the honorable court to remove any and all costs, reserve any and all costs proposed to be incurred to acquire investigator for and in the defense of her criminal case for trial. The thing is, if she gets these starting like in a week or two, I think it's like August, 5th or 15th they come back. She's like 2 months out. It's going to take her a while to get the money approved by the Judicial Assignment Commission, the JAC. And then she has to pay that guy. Then he's got to do his work, and then he's got to give it to her. I don't know how that gets done in 2 months. The defendant's requests are in good faith, and her merits are worthy in striving to successfully, lawfully, and properly perform, act, and thrive. Thrive and overcome. It's like reading a Guardian report in a children's services case. He's been thriving. Her forced by the court position of pro se attorney and representation. It says conclusion. Temporary motion should be granted. Oath under the authority of Florida Section 925.25 and State v. Shearer. The defendant makes the following oath under penalties of perjury. I declare penalties of perjury that I have read the foregoing documents and matters stated are true. I don't understand why she's putting a. It's for an affidavit. You don't need to sign a motion under oath. But whatever. And they sent the certificate on to the judge and the prosecutor. So there you go. Completed and mailed July 18th. Okay. So we've got that one down. What are you guys saying here? Hold on. Luke is saying this was sent before the hearing, by the way, because the deadline for pretrial motions before the judge had organized a way for it to access discovery. Yeah, but even then, accessing it the way he has is really going to fucking set her back. Like, I think there's a problem there. I don't like how he's doing it. Give her fucking documents. Run that shit through a printer. The jail doesn't like it. Here's the thing. Sheriff's like, oh, I don't like this. Too fucking bad. Then put her out on fucking bond. Pick away, chat, pick away. Luke says, well, you can revise the swap and prison break man with his rate. No way he could say it's too much. Who knows? Who knows how much the other people charge? And she might not like the prison break guy. She might not find him trustworthy anymore. I don't know. Apparently, a Cellbrite is an issue in the Richard Allen case. That's not a surprise. Oh, let's see. Criminal rights are being shat on. I wouldn't say they're being shat on, but this judge is being a little ridiculous here and setting himself up for failure. Oh, I think she would run too right away. Well, it's like, then you better fucking get her discovery like right now and help her get what she needs. 5 hours, 5 minutes on the deliberations, guys. They're still going. Let me make sure we have sound up on that all the way. Yep. The sound is up. It's still going. All right. Motion number 2. Reservation for expert witnesses. So she wants expert witnesses to be determined. That's fair. She might not know who she wants or needs. Total amount requesting. I don't know. That one's fair too. And then this one again, how to figure it all out. Unknown. I don't know because I don't have my discovery. Fair enough. And once again, she's stating she's submitting this again because I don't blame her for doing this. She's trying to protect her ass. I think that's actually very clever of her. And reservation of all costs to acquire all witnesses for a defendant's defense at trial. Now, what's this here? Respects from this to acquire all witnesses needed for the defendant's defense at trial. The witnesses. I mean, is she saying like the subpoena? Because you don't have to pay for witnesses. You get them a fucking subpoena. You're not on the hook for the cost. Yeah, I don't see what she's saying here. Yeah, I don't get that one, but whatever. I mean, I'm a little confused. I just don't get it. Sarah, I don't know why we're I don't know why we're I don't get it. It's not very clear to me, but hey, maybe we'll figure it out at some point. Um so hold on here, chat. All right. All done. All done. See, I don't understand this one. This one I'm not sure. Does she want some paid expert witnesses? Well, she already just asked for the paid expert witnesses, so I don't know what she's trying to do there. I don't know how she's getting to that. So it doesn't make any sense to me. She's trying her best to file a motion. And all these motions are good. I like I said, she's trying her best to protect herself. I don't blame her. This is not bad. This is not a bad idea by a pro se. Now, it's an issue because she doesn't know what she needs. And she doesn't deserve to have a continuance because she doesn't know how, but she doesn't know how to file for it. Well, the judge said he'd deny it anyway. I think she knows how to ask for a continuance. I'm sure if she asked people in jail, they would help her figure that out. Chaucerian Fraud says, imagine denying their rights because you don't want to refill the printer's ink cartridge. Well, remember, the jail's like, she can't have all this paper. It's a liability because she's in a pod. It's like, then I guess she goes into fucking seg. And I'm sure she would trade that off at this point. I just saw a Defense Diary Bob Mata post about it. He's in Delphi right now. Yeah, I need to get in touch with Bob and see how that went. Because I forgot he was down there today. Bob's a really good guy. So is Allie. Beware scammer text messages. Yes. At least you stay within the margins. Yes, that's very good. Michael Boyle says pay to serve witnesses. You don't have to pay to serve witnesses when in a criminal case. No, here's some fucking subpoenas. Go like if I want to subpoena a witness, guess what? The subpoena goes out, and the cost for serving that subpoena gets sent back to the clerk, and that gets tacked on the court cost. So whoever loses pays. So like if the defendant gets acquitted, the prosecutor's office pays the court cost. But even then, like typically, like as a defense attorney here in Ohio, I can serve process on anybody within the state of Ohio. So generally, when I get subpoenas, I just serve them on the people I need to serve them on because I could do it right then and there, and I know they're done. Yes, Sarah needs to make her motion. I need to invite Bob on for an island update. I'm going to try to. I got to figure out. I know he's busy, so I got to get a hold of him. Bass says, I hope she wants a suitcase expert. And I hope she uses the word enclosed in motions as much as possible. Oh, no. Is she in a pod? Is she a whale? Can't even troll with correct English. Come on now. Excited Utterance says Tragos is so totally against Boone. I don't get it. Well, I'm against Sarah Boone too. Ultimately, she's going to prison. She ain't coming home. She murdered that guy. Like there is no viable defense for her. But I'm fine with having a lark and laughing about it. But Sarah Boone is toast. But I don't think Peter's really been like unfairly like oh fuck Sarah. I hope she trips on the stairs or anything like that. He's just Peter's just like I think she's a bad guy and you can say that. Sarah Boone is the bad guy. Yes. I call God as my witness. That's James says, I didn't even know that costs money. Well, the sheriff has to do it and they do mileage and they, the cost comes back and yeah. Because part of your court costs, you can really balloon them up if you have to like serve a ton of subpoenas. Luke says, battered spouse is easily a viable defense. I don't think so. I don't think they're going to get it. If you could suppress the video, I think not guilty, but I don't know if you're going to be able to suppress the video. Why was Sarah not charged with first degree? Because it wasn't clearly intentional. I think it was like something as the opportunity presented itself. She's like, oh, well, fuck it. Now I can kill him. I mean, it's more likely because they're drunk and acting like idiots. Oh, yeah, I agree, Hella, though. Yes, just because she's being going to prison doesn't mean she should be fed to the lions. I agree with that. I totally agree with that part. I think we're on the same page. We're on the same page. We're trying here. And they're still fucking going, chat. Wow. They're still going. And going and going and going. So let's see here. Trying to figure out where we are. Sorry, I'm gonna move everything around. The judge basically blamed the jail, acting like it's never had a pro se defendant. Yeah, and that's the thing, though. I mean, because there is a limit to what the judge could do. If the jail's like, we're not going to let you do it, there's only so much you can have. But at the very least, they've never had a pro se defendant like this, where she's going to have, volumes and volumes and volumes of garbage. It's one thing where you got a pro se defendant where they've got like a brownie full of papers or something. It's not that bad. This is something else. I guarantee you this is probably like at least 10 bankers boxes full of shit. Her big problem is, yeah, this requires notice of battered spouse 10 days prior to trial. So she needs to know how to file it. Yeah, and I think she's gonna get fucked on procedure, but you know what? All pro se's get fucked on procedure. That's why you don't pro se. That's why you don't pro se. That's why you don't, that's why you don't just that's why you don't just hop into an airplane. Like, yeah, anybody could keep it in the blue and out of the brown, but landing it's the hard part. So see, Hill, I disagree. I think she has forfeited her right to counsel. Like, I think that's actually gonna hold up. And she is a fucking idiot. She's deserved the scorn and laughter she has. She treats her clients, she treats her attorneys like shit. She acts like she knows everything, and she acts like there's no other way this could be. I think she's got, I don't think it's just mental health issues. I think she's just a fucking insufferable person. So in Canada, they just euthanize her. Yeah. Do I do a cheeky and write her how to win? I mean, I can't tell you to touch. I don't recommend touching the cows, Luke. But if you want to, go for it. Yeah, I don't recommend it. Hella, yes, the Constitution is for everybody. But Sarah would keep doing this literally for fucking ever if she had her goal. Like, she'd spend the next 15 years doing this. That's a thing. I think Bankowitz was legitimately ineffective. I don't think so. I think the way Sarah's been complaining about everybody, she's being fucking ridiculous. So I think she deserves what she's got coming to her. Hella says, is there case law on this? Yeah, there's case law on that. You do review, if you keep acting like a cocksucker, eventually you lose the right to have an attorney. Because you keep rejecting them all. Well, you don't get to keep rejecting them forever. And that's the thing. Like, that's the other way to look at this. Let's just say she kept on saying, I don't like this one. I don't like this one. I don't like this one. You're not entitled to an attorney of your choice. Hell says, where is the 8 attorneys law? There is no cut and dried law. It's an issue where the judges have to, based on their experience, make a decision. And remember, 4 of them weren't really your fault, so it was really just 4 attorneys. But 4 attorneys is a lot to have, period. So, Nick is never going to get an attorney when he runs out of money. I mean, maybe. Maybe. So, she's lucky to have that many, yeah. I think so. He spent over a year on the case and did less than what Hobson did in a month. Sure. But I'm sure he's been in contact with her on a lot of things. Like, was he deficient? No. Was he the best? No. I just don't think he was ineffective assistance there. So, and even if he was, let's remove him from the equation. Having 3 attorneys is still a shitload too. And Cashman was all about that action, dude. Cashman was ready. Cashman stepped into the courtroom with her. And here's the thing. Cashman stepped into the courtroom with her fucking boots on, ready to fight. And Sarah fucked around there. So, what more of a fire-breathing, like, knight in shining armor you want than that? So, oh, he could see he was in contact with her. Yeah, well, so The state is still paying for Prison Break to help her, yes, but I can also understand her saying, like, the way this has gone, she doesn't like it anymore. And also, hold on here. Oh, no. The fucking Kino Casino is showing fucking Demon Mama. Oh my god, I feel bad for them. God, all those people having to learn about these, like, Destiny Orbiter fucking retards. Oof. We're not stream sniping that, guys. Any Richard Allen updates? They finished day one, and we're gonna work on that coming up, sellers. But I don't have enough right now to say anything. The hearings about the motions to dismiss and everything that happened are going on right now and happen today and tomorrow. So hopefully tomorrow there's even more. Is the jury still going? Yep. They're still going. Who's Demon Mama? A fucking Vosh Destiny Orbiter shit. It's horrible. No, we're not. It's so fucking cringe. And the Xanderthal bread tube commie killing each other thing. Yeah. Yeah, I'm doing, yeah. Probably a horse fucker too. Yeah, I mean, yeah, probably. Matt says, who's Richard Allen? Richard Allen is a guy out in Delphi, Indiana, who's accused of murdering 2 girls back in 2017. And it's a cold case murder at this point. And he's getting railroaded. Yes, Vosh was a Destiny Orbiter. And that's the funny thing. All this spawned out of Destiny. That's the oof. Yeah, guys, it is going on 9:30 here in Florida. And they're still going. So is this the same true as on the kill stream years ago? I don't think Demon Mom ever went on the kill stream. Ralph would fucking break her. Yeah, Demon Mama is technically a Vosh orbiter. Yes, you're right, but so let's see here. Say, wait, you're watching live right now, Pancake? Yeah, they're still live. Do you think that means you're getting close? I don't know. Maybe. Luke says, I still think my take on Popcorn Man is retarded. You know what? Which part's retarded? He used force and he was justified in force. But Popcorn Man, like, they were both fucking assholes. That's just my point. The jury's trying to get overtime pay. If it's a Demon Mama, he definitely went on there. Wow. I can't imagine that went well. I'm surprised Ralph didn't just fucking BTFO him. Demon Mama is the person right wingers think every terminally online person is. Well, Destiny and Vosh and Demon Mama are pretty much all the same person. So they got a 100 sub dono. Holy shit. Their subs are like $5 a piece too. Yeah. I will say that is funny though. So Xanderthal is a bread tuber, and somebody sent his political donation money. His manager set it to a wrong account. So that's funny. All the money he was getting paid got sent to a wrong bank account. Okay, see, here's the point, Luke. I don't think they walked up. It's like, please, sir, may you turn off that telephone? My wife, my missus and I were just trying to watch the new Nickelodeon. And then, ow, ow, ow! Stop hitting me, sir! I've done nothing wrong to transgress you. That's the point here. That's the point. Does my apartment office have the right to give my phone number to CPS? They did. I mean, it's probably if they want to. Jury question. I don't know if there's a jury question, chat, but we'll see. We'll see. We'll see. The jury wants lobster. Is it a lot closer to Oliver Twist and everyone's an asshole? Nah, maybe, but it's just like when people. Never mind. I'm not going to get into it. The jury wants to go freebasing cocaine. They're like, it'll make us focus more, Judge. We heard about it. It's like Nick Rekieta said we could do cocaine. It could easily be saying they want to go home. Dolly says, can we say that they were watching Lone Survivors the funniest thing? So they probably want to go home. Maybe this is late. This is really late, guys. And also remember, this is 5.5 hours in of deliberations. That's serious. Like, I mean, that's a lot of time. A lot of cases don't go this long. Up here we go. Here we go. Yo. What is the max hours the judge can make you stay? Well, I think that this point he would be. I don't think the judge can keep you like tonight. Like they have a right to go home, and I think this is a reasonable time. No later. So if it takes all night, they'll still find a way to make sure Eric July doesn't get away with it. I know. They'll be like, Your Honor, we sense Eric July to be guilty. Dolly says I have to go to bed. It's like 7:30 where you live right now, Dolly. He's like, oh fuck. No, that's not the. You thought it was the jury for a second. God, that would be really bad if that was. Yeah. What was the popcorn trial? That was Curtis Reeves. He was in a movie theater shooting. That was a long time ago now in history. That was like around Kyle Rittenhouse time, chat. That's back in the way before. We like covered bits and pieces of it. JRZ is saying the shooter in Florida would make the jurors stay all night long. Yeah, but I think it's in trouble. Oh, Dolly's saying it's 6:35. I get up at 4:30. Jeez! 4:30, man. There's a 4:30 in the morning? Wow. Jeez. All right. The camera's moving. That means we're getting ready. So Let's see. So let's see. Yeah, what's happening? Hold on here. Time to make the donuts. Yeah, that was the other thing too with the Curtis Reeves case. It happened in 2013 and they got to it in 2021. It was like really crazy. So yeah, Adam said I got the 4:30. You got to work. Jeez. Didn't mean to BK and AK. All right, here we go, guys. So yeah. The entire court waited for Reeves to die and he didn't. Well, that was the other thing too, guys. Curtis Reeves was like fucking in his 70s and like into his 80s by the time the trial happened. I'm getting up at 3:45. Fuck that. Sunshine says Judge got a nap in. Honestly, if I'm Judge, I'll probably take a fucking nap. So let's see here. The judge looks distraught. I don't know. We'll see. We'll see what the issue is. He looks mad or confused. Well, we'll see. So let's see. Let's see. All right, here come the prosecutors. Yes, Curtis Reeves' defense counsel, they were very, very, very good. They were very, very good. That was always a very good thing. His attorneys did a very good job. Here comes the defense team. Boom, 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 boom. Like a bow wow wows. Wait, is that guy wearing body armor? Is that a bodyguard? That guy's like he's like really overly bulked up.
All right, welcome back, everyone. We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I have another communication from the jury.
Another communication.
I'm going to read it verbatim, and then I'll hear from both sides. Unable to come to unanimous verdict. Signed, jury.
That's an easy one. It's been less than 6 hours. Keep working. But with this caveat, Your Honor, I think you should at least acknowledge to them, because I don't know that
Let him go home.
either out of politeness or a sense of intimidation, I don't know that they know they can ask if they can go home and come back in the morning.
Judge, and I think asking them about going home and coming back is definitely something that they also need to Allen charge before we make any decisions after that.
I didn't give an Allen charge after 6 hours.
Yeah, hold on. Just go ahead and say your piece.
Judge, I didn't realize that there was any hour attached to an Allen charge. I just thought that once they said they were deadlocked, that you give them the Allen charge. But it is almost 10 o'clock, so they may.
I mean, I'm surprised that the prosecutors want to do the Allen charge. They must think it's only one holdout for not guilty. If they're wrong, though, and they fucking do an Allen and they come back, we're still deadlocked. Tomorrow morning, the judge going to say, well, I guess we're done. Fuck y'all. That's a dangerous thing to do.
I'll go home and come back tomorrow.
All right, thank you both very much. As we all know, the Allen charge is a one-time thing.
Yeah.
So my inclination was to
Florida's
bring
a
them
one-
out, acknowledge that they've been working for
In Florida,
almost 6 hours.
in Florida, it's a one-shot thing, guys. You get one Allen charge, and that's it. So
Well over 5.5 hours. Acknowledge the time of the evening and give them that option. And I'm not going to ask for them to vote. The way I do this is I'll explain to them, you've been working. We acknowledge that it's late. If you want, you can go home for the evening, come back tomorrow, fresh, and continue your deliberations. I send them back to decide if that's what they want to do or not, and then go from there.
Yes.
Okay?
Okay.
All right, let's bring them out.
here's the thing, Chad. It's not wrong to say with that out. Like, here's the problem with the jury. They're like Sarah Boone. Like, they use words, but the thing is, what does that word mean? Did you use that word in a way that makes sense? I don't know if they did. Maybe they really are in a deadlock. It's somebody in there saying, fuck y'all, I'm not changing my mind. You guys can all eat my whole asshole. I ain't changing my position. Maybe they are deadlocked. We don't know.
Also,
Chris says, I didn't watch any of the trial. Is she guilty? Well,
right.
we might find out soon enough. DSP will mail them a spoon to eat ass. She's guilty, but not legally guilty yet.
Good.
So. Well, let's see. Well, yeah, I would be very fucking upset. I'd be on edge right now, too.
All right, y'all can have a seat. Welcome back. Members of the jury, I've received a note from you. It says unable to come to unanimous verdict. We all recognize that you've been working for almost 6 full hours, and it's getting late. It's almost 10 o'clock in the evening. I want you to go back, and there's an option that we can come back tomorrow and start fresh in the morning. I do have some court first thing in the morning, but we can get started same as every other day about 9 o'clock. So I'm going to ask you to step in the back and make a decision amongst yourselves if you'd like to come back tomorrow morning fresh to start.
Or there's no other option.
I need you to discuss that first, please. All right, you can all have a seat.
Yeah, this is absolutely terrifying for her at this point. And here's the thing, KL, it's not too early if they're truly deadlocked. It's not too early. It might be perfect. This might be the right time. We don't know. We'll find out. Let's see. Oh, Ava's not there. She's out probably partying it up. Where's she at? She didn't come back. Oh, yeah, you guys, they might be stuck. We don't want to come back tomorrow. We want to leave. Ah, that'd be hilarious. Ava's out making her TikToks. Yeah. T-shirts don't print themselves. So, hmm, so let's see here. That one lawyer just smiled his pits. Hold on, guys. So let's just, you know, it's a smelly time being in court, and it's intense. You sweat a lot. You know, like your socks are soaked. Just it's a very intense. It's intense for everybody. Hung jury means another trial. The prosecutor wants to bring it, right? Yes, but I don't know if they'll try this again. This was a tough one. This was a tough one. I don't know if they retry this. This is rough. This is tough. This is tough. I don't know if they retry it. Hmm. The Allen charge hasn't been used yet. And guys, the Allen charge is where you set the jury down and you tell them like you're deadlocked. You know that the Allen charge is look, no other jury can do this better than you. You are the best situated jury to hear this case. You need to pretend like there's no other jury in the world that could come in here and do it. If you guys are stuck on your positions, are you doing it because it's based on fact, or are you doing it accidentally out of you don't want to be seen as wrong? That's the Allen charge. It just encourages everybody to reconsider their positions and then go from there. So can they theoretically go all night? They could if they wanted to. I don't think they will. I think at some point the judge would shut them down for the night. Like if it got to like midnight, I think he'd shut them down. So um there is no Allen charge yet. He's gonna let them decide if they want to go home first. You can have a hung jury after 1 day deliberation, sure. 6 hours is a lot of time. Um the judge didn't explain that well. I don't know. I think they understood what he was getting at. Let him read the Alan Parsons charge. The judge tried to make me go all night. I would nap in the deliberation room. Oh, they would. They would. I guarantee it. Um, 6 more hours. Fuck that. That's worse. Do you think they need to be unanimous on going home? No. I think if one or two of them wants to go home, that's enough. Kale says, I'm just the judges saying, just keep trying. I agree. And that's normally what happens. Judges keep saying, keep trying. So, so. See, they're all hyped up on sugar from the pop. Yeah. Yeah. And Old Line Red, you're right. They might be entrenched by now, guys. When it comes to these simple cases, it's whether or not she was in fear and whether the fear was reasonable. That's it. That's it. That's it. I mean, you should have let him made a wop brisket. Oh my god. Yeah. That one man is using logic. And Michael Boyle says with self-defense, you can't really do a compromise. And if you really think not guilty, then you shouldn't compromise. Yeah, that's another issue. If you truly think you're righteous, then yeah, there is no compromising. And remember, I told you guys, I've had cases where, you know, you could tell it was 5:30 at night, and it's like, shit, I gotta get home. I got dinner. My wife's got out there. I got my kids. And juries will cut it short. It happens.
All right. The response from the
back.
jury is we will stay. Signed by a juror.
What? What? They're gonna stay?
So we'll be in recess until we get another question or a verdict.
Sure, thank you.
So they're not going to Allen charge him. He's not going to Allen charge him. That is interesting. That is an interesting thing, chat. No Allen charge. Yeah. That's pretty fucking based. It is. We're going, chat. We're going all night. They got the stendo going in the jury room. They got the stendo, chat. Even Clyde's right here. We got the stendo. So, yes, we're going all night. Oh my God. Yeah, yes, there's no reason to charge Allen, but they didn't come back to that issue, which I think probably should have been better for the record to clarify, but we'll see. They hit the goal, chat. Hold on, we gotta bring Clyde up for this one. Come here, Bubba Bear. Clyde. Come here, Bubby. Come here, Bubba Bear. Come here. Come here. Oh, hi. Hello. Oh, yes. Oh, hi, Bubber. My Bubber Bear. Oh. He's like putting hands on my face. He's like, shut up, fat man. Yeah, you guys want to watch Kino Casino while they're deliberating? Because I think we're pretty much there. A 19 cheese lasagna, I would eat that. Since we have time. Wait, what's this? I could do a blacksmithing stream. I'd have to hop in the car for an hour and a half. And it's hot outside, man. Like that forge going, it's gonna be like 1,000 degrees. So no, when it gets colder out, we'll do some blacksmithing. So I can sit there in my shorts. I can sit there in shorts and a t-shirt and do it. It's actually really nice. How many cases does Allen work for? The Allen charge works quite a bit. That's why they use it. Remember, most cases end in verdict, so yeah. Unable to come to unanimous verdict, yeah. Long crime, better change the quote. Yeah, we'll see. Mike, thing is down in Columbus. No, it's not. Columbus is like 3 hours away, man. Like 2.5, almost 3 hours, man. I can play at the sword. No, not tonight. Yeah, but guys, we are going to switch over. Chat, we're going to switch over to Keto Casino right now. I know you guys might not like them, but it will be entertaining for a while. So, and I hope the guys don't get too upset because they do good stuff.
But instead of Tyler Durden, it's just like this broke,
Just like a pedophile, like Adel Wolf,
or
like,
rapist.
I'm happy to announce that I did
Yeah, it's fight self.
help my best friend secure that attorney, and that attorney has been hired and will be moving.
Some states limit the use of the Allen charge. Yes, in Ohio,
Very,
you
very
can
By the way,
go up to 3
you're
times.
a
before you
lawyer.
get a
Boy, do
mistrial.
they have a fucking like
Like they have
a
to go out,
task
they get it read
in
again,
front of them, like,
and then they
you-
get read
there's
it again.
audio of
So-
you beating her.
This is like Dante must die level difficulty for a lawyer. My client is Ethan Ralph. Ah! Like you just imagine them screaming in the mirror. Their voice is echoing throughout all of New York.
Oh man, Your Honor, my client is guilty. Excuse me, sir. This is a divorce.
Please, can we just get this over with, man?
Come on, guilty. Whatever the fuck. Let's go.
And so I'm happy about it. I missed 2 shows
Yeah,
in a row.
maximum difficulty, minimum fun.
Someone said
Sorry,
this is
guys,
an
hold on,
Adam
Frank,
Sandler
please.
movie. It really is.
Well, you know, I hate to miss shows. So I thought I'd make it up to you with a 12-hour. We're going to try 12
Pause.
hours.
He didn't make it. It was
No.
only it was 9 hours.
Like one of our regular streams.
He scammed it, folks.
But
He scammed.
and he hit the goal.
Yes, chat. They're still, and like I said, they're still going down below. It's still going. So we'll see. We'll see here. Mike says I'm heading to work. So you're stuck with some of the midnight shift, yeah. Yeah, that's Ralph, guys. That's Ethan Ralph up there. If you've never, that's not true. Or can we meet the goal? That's Ethan Ralph. If you've never seen him before, chat, that's who they're mocking. So it's not Nick, chat. Oh my God, you guys, come on now.
Oh.
Rob Schneider is the gunt.
Well, Harry asked what happened to the 20. It went up his nose. Like,
Yeah, he wasn't paid 20,000. Stop.
So no, what happened was he sold the swamp property to the church he donated it to the church. So then he was able to write off on his taxes $20,000.
Oh,
And then his lawyer released back to him $20,000 from selling the swamp. So that's
we're
what
gonna. So he actually was right. Hang on, he was going to. Hang on, where is it?
I'm dead serious. We're coming to build a church on that land.
Well, he did, but he actually didn't. He sold it to have a
Yeah.
church built on the
the
land.
church is going to build on that land.
So that's awesome.
Yeah, he is. He's looking good.
Just to see if I can still do
I
it.
need to catch
A
up.
12
Yeah, that church was built. He did it. That was not a lie.
He did it.
Congrats, Ralph. He did it.
I hate to miss shows. So I thought
You're
I'd
passing
make
the
it up
gas
to
station.
you
Awesome.
with a 12-hour. We're gonna try a 12-hour just to see if I can still
He
do it.
even you got a preemptive coping because he knew he was scamming.
Listen, we'll try 12 hours. I'm gonna be popping Xanax. So
12-hour marathon stream
really?
starting at noon Eastern today on Rumble. I may even try Rumble Studio. I don't know.
Oh, don't. I've only heard bad things about Rumble
So,
Studio.
by the way, do you know now on this divorce stream, Ralph's down so bad he's doing ad reads for penis pills?
Oh, I heard about this.
He's doing the Rumble ad reads. Yeah, you can be bigger, faster, harder, and stronger with these boner pills. The Ralpha male takes them for the Memphis Micro, and now you can too.
Just
And he's
like-
just absolutely slurring his words during it. He's fucking it up, missing words on the ad read. It's a disaster.
So
But
also,
Ralph's real desperate. I gotta hit the divorce goal by doing the ad reads for the boner pill.
yeah. So like the Blue Chew Ralph code. No. So what happens is Rumble now has like you do the ad read, right? So it puts like a script up for you, and it pays you like $10. So imagine we need
Yes, he has the best
we
voice.
needed two subs real quick. Ash, read it real quick, right?
No,
Hey
it only
guys,
pays out like $10.
it's $10.
Shit,
But
it's so bad.
beyond that, Mersh did an entire video talking about how he did all these ad reads, and Rumble didn't pay. Rumble's like, no,
It
we shall not pay.
See,
can't be paid.
but
Shan't
a
pay.
divorce celebration stream here, live on the kill stream. First
Oh,
time
yeah, Ralph should do a whole show where it's just ad reads. 8 hours of like just ad reads.
ever. First time we've ever done one of these. All proceeds
Wait, what?
stream here, live on the kill stream. First time ever.
First time ever.
First time ever.
What do you
He's not
mean?
even a first time ever.
That's
It's
a
the
lie.
first time he ever raised a goal for divorce, I guess. I don't know. It's like a real selling point. It's like, I'm getting divorced. Okay, it seems like a you problem. What does
stream
it
the
have to
making.
do- well, how does that make the show better for me? That you are getting divorced, sir?
Divorce
Really add up.
Stream special.
First time
Oh man.
we've ever done one of these. All proceeds from this stream will go to my good friend's divorce lawyer.
Oh,
He even knows what
he's
a sad.
laughing.
He knows what a sad cope it all is. What a
What?
farce it all is.
Look at his reflection. His room is just garbage.
Yeah, well, wouldn't it
What
be
the-
for you two? Like,
Yeah,
why would
that's
you even bother?
That's true.
like,
That's true. That's true.
Pockets. So any help you can provide, we're on like an 84 show streak, I believe.
That room is dirty. Look at this garbage. It's like
clean your
heat.
room, Gunty.
Listen, he's missed the goal like 19 times.
Yeah.
By the way, his goal is nothing. It's like Hog's goal. Like, it's not even a goal. It's, do we make minimum wage today?
Do you know the only person's goal who's lower than Ralph's is review tech?
Oh, that's why he's selling the house. At least Review Tech has the house, though, he could sell. So,
I'll figure out the exact number, 84, 85.
All right, Chad, I'll be right
before,
back.
We go.
no
live.
one cares. No one's like 84.
Oh.
Whoa.
Yes, these guys are both Canadian.
And I'll update that, but I hope
No,
you'll
Dick Licata, you have not missed that.
before we go live. And I'll update that, but I hope you'll all join me at noon or throughout the day.
How was the special? Did you watch any of it?
I didn't watch it. I'm insane. Not watching any of that
for
shit.
the kill stream
I have eye dubs.
marathon
Yeah. No, Range Queen, not yet.
throughout the day for the kill stream marathon divorce celebration stream live on Rumble.
Oh, man.
Oh,
Wow. That was like the most unhyped promotion for any event.
you know, there was no energy. I was like, whoa, and we're going to have this guest on and we're going to show this story. Can you believe what's going on? It's like, I'm getting divorced. Or my friend is, who's me. And I'm my only friend, my best friend.
It's
And I'm
sad.
broke. And I can only afford a lawyer that's $300.
Yeah.
God, pathetic.
Oh,
well,
can we do Boogie
speak-
first?
you want to do Boogie before we get to
Because
Ricada?
Ricada has to be longer, isn't it?
It is going to be a long
This is a short
segment.
one. Boogie's very short. It's really short, isn't it?
It's 5 minutes. Oh, man. All right.
Okay, chat. All right, we're gonna felt him real quick, and then Ricada, I promise you guys. I want to get all these clippable things, right, guys? Boogie had his
Boogie put out a new video after his pause. What is wrong with this guy's hair? What's wrong with him?
Got it.
It's like somebody said that he looks like a cafeteria lunch lady. He just go in and said, yo, just fuck my shit up. Make me look like a cafeteria lunch lady. Yo, just style it so that I'm permanently Norwooded, y'all. Like, look at that, man. Look at that shit.
He's a clown, but not
Like-
green hair.
Like, can this fool not fucking like get Desi to do anything with this hair?
Right?
Make it a bit better. Like, look at this shit, man.
So he's
I
now
know the founding father Max. He's Ben Franklin Maxing this bitch. Listen, you don't want to go down the path of the Ben Franklin Max. I've been there, okay? Ben Franklin Max, there'd be no pussy, dog. Ben Franklin Max, and there'd be no money, dog. There'd be nothing.
I love how he has this liar tattoo, but the focus is the hair. Like, you know what I mean? His hair's so shit. So here's what happened.
He's
They-
Tipples the clown. He may as well get it dyed. If he gets it dyed like rainbow and he fucking puts on the clown, Tipples the clown. Da, 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 da. Review tech kept saying the word Tipples and just laughing. And it's like, Rich, like you can't just keep repeating the word Tipples like 300 times. Like it's funny, but you can't just go Tipples. That was the review text for Tipples. And then he hit the fart button. It's like, oh man, what are you, like 10 years old?
It's brutal.
I twiddled my Tipples.
So if you guys have probably seen Boogie's been forgiven by Keem and all those guys apparently for having this liar tattoo. But like Boogie's like, I forgive myself finally. I'm like,
Oh,
no one cares
shut
what you
the fuck
think.
up. You're
No.
a fat cunt. Die, Boogie. Die, Boogie, die. Okay, so you're watching.
Scott, you're allowed to have that opinion. I don't know what else we're gonna do right now while the jury's out. I'm kind of out of ideas. So, and this is about the best I can do right now. So, but I enjoy it. That's the other issue. Don't worry, it'll get good when they get to the Nick Rekieta stuff. Give him some time; it's worth it.
Should have had to get it in giant font on his forehead and then continue to be punished. But no, it's like, okay, guys, we have a really boring show. We're clickbaiting it as the end. But it's not the end. And Keemstar's like, no, I swear this will be my last. Yeah, I bet.
Yeah.
Like, how many times do you think you can lie to me? I'm not going to buy into your bullshit anymore, Daddy Keem.
Yeah, it's like Memento. Like, don't believe his lies. Like a picture of
No,
Keem.
seriously, don't believe his
Holy. Here we go.
Look at this.
Watch, it's only semi-permanent.
Look at it. Does this look infected to you? A lot
So,
of
like,
people are
he's
saying.
trying to,
Whoa,
so he's
Ash,
trying
Ash.
to flex that it's infected.
No. Here. Listen.
Look at how fucking
No,
his hair
Does this
is.
look infected to you? A lot of
Someone farted. You hear the fart? listen.
look at it. Does this look infected to you? A lot of people are
Yes, I read the
Somebody
scare
gave him-
emotions
was
already,
that
guys.
Desi holding the camera and farting?
Desi
Whoa.
farted. That
She's
was-
getting a quick start on her fart fetish OnlyFans, I guess.
She farted.
Oh,
dude. That was
wow.
a fart, dude.
Was it her or was it Beluga Boogie, you fucking ripped ass? Place your bets, Chad.
Look at it. Does this look infected to you?
Was it a queef?
That was a queef, bro. Holy shit.
A lot of people are
Did
saying
you,
it's
by the way, I learned yesterday that Boogie made a video bragging about how he used to fuck his own folds of fat.
What the fuck?
When he masturbated, he used his fat folds as like a pocket vagina.
Oh man.
How is this even possible, bro?
Oh.
Like this like fucking like fatness that I can't even comprehend, even as a very fat man. Like, this is like the Ralph quad tit and the gun. It's like, what's going on with you guys?
Buddy, holy, dude. Holy.
It's not real because it didn't look infected like 3 seconds after I got it. It's now been 24 hours.
Like, why are you flexing the
Sammy doesn't
infection?
like it.
Oh my god.
This
No.
fat is like spilling over.
And
Like,
now, oh my
bro,
This
for
guy's
God's sake, man, this hairline is so Norwood Reaper. Like, holy fuck, man. Either shave it off or figure it. Like, look at this, dude.
Man. That's
Holy
a tough
fuck.
looking guy.
You don't say.
Imagine Desi fucking being fucked by him. No?
pull my beard out over it. And
How
that's
does it
kinda
even
why I
happen?
Wait,
It doesn't even make sense.
Wait, hear this. Hear this.
A lot of people are asking me when I'm growing my beard out over it, and yeah, it's kind of why I put it here. But put your
Wait, so you admit? Oh, I'm actually putting it here so I can hide my.
Yeah,
You fucking fuck.
it's such bullshit.
What a boring ending to this arc.
Can you feel over the lettering? Do you feel beard hair there? Because I don't.
By the way, DSP felted them so bad they were crying
Oh, yeah,
yesterday.
they're
Oh
coping.
man.
Darkside Phil sent the whole Locale Live podcast to the Shadow Realm.
Yeah,
The
like
king
literal.
just sentenced them to eternal torment.
Yeah,
Season.
yeah. Big shout
There-
outs, my friend
There was
DSP.
weeping and gnashing of teeth on this podcast.
Yep. We're gonna have a DSP as the we're gonna
Everybody in chat,
We're gonna-
we love DSP.
DSP.
Bow down
DSP.
to the bow down to the king. And later on, I'm gonna
Willow,
show
what do
you
you
guys.
he doesn't know you.
I
Yeah, I was
found
DMing with
out-
him today, actually.
I found out Darkside Phil's lineage. He actually does come from royalty.
Yeah, he does.
And we're going to go through the Darkside Phil family tree and look at all of the incredible people in
Mhm.
King Philip's lineage. It's true. It actually turns out that Darkside Phil is descended from like the mayor of London 3 times, like barons and lords. Like he's an actual legitimate royal king.
Not even joking, by the way.
The
but
blood of the
no.
king runs through Philip's veins.
I was DMing with him today. We are planning in a few days. I want
We
to
are planning
pre-plan.
a crossover with
crossover,
phenomenal
so-
Phil. We're going to
Yeah.
be going over there. He's going to be coming over here.
Yep, we're like
Phenomenal Phil is going to be a staple of the Keno Casino. We wish he could be third chair. He's just too kingly for a role like that.
yeah. But he
we would bring him
will
on
allow
permanently.
us. He will allow us his time. And
will
he
be so
also
gracious.
he also wants to watch the June the King documentary with us. So we're planning
Yes.
that out too. So
We're trying to plan that out, but Phil is
on
he
RTU,
doesn't-
on RTU.
He's struggling with Discord, so
We'll
we're
figure it
trying-
out. Yeah, we'll figure it
Fine,
out.
You're gonna figure it out.
Yeah.
We're gonna figure it out. But phenomenal Phil, it's a go. He is a feminine phenomenon. The
Exactly.
phenomenal Phil.
Because it's smooth. Because I don't think my beard is coming back. By the way, I'm a 50-year-old man with a face tattoo now.
Yeah.
Yesterday was my birthday. I turned 50. This is how I spend my birthday, everybody.
All right, this one guy in chat, I forgot what his name was. I don't know. I scroll by it too. Dad Jeff. Oh, Phil's a piece of shit. How dare you?
Phil, how
How dare you
how
in
dare
my
you try
chat?
and sully and dirty the name
You
of phenomenal Phil.
You sick
King
bastard.
Philip Burnell, first of his name.
You make me sick.
Lord of the gamers and king of the locale. How dare you? How dare you besmirch the name of Philip Burnell in this chat?
That's actually a
I wanna
bannable
send-
offense.
I ought to
but we
send
won't.
your ass to ban world.
We won't, but we
he
should.
didn't pay his taxes. Based. But he scammed his fans.
Based.
But he jerked off on live stream.
Double
Based.
based.
Like, what are you talking about? Based,
Every
buddy.
time someone's like, someone on an at replies like, he didn't pay his taxes. I'm like, why
Good.
would I care?
Good.
Why would I give a fuck?
It's tax-free, bitch.
We've covered Ralph.
Like,
DSP
this
is
is the
gone.
thing is-
You know what I mean?
No, you know what I mean? It's like, it's arguable that Phil is more moral than we are, for fuck's sake. Like, some of the crazy shit but the humanity of it all. Phil scammed some people there. Like, what do you mean?
He plays
They
WWE
agreed to spend
champions.
him. It's his money. It's his own. It's his business what he spends his money on.
What a king.
And not only that, but how many of you out there have ever been the best in the world at something? Phil is the best in the world at WWE champions, if that's even his account. Phil says it's not. Why don't you believe Phil? What's wrong with you people? What's wrong? How many of you have ever been the best in the world at something?
Right?
Come on. We're laying down the fucking Dark Side Phil defense force, folks.
Woo!
We're shilling for phenomenal Phil. Long may he reign.
Hang on, let me wind it.
By the way, I'm a 50-year-old man with a face tattoo now.
What? Ash, look at his fucking nose hair.
Buddy, get the
Boogie.
fucking trimmer,
Get
bro.
the trimmer, bro.
Holy, how does he even breathe?
my
Oh,
God.
zoom in. Oh, I almost don't want you to. Enhance.
No, I can't. Ow. Ow. That's
What a mess.
That's disgusting, bro.
Man, I would pay anything to see Dark Side Phil box Boogie. Dark Side
I'd
Phil
kill.
just knocks Boogie clean out.
Right? Oh.
Yesterday was my birthday. I turned.
How does she not go, hey, do you want to fix this? Look at this, man. That's fucked, bro.
So
50,
Kino
this is how-
420 asked about the Maddox interview. We
Yes.
are doing the Maddox interview, but
Very
it's going to
soon.
be around the time his show's coming out. He wants to promote his show. So
I respect
when
that.
yeah, it makes sense.
Yeah.
Sorry,
makes
guys.
sense.
So
2.0
he'll be
called,
on
so
in a
I-
few weeks or whenever that.
2.0 called. Sorry. We're back now.
5 subs.
Woo! Let's fucking go. Let's go.
Go.
I was spending my birthday, everybody. And I deserve it. I get it. I get it. I still have a doctor's appointment in like 16 days.
Yes, we can see
I have to go
you.
see my doctor, and he's going to ask what this is about.
Your doctor
Is
is.
he-
Who
Who gives
cares?
a-
Who fucking cares?
You know,
And I
2.0
still
called
have
me
this
from
disease.
doing
Stayed
his.
over.
No, you know what this is?
Oh, and then he goes, he still has this disease.
Whoa!
You stop it, you fucking lying sack of shit. You have no idea if you have that disease. He's lying about it again. The chicanery of it all. He's saying he has the cancer again. He hasn't learned any fucking lesson whatsoever.
I'm gonna tell you something too, by the way. He's acting sad. You want to know why he's acting sad? Keem told him this. Okay.
Yeah.
Keem told him, you have to make a video and actually act like you're sad about the tattoo. Because he ended the stream, the tattoo stream, with him going, "This rules. I look
I know.
awesome."
He
He's
loved
like,
it.
"We love it. I'm now free." Keem's like, "Listen, you need to make a video that shows that you're upset about this."
So this is an idea that people have come up with where he plays Tipples the clown. So he dyes his hair rainbow, puts on the clown paint, right? Puts on the red nose, and he's Tipples the clown. And what he does is he defends like the worst take imaginable. So every one of his takes is like he'll support Chris from Mr. Beast and say there was nothing wrong. Like he'd support Kaffles with the scamming.
All right, hold on, chat. Ribbon caps, a new member. Thank you. And then, guys, when they get to the Nick, I won't stop. EDW Raptor with 5 memberships. Thank you for the support. And then EDW Raptor for $10 says, "Can we hit the gold, chat?" I don't know, guys. It's all about the jury. They're still going. They're still going, guys. 6 hours in. Even the dogs think it's crazy. So.
He actually did.
He did. Do we have that? Do we have that?
C, we do have that. Alex C says that would be stealing Tipster's gimmick. Yeah, that is the real Tipples the clown. Is Tipster.
Yeah.
Felter Skelter for a sub.
Woo! Let's
Miss Joy says,
go.
"Thank
Big
you for
support
blogging,
today.
Sean. Your chat is the best." Thank you. Thank you for being here.
How do I look? How you tell
For
me? the truth. How do I
$20.
look?
Thank you.
Like,
Horrible,
I think you
dude.
look
And then-
adorable still. I still find you
What?
very
That's
attractive.
because
Seller
you're-
says,
that's 'cause you're
"Horse
And
a
I
white.
think
goal
you're
for
brave, but I
5."
also, you know,
Oh,
it was
he's
the right
brave.
Brave.
I mean, listen, what a brave stance you took lying about cancer. I mean, lying about cancer and lying about being molested. Like, I guess it does take a lot of balls to do that, but I don't know if it would be considered brave. It would be considered like treacherous and cowardly by most people.
This
But
is so
from a certain
fake.
point of view, like the fake tears.
This is so fake.
In love
And I
with
think
me?
you're brave, but I also, you know, it was the right thing to do.
Yeah, I didn't want to do it. I obviously didn't want to do it. I still wish I hadn't done it.
Shut the fuck. This is where you go
He loves
full blown lie.
Except
Full blown lie.
the fact that I didn't want to do it is why I did it.
You know, by the
Because
way, he got paid like 20,
20 grand.
30,000, 20 grand probably
to do this, yeah.
to do this.
Yeah.
So
Yeah.
he's walking on sunshine with
Mm.
it.
He was paid to do this.
I got fucked up, right? I get it. And I'll tell you what I learned about all of this is I need to shut the fuck up.
Yeah, well,
Why aren't
yes.
you doing that now? Like, I don't want to look at you.
About my trauma and my history and all that shit. It's played the fuck out.
This
Nobody
is
wants
so
to hear
fake.
about it. Nobody.
It's
I
so
know.
bad.
Boogie, yeah, nobody wants to hear about it. Nobody
Wait.
cares. So just log off forever and die.
He's got a fucking script on the other side of the mirror.
Stop.
He's got, look,
No.
what's that in his glass? He's reading something.
No, not the script.
He's
Team says it's not scripted. Dark Side Phil confirmed vindicated. DSP, DSP, DSP.
He reversed the script, right? So it was flipped. So in the reflection, it would look like a normal script.
My trauma and my history and all that shit. It's played the fuck out. Nobody wants to hear about it. Nobody cares. I need to figure out how to be entertaining on YouTube again.
Again,
The
I think you need to
truth.
find out how to be entertaining.
The
Period.
truth.
No, it is the truth.
Yeah, you do.
Why
I
is
don't
it-
know what that even looks like. I can't even imagine. It's been so long since I tried.
So long since you were entertaining. Like, this is sad. Just put him down. This old Yeller shit.
Old
You're
yellow,
past
old yellow.
your prime, if there ever even was one. It's time for the day of the pillow for Tipples the Clown.
Yeah, it's done, dude.
Liar.
You
May as well
looking
say
at me?
lolcow. I
You
have
looking
branded
at
myself
me?
a lol.
You must be looking at me because I'm the only one here. It's like, this is fucking shit.
This is so gay, dude.
Cow for life. Dumbest thing I've ever done. Except, of course, exaggerating, talking about my disease without.
Exaggerating, but
Oh,
you don't have cancer.
man.
You have learned nothing. You have learned nothing.
Even if
Getting
you
full-
had the polycythemia vera, it's not really cancer.
No, buddy.
This is stolen cancer valor. You have, is in your own words, the Animal Crossing of cancer.
yeah.
Okay. Come back to us when you have the Dark Souls of cancer,
Like
and then we'll laugh at you.
exactly.
Diagnosis of cancer and then calling it cancer, even though it's probably.
What he said yesterday that if he gets a cancer diagnosis and it's positive, he's getting the tattoo laser removed, like ASAP.
Cancer, and I still
Right.
might have cancer.
No, you don't.
Now I have to go. How do you explain this to your doctor?
Yes, hold on here.
He watches my videos, by the way.
Yes. Yes. Well, the ninth caller on the KBBL hotline wins free tickets to the premiere of Twister this Thursday at the AMC movie theater. Caller number 9 now.
People on
It
the internet
is
last
what it
night at
is.
me. It
Why?
did not work. People are
So,
very
like,
mean.
this is like a retarded concept that he has in his mind. This is, by the way, this is such a felted look in his eye. This is the look of a man who actually believes Keemstar is the god king of the internet and that whatever Keem says is gospel, as though he were Jesus Christ, and that everybody online has to respect Keemstar's assessment and wishes? No, Boogie. What
Amber,
Keemstar
no, I have
said
not
in his
gotten to those
forgiveness
Hannah Reid
only
motions
applies
yet.
to Keemstar.
That's
The
part
rest
of this
us
week too.
still hate you. The rest of us wish for you to die.
Like
The
tomorrow
rest
night,
of
I
us
think it'd
wish
be a
for
good
you to
night for
go
that.
away, take
also
a long
catch up on
walk
Richard
off a
Allen.
short pier and drown in a shallow
And then maybe
pool,
Friday night,
okay?
Young Thug
Like,
would be the
that's
plan.
the reality of it.
So that would be your,
Sorry, I keep zooming into the nose.
that'll be the game plan. Tomorrow night, we actually might look at Hannah Reid and get caught up. And then tomorrow night also, maybe try to get caught up on Richard Allen. And then Friday night, probably Young Thug and get caught up there. There's a lot to catch up on.
There were some people who thought it was great.
Yeah. That you lied about.
Thank you for the super chat, though. I appreciate it.
You lied about being molested too. Like, woohoo.
Woo!
If you're one of those people, you need to drop a like on this video because you're gonna be like,
What?
Imagine begging for likes on the video. So, okay, guys, I've been forgiven. Hit like. No,
No.
that's not how it's gonna go.
We shall not hit like. on
Even
your video.
with Keem's golden broomstick, it's not going that way,
No.
bro.
No.
Like they were gonna bring on somebody. They were gonna bring on what's his name, the guy that Boogie kept seething about.
Oh, oh my God. Fuck.
Somebody in chat.
Oh my God,
say
someone in chat.
The guy that Boogie was obsessed with,
Jackson Clark. Jackson Clark. Yeah.
So they said, Wings was like, what if we bring Jackson Clark on to press Boogie? And Wings like, this is a really good idea. And even Boogie was for it. And then Keem's like, no, he'll just come on and make fun of Boogie and Pratt. We won't have him on.
What?
Yeah.
Yesterday?
And yeah, yesterday. I'm like, I thought the point of the show was holding Boogie accountable and humiliating Boogie.
It's bullshit. It's bullshit. The whole show is bullshit.
50% dislikes. I'm telling you, this is bad. This is bad. I have ruined my life.
Shut the. You're getting paid now.
The thing is, he's making way more money having faked cancer in his molestation than he would have without.
Yeah, exactly.
Which is like one of the greasiest, scummiest things in the world. And
No
it's like
Vince
you
McMahon
couldn't be pissed
updates,
off
guys.
About it, and
We'll take a look for
kinda
that.
Are, but there's nothing you can do because Keemstar has completely insulated this guy. No matter what backlash they receive, they're making money hand over fist off this.
Yep.
So, all you can really do is laugh at how fucked it all is.
Laugh and go, this sucks. Da, 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 yeah.
I've ruined my life and I've ruined my face, is what I've done here. But at the end of the day, it was the right thing to do. And $4,000. I donated $4,000 to St. Jude's.
No, you didn't.
Oh, he charged it back.
Show us the
We all
receipt.
know.
Yeah, no.
Where's
stop.
the receipt on that $3,000 donation? And the only reason you did the $3,000 donation,
He said
was
4,000
so that
here.
well, he did the $1,000 donation, right?
Uh-huh.
And then remember with Mudahar, he was like, but he did that. He donated the $3,000 so he could get his play button back and sell it for $10,000. So he was trying to make a quick $7,000 profit by selling it to the biggest donor they have on Locale Live. It wasn't a charitable deed. It wasn't because he really cared about cancer. And then he threatened to charge it back and probably did anyway.
What the
Which hurts, man. I mean, like you're out of paint drink money for a good long time, baby girl.
What a lie. What a lie. I want to see the bank statements. There's no way Desi's going without her fucking pink drinks. There's no way Boogie's going without his McDoubles. Okay, let's live in the real world. Like, this is retarded.
Go to something way more important than just a dumb drink.
Then Mudahar donated $3,000 to St. Jude's because I did.
I've had enough.
Yeah, that's enough.
I've had enough. Okay. I've hit my boogie limit. No, I don't care.
In under 4 minutes.
Yeah, oh my God.
We're going to Ricada. Ladies and gentlemen, Nick Ricada is a crackhead. Rockets is officially cracked.
Here we go, guys.
Holy. So this evidence list came out a while ago.
Shit.
Let's go down to the very
Okay. Yeah, we got. God damn it, chat. Fucking jurors knew when they were going to start talking about Nick. God damn it! Yeah, later we're gonna have to go say hi to Andrew. Yes, it is Legal Mindset's birthday. So make sure you guys stop by there and tell him happy birthday. Because he deserves that. He's a good guy. So let's see. All right. The problem is you pause Keno, it doesn't stay. When you pause Keno, when you pause on kick, it keeps going. Yeah, but I don't know if Long Crime knows what's up. They might not know. Yes, Trent throw. The jurors are nose guarding. The jurors are nose guarding. Yes, Mavka. Legal mindset. Legal mindset.
Legal mindset.
Legal dick.
Oh. So yeah, the nose guards are there. I kind of get the feeling if they have a verdict. Stop the clock, chat. They need to stop the clock. How many blows do you think she gave her uncle? I don't know. The guy with that brow ridge, you think she's fucking Australopithecus. Those eyebrows are like so fucking far apart. And the eyes, too. All right, Chad, here we go. Yeah, I kind of get the feel it's probably guilty. I'm betting, actually, Chad, I'm going to be honest right now. Hold on. We'll open up to Chizat. The Chut. The Shadow for Battle. Oh, shit. All right. Shit. Ready? Arizona's primary was tonight. I hope Kerry Lake and Abe Hamida won, but I don't know if they did. All right. Hold on here. Oh, shit. All right. All right, chat. Hold on. Yeah, it's a compromise verdict. We'll see. All right. Hold on here, chat. We need to start a poll. Then there's only 3 options because there's only 3. So there's our options, chat. Guilty, not guilty, or guilty of the lesser. Go ahead and vote. And then we're going to just go ahead and dump this in there. Potentially criminal with 5 memberships. Thank you so much for your support. Yeah, guys, I think it's guilty. I'm hoping it's not guilty, but I don't have a good feeling. I don't have a good feeling about it. And guys, after there's a verdict, we'll hang out for a minute. But I think from there, we'll probably pack it up. We're not going to go too long tonight if we have a verdict. Yeah, I have a feeling they're going to convict her, though, which is bullshit. But also, I want to know the Arizona primary results. Let me see here. Jeff, how are you doing, man? Good to see you. Legal Vice is here. I thought Meatloaf was dead. Yes. If you want a link, I know you're probably working, but if you want a link, you can join us. I'll send it to you. I don't know. Like I said, I know you're probably working and helping plot Korean shipping disasters. Figure out what bridge in America you guys are going to strike next. But it's okay. I appreciate the Spectre-like work you guys are doing. So, yeah. Does Ohio have any prosecutees? I mean, there are probably some. I just don't think I've run into any of them. You don't like the smiling the prosecutor's doing? Yeah, but they always are going to be smiling. I mean, they like remember at the end of the day, Sophie, this costs them nothing. I mean, if you're the prosecutor and you lose, okay, fuck it, I'm going home. They're going home tonight. Tomorrow morning, they probably have the day off. So, I mean, you know, and even then, even if they lose, like they're gonna go home, sit on their lanai next to their pool. They're in Gulf Coast, Florida, in the south of Florida. Like, what's there to hate? They're okay no matter what happens. Lots of hard threes in that courtroom. Jesus. Siobhan saying prosecutees, he means like good-looking women that are prosecutors. They're cuties that are prosecuting. Jeff says, I can't join today. Gotta work faking for chat. Understood. They're taking the rest of the week off, win or lose. Fucking prosecutors. Well, maybe they can get away with that. I don't know. Does a court reporter get the day off tomorrow? Probably. Well, for something like this, if it's a late night, I can see the judge saying, like, we'll do the recordings tomorrow. And then if they want something typed up, they'll do it. What is the stenographer doing? Don't call them a stenographer. They are a court reporter. They would get really offended if you called them. Some of them get very offended when you call them that. So, there comes Ashley. Yeah, I'd be like ready to fucking vomit too. I'd be all fucking warbled as well. So, why does everybody look inbred? They're in Florida. That's why. All right, chat, here we go.
All right, we're back on the record in the state of Florida versus Ashley Benefield, 2020 CF 3014. I've been informed there's a verdict. Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because
I don't
of
think
their
they were truly
demonstrated
deadlocked,
ability
is the
to be
issue.
fair and impartial. There are to be no out relied needs to be respected. You ready to bring in the jury?
Okay, sorry guys, I'm making sure we're caught up. Yes. We, the jury, find Nick Rekieta guilty. And then she's like, what? That's a shame. This is weird. Yeah. I don't think they were deadlocked. I think that was, remember, they're using words and they don't know the meaning of them. It's like Sarah Boone. You're using words you think you understand. Oh, come on. I don't want her to be fucking convicted, but I feel like it's going to happen. Sadly, guys. Someone realized they weren't going home, so they switched up. Yeah, could easily be.
All right, you all can have a seat. Members of the jury, I understand you have a verdict. And we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form. Thank you.
$238 people here, guys. Thank you for sticking around. I appreciate it.
Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in Fort Manatee County, Florida, the state of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm?
Yes.
Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida.
Very likely.
Cheryl foreperson.
Would either side like the jury polled? State?
No.
Defendants?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk.
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and
Mike, we'll get to
consideration
this.
in this case. I know that many of you have missed important work obligations and family obligations and other
Yes, it
engagements
does.
that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get
You only
that
still
to
have that shirt, bitch.
I also want to advise you of some very special privileges.
Your
that
dad was
all
an
jurors
asshole. It doesn't
enjoy.
change anything.
No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, You are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices, and please make sure that your notes stay with the deputy. They're going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you.
Kale, I don't think they were deadlocked like we think of deadlock.
All right.
I think they were jurors who just said shit.
State.
Judge, I would ask you to remand the defendant at this point. I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do it to PSI.
I think we prefer to have PSI.
I'll sign an order tonight for that. It's a late in the evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that the Younghans, rather, I know that the court is familiar with the standard. They
We'll get to this.
stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have
Those novel
good
issues are
and
not going to
sufficient
result in a new
grounds
trial,
to
though.
appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benefield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here. Her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghans decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable. And where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Miss Benefield to bond, continue her on the same bond, in fact. And if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the second district. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny.
Yeah, she's looking at a minimum of 10 years in prison, guys. Maximum of
Ms.
30.
Benefield, the jury, having found you guilty of manslaughter with a firearm,
So-
I'm going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing. All right, the court will stay in recess until we get a sentencing hearing set up.
Thank you, Your Honor.
I trust Your Honor will issue a written order on the bond.
The bond?
Yes.
Yes. If it's,
Yeah, she's in custody.
if it's required, I certainly will.
Thank you, Your Honor. Thank you, Madam Clerk. Thanks, thank you.
All right, guys. Yeah, I kind of got the shitty feeling that was going to happen. So a bunch of questions. We'll get to them all. Yeah, she's looking at, guys, and, you're wondering how much time it is. I mean, looking at a couple different websites of different attorneys down in Florida, manslaughter with a firearm, it's 30 years in prison. If it's a gun, she's a minimum sentence of 10 and 1/3 years, but also the maximum of 30. So she's looking at like 10 to 30 years in prison. And Florida is very tough on guns. That's part of the issue here. Florida has so much. Florida's way of dealing with crime and all the criminals. This is what happens. So, yeah, this is so sad. Alexa, play Despacito. So, yeah. So, let's see. We got some things to talk about here. Dolly's saying she's got good appellate options. I mean, I don't think any of those overturn or get her a new trial, man. Remember, appeals are for losers. What happens if someone says no during the jury polling? Well, then we'd have to stop and say it's not a legitimate verdict. I've never seen it happen. The gun ups the minimums. Yes, in Florida, gun is a massive enhancement. Florida does not fuck around if you commit a crime with a gun in Florida, you're fucked. In Ohio, you get 3 years added on. In Florida, it can give you like 10. Cale Burke is saying they were deadlocked for 30 minutes. They came back with a verdict. Well, they were gone for a while. And here's the thing. I don't think they were deadlocked like we think of the word deadlocked. Remember, these are jurors, so they're not thinking in the terms we're used to. It's like Sarah Boone. She can ask for things, but if you don't use the right terms, it doesn't make any sense. I think they just weren't like they were at an impasse. Or like they hadn't reached a verdict yet. So, Ken saying, I'll never cave on a verdict ever. No one deserves to suffer at the hands of the state. I agree. And Brandon, let's go, Brandon. How you doing, man? Saying, how's it manslaughter? She said she tried to kill him, didn't she? Yeah. This is a compromise verdict. A bunch of dumbasses. So, 10K View says PSI, pre-sentence investigation report. So basically, right now, the judge to properly sentence her needs to know everything. Like you'd want if you were her, you'd want to tell the judge everything about her, and that judge would want to be able to confirm it all. So he's not going to wait till sentencing. The probation department will meet with her, and they'll fill out forms because right now the judge just has an indictment and a guilty verdict. That's all he's got to judge her on. And that's not enough. So the probation department interviews her. They sit down with her and talk to her, and they give her the life of Ashley up to the conviction. And that gives her attorney time to bring in witnesses and people. So we'll see what happens. But yeah, that way it's called a pre-sentence investigation report. And they do all kinds of things: your family life, education, growing up, physical health, mental health, like all the stuff you'd ever want to tell a judge. Employment history, everything. Brad says no need to worry about moving now. Well, that's true. At least for the next 15 years, probably. And then Trent Thorough is saying the moral of the story is don't find yourself in a situation where your life can be decided by retards. That's easier said than done because remember, you only have so much control over it. Anna Wall says no waterworks now. I guarantee you she's fucking on Valium or something right now. And even then, I've had clients at that point, they're just kind of like, they're just mentally out of it. You're mentally exhausted. You're at your wit's end. You're kind of like, whatever happens, happens. You're okay with it. You're accepting of the reality there. So is she remanded? Yep. She's gone. She in custody. Young says, I wonder what she wrote down. Probably a letter to her daughter or a note to her daughter or her family. I very much agree. That's a shame in saying that happened recently. There was video of it. Girl said she was pressured and not guilty because the guy was black. Well, if that happens, then yeah, that creates a mistrial issue at that point. Would the fourth person get in trouble if someone says no? It all depends. Is the fourth person saying like you better say guilty or I'll fucking kill you or something like that? I mean, maybe. But if the person's up there just like I was just really nervous and everybody was like staring at me and I was just scared, then no. It all depends. It all depends. So remember, that person had to come up there and sign their name on the paper. Anna Wall thinks I think maybe one person did one murder. Yeah, maybe we'll see. Manslaughter doesn't make much sense, but the jury made a conviction. Michael says, do you think a better attorney could have done better, or is it just a shit case? It's a tough case, man. This is a tough case. It's tough because Ashley is just as fucking crazy as he was. If Ashley hadn't been crazy like that, like get him arrested at the hospital, and all that shit, she probably would have walked. It just doesn't help. It doesn't help in that regard. I guarantee you she's not on diazepam. She could be on any number of things. Remember, she's allowed to if she's got a lawful prescription for it. I mean, Abel, yes, that's all. Your dad ended up with a shitty t-shirt. I mean, yeah, Ashley's convicted and all you have are fucking t-shirts. So I guess you fucking got, hubris follows people like a motherfucker. I mean, it definitely was a compromise verdict, and that's the sad part. Can you explain what you think is going on at this late hour? I'm sure that everybody wants to go home. It's 11 o'clock. Nikolai Muse sentencing is tomorrow. Oh, we'll cover that. And David says, I would not convict, but I see how the jury got there. Yeah, me too. I understand it. But I still think it's bullshit. Then Adam Watford for $10 says, I feel like if the state can't prove their case to the charge at the beginning, they shouldn't be able to add charges at the end. I agree. If they thought they needed that, they should have charged it. I totally think so as well. I think the defense is the one side that should be allowed to add charges if they want to do lessers. The leader of Hamas just got yeeted by the Israelis. Yep, he got drone striked. 8:30 Central. He could get the 97 years. Ooh, so that'll be 9:30 my time. Oh yeah, I'm sure. Oh, you're so mean. You're so heckin' mean, Mr. Mew. All those fucking people deserved it, so they could fuck themselves. David said she'll only get a few years. She's looking at a minimum of 10. So. She shot a man under suspicious circumstances. Yeah. Yep. Yes, she did. It was sketchy. That's the problem. It's rough. And then Ariel saying, Ariel, I also hope the bar is going well for you today, and good luck tomorrow as well. 9.5 year mandatory minimum. I was reading 10, but yeah, either way, but she's only 30 something, so she'll be out by the time she's like 40. So, yeah. Oh. Yeah, Aaron says you got this. Yep. Mike says maybe she can find a better man at the women's prison. Oh, maybe she'll be married. She'll be married within 2 weeks of being out of prison. Yes, she will be. I can see the judge getting 15 to 20. I'd see like 10 years. I think there's a lot of issues there. Okay, tomorrow. You're excited for tomorrow because today was the MPT, the model professional test. Yeah, the MPT's garbage. So good luck on the MBE. Good luck. You're gonna be fine. You're gonna be fine. It's 11 o'clock. Go to bed. Go to bed. You should be in bed now. Sleep. Gypsy Rose got 10 years for planning her mother's murder. Yeah. Oh, the essays are tomorrow. Well, get some sleep. She'll get married in prison. Well, like to somebody on the outside, or like one of the women in prison is going to marry her, because that'll be interesting. When is the Sarah Boone trial? October 7th is when it starts. Beginning of October. So we got a ways to go. But God, imagine if Sarah Boone got locked in a cell with like Ashley Benefield. Oh my God, she could she's a ballerina, so she's probably very flexible. Sarah will shove her in a lockbox and she'll be like, what happened to her? I don't know. Oh, okay. Oh, you did creative writing on the essays today because you turned retarded and you forgot everything? You're going to be fine. You're going to be fine. Don't fret. Don't fret. But you can always do the joke. What did the Mexican gangbanger say when he took his test? He's like, what you think this is, essay? Somebody said they saw my what? Saw my retweet of something. Oh, England, yeah. The people are getting mad. Yeah. You're gonna be fine. Just go get some sleep. Jesus, go to bed. You need to. And then Adam, I covered this. Yes, I agree. I agree wholeheartedly. Oh. Robert says she'll make a batchstick ballerina music box with her. Oh, 7 crazy suitcases. Jessica Lynn says no verdict. She just got convicted of manslaughter. Not guilty on murder, but guilty on manslaughter. So they convicted her of the lesser included offense. This will be a Netflix movie in 10 years. It's going to be a fucking Lifetime movie in like 2. Give it time. Give it time. Scorpion says, I couldn't decide on that one. Bothers me she seemed to abuse claims when it advantaged her in court. Went back and forth. Seemed all around like a toxic relationship. It was. Both of them were scumbags. Ashley seems like a horrible fucking human being. Doug seemed like a horrible fucking human being. So, and that's part of the problem. A jury wants to have somebody to hate, and you don't want them hating your client. But if your client makes it easy to be hated on, well, then they're going to hate him. So Ashley has a problem. She's had that problem, but I thought they were overcoming it. So Ava will star as herself for the money. Yeah. Yes. Doug did seem like a worse human being, but he's also dead, so now the victim. Yeah. Oh. No one's going to fight for someone that they hate. That's true as well. That's part of the issue. She's not hot enough to be that psycho and get away with it. She's a Cleveland 6 at best. I bet when she was in her 20s, I bet she was fine. Meme Copium said he'll be streaming all week long. And then Ron is saying verdict. Yes. Verdict is she's guilty of manslaughter, not guilty of murder. So she got convicted. So, oh. Pure Jealousy said she's been abused and put through hell, but I'm sure some of the hell's her own making, and she put Doug through hell of his own. Yes, Meme has been going ham on Nick, man. He's been A-logging like a fucking boss. If Meme was A-logging any harder, you think he lived in Oregon, was just like, Meme's been A-logging with a fucking 36-inch bar in his chainsaw. So, any new trials in the pipeline? Not right away, but there's some coming up in August. But I got to take a break. I got to get some work done, and there's some other things I have to get focused on in the next couple of weeks. So, Pierre is saying, I'm just saying why she looks rougher. Yeah, but she's also had so long now of dealing with a murder case hanging over your head. That's going to add a lot of time and a lot of years to you. Like, regardless of who you are, that's going to make things. Ooh, actually, turn that on. Oops. It's the weapon light. I use it sometimes at night so I can see out in the yard very well. Normally it's on the Glock. So, Reggie the dog got the worst of it. Yeah. So what's going on with the OnlyFans murder? So the tampering charges got dismissed for Courtney and her parents. There are some police and some prosecutors in deep shit. So that case has kind of been on hold. Shredder says, who does the judge give her gun to now? I don't know. I don't know how that works now. Oh. So. All right, guys. So Legal Mindset is going live. I'm going to send you all his way because I know he's out there and it's his birthday. If you guys could just say happy birthday to him. You don't have to do anything else. I'm sure he would just appreciate people coming in and say happy birthday. Or if you ran in there and just went, Legal Mindset, and just did that. Either way, I think he would be thrilled with you guys poking in and saying hello. And then, yes, tomorrow morning, 9:30, we will do Nikolai Mew, the Apple River Stabber Man. If you guys remember, he split those people stem to stern with a gas station pocket knife. And he's looking at nearly 100 years in prison, which I'm not going to lie. Too bad he didn't kill any of those people because they all deserved it. Oh, mine said push it back to 11:15. He pulled a me. Pushed it back a little bit. Oh. So that is where we are. And it's sadly, we won't have the Ashley Benefield thing. We won't have the Ashley Benefield thing anymore because we'll be done. And I like this AI generated image. And hold on, chat real quick. What was that? They're playing Nick Alive, but I can't redirect them over there, so I'm going to send them a mindset. So that is kind of it for us, guys. Let me see here. I have Betty Davis here. Yeah, I know it gets all weird. There, see, it's down. Go back to the stream we were watching before the verdict came in. Oh, Deanna, that is over on kick.com. And here, I'll put this in for you if you want to watch it. These guys are... make sure I have the right address. Yeah, if you go to kick.com/Keno Casino Gaming, that'll take you to those guys, PPP and Worski. And they'll be up there running their thing. They'll be running their train on Nick and Aaron. That's where you'll be there. Matt says, I've been 5 of 6 on cases I watched. I should get a paycheck for it. Yes, cross-platform redirect would be dope. It would be. Is 2.0 here? She's home, but she's not here. Well, they shitting on Nick. I understand, but I mean, they A-log everybody. So, Aaron did water sports on Caleb. Yeah. I'm the auxiliary law bishop of Ohio. I'd rather be a cardinal. How about that? And John Coleman saying, I'm fantasizing about Sarah and Ashley being bunkmates. Oh, no. Oh, no, chat. Oh, 2.0 is here. Hello, 2.0. All right, guys. The final boss makes an appearance. All right, chat. Well, thank you to everybody here. Thank you guys, everybody, for all your... thank you for everybody here who's commenting, participated, liked, disliked it. We had quite a few people earlier. And then, yeah, everybody on Twitch and YouTube who super chatted, did a membership. I appreciate all of that very, very much. This was a fun day today, guys. I think we had a lot of fun today. 6 hours in, it's been a lot of fun. Yeah, I am surprised it went this late. I thought it'd be done at like 6, but hey, at least we got all done in a day. Nice, clean, and neat. No verdict watch stream for tomorrow. We'll do Nikolai Mew, and then yeah, we'll probably try to catch up on Richard Allen in the afternoon. Yo, Hunt says, we're going all night, chat! No, not right this second. And this is who we are. Says, I rebuke that verdict. Wait, you can't do that! Oh. Yes, noise. Try 6 months, yes. Oh. All right, guys. So thank you again, everybody. I'm a poor phone hanger-upper, yes. Well, I'm trying to be a good host. So, guys, remember until next time, just because you did it doesn't mean you're guilty. Except for Ashley, because apparently, well, jury says you are, so toodles.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk report to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy